Mentioning, please wait for next week. Let us just dispose of some matter. Unless it's our order correction.
I'm mentioning for praying for leave to file without certified.
Why?
copies. I applied for certified copies.
Very leave.
Lord, urgency, my lord, guarantee application in connection with the.
Come back next week.
First
Mr. Giri. Come back next week. Next week. Yes.
Leave was granted, my lord, in case of failure of mediation to be mentioned.
Pardon?
Liberty was mentioned. Liberty was given to me to mention the matter if mediation fails. Mediation has failed.
Mention next week. We will include in the list.
Next week mention. Next week.
You want contempt application?
No. Next week.
She may be permitted to mention a matter for correction.
Correction, yes. Only correction we are taking.
And may I permit to mention for my lord, may I permit to mention for hearing matter for
Next. Hearing we are not taking up in any.
My lord, I'm suffering.
Execution date is fixed on 11. But I tried to move the vacation bench.
It's an application.
It's an order 41.
Execution this 11th.
This 11.
Handle. Yes. Column.
My lord, I'm suffering. My lord, I'm
No, wait
getting
for
water from the reservoir. My lord,
Right. Yes. One call for it. Accordingly, FMA 664 of 2021 is allowed on contest against the respondent numbers 1 and 2 and ex parte against the other respondents, thereby setting aside the impugned order bearing order number such and such. Defendant respondents number 1 and 2 are hereby restrained by an order of injunction from collecting monthly rent from any of the tenants in the suit premises till disposal of the suit bearing such and such. It is made clear that the above findings are tentative in nature, arrived at only for the purpose of deciding the appeal against the refusal of temporary injunction, and shall not be binding on the learned trial judge at any further stage of the suit, including the final hearing of the suit. Consequentially, can is also disposed of, no orders to cost. আবার পরে ঠিক করতে হবে।
Lordship, I appear for the.
In such view of the matter, FMA number 828 of 2025 is allowed on contest, thereby setting aside the impugned order bearing such and such. Made clear, above findings are tentative in nature and shall not bind the learned trial judge in any manner while deciding the main temporary injunction application and at the final hearing of the suit. Consequentially, can is also disposed of, no orders to cost administrative.
Lordship, I appear for the respondents. I'm praying for a stay on
No,
the
I'm
judgment.
appearing.
Lordship for 3 weeks.
What was the nature of the order which you state? Which we
Injunction
It
order.
was an ex parte injunction staying my auction process, my lord, has been.
and after the above judgment is passed and a prayer for stay of operation of the impugned order is made on behalf of the respondent, Fussap, learned counsel appearing for the petitioner, appellant opposes the same. Fussap, however, keeping in view that certain arguable points are involved, let the operation of the above judgment be stayed for a period of a fortnight from date.
Obliged, Lordship.
সই করছি না একসময় ফটো লেটার পাঠ নিয়ে ফর ফটো ইয়েস here
Item number 3, my lord.
counter
Item number 3, my lord. Can you take it next week, my lord?
no
No,
first then we are not
because
granting.
of the fact, my lord.
Then it goes out of the dismissal.
Because of the fact, my lord, I'm saying, you, as per your lordship direction, I served the copy. The tag report has not been here. That is the reason.
Okay, what is the
Otherwise,
what is the application for?
application, not application for restoration.
Restoration application.
My lord.
Learned counsel for the restoration application, then let it appear.
Restoration application, man. Twice I have to served. As per last, your lordship directed me to serve afresh. Accordingly, I have served just before vacation. Well, the tag report is not. No, can you take it next Monday? I'm ready for the appeal.
In the application, it will be listed under the heading application. Learned counsel for the appellant seeks an adjournment on the ground that the track report regarding service is not yet available. Fussap, accordingly, let the matter stand adjourned and be listed on June 16, 2025 under the heading application. Application দিয়ে দেবেন surely.
Lord, this is my order 41 application,
Yes.
but unfortunately, my lord, one person has died. And thereafter, my lord, respondent number 8 to be added party. Possibly, my lord, your lordship will feel that the party to be added first. Or otherwise-
Substitution application has to be made.
Yes, my lord, I have. Can number 4.
That is appearing today.
Yes, yes.
Acha.
So, my lord,
This is within time, can 4?
according to me, yes, my lord, today I have got that brief of Can 4, but I feel it within time, my lord.
Why do you say you feel it?
Because
You're
of the circumstances, my lord, it has been made on 28 June 2023. Am I right?
Yes.
23, my lord. So,
And when did he die?
and date is, my lord,
Response number 8 বলছি।
8 to date হয়েছে। Number 1 date হয়নি? My lord, there is no date. I am very sorry, my lord. One person is to be added. Number 8 is to be added, my lord, only. Then in that case, my lord, I will move my order 41, my lord.
No, no, not that. Number 8 is to be added means
Added
8
means
is already there. Shantirani Masat is there. She has died.
she has not done. After that, my lord, serial number 9, 10, 11, etc. are to be added. Am I right? কি করে এই তো already is party. Just sir বলছি।
In the memo, they are not there.
There is a typographical mistake, my lord, I believe.
But they are there in the memorandum also.
In the memorandum also. My lord, let me start, my lord. Order 41.
No, 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 no. We have to clarify this first. We have to decide this application first. Because you have made a formal application, inclusion of the name of Shantirani Masat.
Shantirani Masad is already.
What is the circumstance? Please come prepared. We'll take it up tomorrow. Come prepared on the application.
Very well, Lord. I will come prepared.
Uh,
Today I have got some reply. I'm very sorry.
Since learned counsel for the appellant has been recently briefed, comma, on the prayer of the adjournment, on the prayer of the appellant, the matter stand adjourned for the day.
I'm extremely grateful. Lord.
Thank you.
Well, matter will
Come.
retain in its
Yes,
position.
yes, yes. Come back tomorrow.
Extremely grateful.
Please give the names. Ask your learned junior. No, no, no. Ask your learned junior to write. Yes.
Item 5, my lord. I am for the appellant, my lord. On last occasion, my lord, your lordship was pleased to direct me to obtain the certified copy. I have applied for money with devious reason, my lord. I have not obtained it yet, my lord. Kindly, I have applied for it. I don't know how much time will it take.
Very well. Learned counsel for the
Kindly
appellant.
direct them, my lord, at least, my lord.
Learned counsel for the appellant submits that despite having applied for certified copies of the judgment and degree of the trial court, comma, such copies have not yet been obtained. Full stop. Accordingly, let the matter go out of the list for the present, with liberty to the appellants to mention the matter for inclusion in the list as and when such certified copies are obtained. Full stop. The appellants shall file such certified copies as and when obtained, comma, with the department, and the department shall shall give a further report in that regard. Whenever you get it, file it in the department, have that report, and then mention. এখন out of list হয়ে যাবে।
My lord, I'm for the appellant. My lord, I'm praying for a short passover, my lord. Very short passover,
No,
my lord.
what is the defect?
My lord, this is that matter, my lord, where the condonation of delay was not filed.
Have you
The
filed
appeal
now?
was this. Yes, your lordship. This is a legal aid matter, my lord. Your lordship,
If I may intervene, I'm for the respondent. Your lordship, the issue which was raised was that the Section 5 application was not filed by the actual appellant.
he
It
has
was
passed away.
5 years delayed later on, belated. The actual appellant, and after the substitution of the actual appellant by the wife, they have right now filed the Section 5 application after the process.
They have approached the legal aid.
Appeal was filed in the after 117 days
Yes,
by the original appellant.
yes, your lord.
Your lordship.
Yes, Mr. Gupta, it's a legal aid matter. That itself is sufficient ground.
Well, we have also filed a supplementary affidavit explaining
yes.
the delay as well, your lordship. Like Mr. Rishad Medora is appearing.
Whoever is appearing, but what is the application is can 5 years. Yes, Mr. Gupta.
Yes, Lord, I'm opposing.
Yes, we understand that at the point of time when the appeal was filed, there was no Section 5 application filed
Yes, Your Lord.
simultaneously. Can be filed subsequently. There are judgment.
First, the date of the decree.
You wanted a short passover?
Yes,
That
your
short
lordship.
passover will be over by the time Mr. Gupta finishes. No, no, move it. I mean, opposite. You are in favor of granting the Section 5.
Yes, so I
So therefore, you are.
would try. Now, there's a list of dates, my lord, which were possibly
You'll
handed
take
over.
down. You have handed over.
Possibly, my lord. Subject to correction.
Subject.
No, I'm sorry, my lord. It's with me.
No, it's with you probably. Yes.
I'm really sorry.
Give a copy to her also.
Copy আছে? তাই দেবে কপি দেবো কেন থাকে আমি একটু দেখতে দেখতে বলছি
Yes, sir.
Now the first date is when the
Judgment passed, yes.
first date is when the trial court, my lord, dismissed the suit. The second date is the date of filing, is the date of the decree passed by the lower appellate. Now kindly see, the appeal was filed after there is a delay. Not 11th of
September.
2019. Now kindly see the next date.
So that was roughly say 3, 4, 5, roughly 4 months after.
Roughly 4 months after.
Because 90 days expired in May.
So,
So,
117 days is what the stamp reporter says. So your lordship will
We'll exclude the time for
7 months.
no, not 7 months, cannot be 7.
Yes, which is there. So kindly exclude that.
Yes, 4.
Now kindly see
4 months delay, Mr. Gupta, so much hula hula about that.
And not only on that. Well, had it been only simplicity of 4 months, no problem. I would not have
Yes.
spoken.
Yes.
Kindly see the next date.
Yes.
In July 2023. So the appellant was alive till that time. Section 5 not filed. Now appeal, well, it's mandatory that a application is filed because on the last occasion, well, when we were opposing, your lordship, it fell from your lordship that an application is not required. Because I had placed a single bench judgment in connection with an order 41 for a second appeal. I'm not order 41, the second.
Hand it over, Mr.
Yes, my lord, just Honorable Justice, my lord.
We can't find it on record. This.
এদিকে দাও, back side এদিকে দাও।
Yes, Ashish Kumar Chikal. Justice Ashish Kumar Chikal.
একটাই আছে?
Yes.
এখানে থাকবে তাহলে আমার।
But I had handed over a judgment of Honorable Justice.
Justice Chakraborty, as his lordship then was. We'll just find out.
Where your lordship, there was a reference to another judgment, which your lordship wanted us to sign.
আপনার copy তো দাও।
But if your lordship kindly takes a look at this judgment first.
Yes. Do you have an extra copy, Mr. Gupta? Otherwise, already will follow from this.
আচ্ছা, no, Justice.
Where is the proposition laid down?
Ashish Chakraborty. But yes.
Thank you very much. Thank you. There is no pagination in it.
There is no page.
There will no difficulty. We'll take the second last page.
Yes, but
137. I have considered the facts
the
of the
only
case.
thing, first paragraph your lordship would see, this was an application for condonation of delay in preferring the second time. So facts are not in an identical situation. Now
Right.
kindly sees
Second last page.
second last.
I have considered. Yes.
I have considered that paragraph. But there, my lord, the Honorable Court was considering applicability of Article 137 also. আগে তুমি ছিল কপি রাখতে তুমি বলে ফেলে রেখেছি
In the teeth of the Supreme Court judgment, this judgment is with utmost respect, par inferium, because of the judgment itself. It quotes two judgments of the Supreme Court. One of the judgments says shall is may,
No.
and the other says may be filed even subsequent to the appeal.
My lord,
And in fact, the learned judge himself says that do not necessarily to be in writing.
absolutely, absolutely. But no, it has to be in writing.
No, let us come to the
Yes,
last
yes,
four
this is
lines
where-
of Justice Chakraborty's order.
This is where
When
yes,
there is delay in filing an appeal, the law requires an application for condonation of delay, although not necessarily to be in writing.
this is where I join issues, and I'm backed by a Supreme Court justice.
Achha, very good.
There's a distinction,
Yes.
in my humble understanding, between a normal Section 5 application or a Section 5 case and an application for condonation of delay in connection with an Order 41. Because of a specific provision, which your lordship would kindly consider, on Order 41, Rule 3A.
Yes.
But this, in my humble submission, is a departure from the regular Section 5. The lordship will test it, Mother, kindly. Kindly comes to Order 41, Rule 3A.
Right.
Lordship,
CPC একটা দিয়ে দিন। CPC এখান থেকে দিন। Code of CPC.
your lordship would kindly see the heading of the provision first.
Yes.
Application for condonation of delay.
Right.
When an appeal is presented after the expiry of the period of limitation specified therefore, it shall be accompanied by an application supported by an affidavit, setting forth the facts on which the appellant relies to satisfy the court that he has sufficient cause for not preferring them. Now kindly sees what is the distinction with Section 5 language. Because the other judgments were considering a Section 5 case.
What about this Pradeep Kumar, which was quoted by Justice
Yes,
Chakraborty?
I'm carrying. I'll place. Kindly sees the language of Section 5 first, minute. But here, as it fell from your lordship also on the last occasion, that it does not contemplate an application or an affidavit. It only says sufficient grounds. It can be oral. And though that is the line of judgment of 1992 Calcutta, which I am also carrying, which was one of the judgments which Honorable Justice Chakraborty, as his lordship then was, had considered. But Section 5 language is not does not make it mandatory for an application to be filed.
Yes.
Now the 92 judgment was in respect of a mandamus appeal, where no Order 41 Rule 3A would directly be applicable. But in case of an Order 41 case, 3A squarely comes in, and therein I would be trying to substantiate my point by relying upon a Supreme Court judgment.
Yes.
This is reported at 2000 Volume 7 Supreme Court Cases 372. This is on Order 41 Rule 3A, but I am not once for once arguing that belated application cannot be filed. It has to be filed with the appeal. That is not my argument. Because that has been that shall at the time of filing has been diluted to mean it's directed. But
So then they have to file another application for condonation of delay in filing the Section 5.
which cannot be done because of Article 137.
Why do you
Because
say that?
137 prescribes for limitation period
For
for
that,
filing an application.
yes. Therefore, if there's a limitation period for filing an
Filing the
application,
Section 5.
Section 5, then why can't there be an application under Section 5 for condonation of the delay in filing that it's not a Section 5, Order 41 Rule 3A? Why can't there be an application for condonation of the Order 41 Rule 3A? Because other provisions under article those articles, Mr. Gupta, all are amenable to Section 5.
Absolutely.
Every article of the Limitation Act provides for some limitation
Yes,
regarding something.
absolutely.
So in all the cases except suits, in
But
applications,
appeal and
appeal application, we can always take up a Section
Yes.
5 application or even
Yes.
consider condonation of delay.
But
Why can't we do that in case of this one,
here I
this
yes,
condonation
here I
delay?
would want to submit that
Yes.
A for appeal, it's 116A comes in, which makes it mandatory for 90 days. Now, in support of that application, the belated appeal, an application was mandatorily to be filed. Not with
Yes.
the appeal, maybe later, but mandatorily an appeal.
Within 3
application
years.
was-
Let us take your best case within
I
3
am
years.
saying it has to be filed within 3 years. Now,
Right?
the
They have
original
not filed it. They have filed it after that.
They have filed after.
They have put in a supplementary affidavit explaining the delay in condoning that.
Yes.
Now this is a Section 5 application.
The Section 5 application.
Mr. Gupta, this application need not be in writing. The application under Section 5. There are two stages in this scenario. Second appeal filed belatedly. They file an application which is captioned as Section 5, but it's basically under Order 41 Rule 3A. And there are several judgments which say that if there is a specific provision, that should be invoked. So let us consider this section 5 which they have filed to be an application under Order of Partition Rule 3 capital A. If that be so, that has been filed now beyond time.
Yes.
Because that also 137 by the same logic can be applicable to this also. Then.
Yes, but this is beyond 3 years also.
Beyond 3 years, only because it is beyond 3 years, we are at the second stage, Mr. Gupta. First stage was
Section 5 for the Section 5.
yes. Section 5, not for the Section 5. Section 5 for the Order of Partition Rule 3. Yes.
He was alive in 2023.
He was alive. He's
When
dead
that-
now.
When that period of 3 years was
Lapsed.
there, he was
He's being alive or not being alive
advised that
is
do not
immaterial.
file any application.
But we get
because-
that. He
because
was
your
not.
appeal would be coming
He
and
was
you-
advised there was a wrong advice.
because you have to put in the occupation charges to get a stay. So keep it pending. So
Occupation
you will
charges, if we
kindly-
impose, Mr. Gupta, occupation charges will consider, whenever we consider occupation charges, if at all their
But
appeal is
logically,
admitted and we grant stay, we have to consider always from the date of the decree. We grant it or not, that's a different proposition
different
altogether. But we have to consider whenever they do it, it retrospectively goes back to the date of the eviction decree.
Eviction, yes.
So there is no difficulty in that. Whenever they are just delaying it, not avoiding. They cannot avoid.
But
Whenever you impose that, that goes back to the
they are
date of the
delaying it only for the purpose that if they had moved the Section 5 or
that
Order
we are
41 Rule
that
3,
is in the realm of conjecture. So why are they delaying it? They've given some reasons. They're saying it's a legal aid matter. They could not gather the money. They have come through legal aid. The person died. His heirs are now taken.
that is now, not the original appellant. No, not the original appellant. But I am only on that.
No,
I mean,
we are considering their situation.
yes, I'm
These
only
people
in
say
their situation.
they have stepped into the shoes after the substitution is
Yes,
allowed.
but more than 3 years had elapsed when the original appellant was alive. So even then they did not file the Section 5. So that is what I was saying, or Order 41 Rule 3. So that is where, my lord, I submit with the help of this judgment.
Yes, let us see this judge.
Your lordship will kindly see page 376, paragraph 10.
We have a knack of coming to the wrong paragraph, and we have come to paragraph 19.
Yes, I will be relying on 19.
Yes,
I will be relying on 19.
yes, 10.
The object of enacting Rule 3A in Order 41 of the Code.
So you have come to 19.
I'm on 19.
10 you are placing for?
10 I was placing that subsequently it can also be filed. So I'm not joining.
Yes,
it.
yes.
But 19 your lordship would
Right,
kindly have.
Right.
The object of enacting Rule 3A in Order 41 of the Code seems to be twofold. First is to inform the appellant himself who filed a time-barred appeal that it would not be entertained unless it is accompanied by an application explaining the delay. Second is to communicate to the respondent a message that it may not be necessary for him to get ready to meet the grounds taken up in the memorandum of appeal because the court has to deal with an application for condonation of delay as a condition precedent. Barring the above objects, we cannot find out the rule that it is intended to operate as unremediably or irredeemably fatal against the appellant if the memorandum is not accompanied by an application at the first instance. In our view, the deficiency is curable. So, what I was on is that in this paragraph, the Supreme Court has said that it has to accompany with an application. So, when an application is there,
Here the Supreme Court says it's curable. Can we file later?
Yes. So
They have done that.
I'm not opposed. I'm not opposing per se that belated filing is
Can be done.
it can be done. I'm not saying. But what I am on is they have filed this application under Section 5 after 6 years. So this is where I join issues that Article 137 would squarely come. So that is why, my lord, in my humble submission.
What is the explanation given by them in their supplementary affidavit to which you're opposing that? So let us find that out.
Advise them to file a Section 5.
Let us see the supplementary affidavit.
No. Your lordship will kindly look at the Section 5 first, and thereafter I shall take your lordship to the supplementary affidavit.
Section 5, there is nothing.
Section 5, there is nothing. So when we pointed out, try.
So you can directly come to para 7 and 8 of the
Yes,
supplementary.
yes.
So you also know, he also knows, we also know that there is nothing in the section.
Yes, that's not,
So let's come to para 7 of the supplementary.
yes. Yes, so my lord, but the
Sir,
appeal
book
was
to tell
filed.
us this, sorry for this. This 3 years elapsed after the demise of the original appellant or before his demise? The 137 period that expired before his demise.
And that is the sole point where I'm objecting. But because if your lordship sees that the entire case made out, even in the supplementary, is he was a layman, he did not know. But then he filed the appeal, 117 days. It's not that he's filing the appeal later. So then it should have been accompanied. Now, your lordship would kindly also, before your lordship considers this aspect, kindly also sees provision of Order 41 Rule 11A. I would humbly beseech your lordship to kindly consider reading this with Order 41 Rule 3. Kindly sees 11A, time within which hearing under Rule 11 should be concluded. Every appeal shall be heard under Rule 11 as expeditiously as possible, and endeavor shall be made to conclude such hearing within 60 days from the date on which the memorandum of appeal is filed. Now, if your lordship considers both these provisions harmoniously, then possibly the intention of the legislature, in my humble understanding, subject to my lord's satisfaction, of course, would be that one has to file an appeal, and there has to be an endeavor that this appeal is, the Order 41 is heard within 60 days, or it may not be mandatory, but it's somewhat direct. So this would possibly not give a leeway to an appellant to file anytime thereafter at his own sway. So these provisions, along with Article 137, possibly has to be read into, in my humble understanding. Because otherwise, whenever the execution is levied, I can levy an execution after 12 or just before 12 years. They will come up with a Section 5 then. And then they can get the entire period convert. So this possibly, would not be the intention of the legislature to keep it pending for all times to come. The memorandum appeal will never get listed. Once the Order 41, the Section 5 is not, it will be at Zima stage or whatever it is. So, thus, in my humble submission, possibly these two would mean that they had to file it within. May not be with the appeal, but there. And your lordship would also kindly see the supplementary affidavit ground, the paragraph which your lordship pointed out, paragraph 7.
Yes.
And also paragraph 8. The only pleading is that he was not advised by the learned advocate to file a Section 5. So that is the explanation, in my humble understanding. And he did not know the formalities, so that is why. So this ignorance of law, when an appeal is filed belatedly, possibly would not come to the aid of him. When he was alive for even 3 years thereafter, he could have pursued the appeal.
Right.
Those are my questions. And also one thing, that 1992 judgment is only in a mandamus. That is not
the one you cited.
No, the one your lordship was referring to, Justice A.N. Rai and Justice A.M. Bhattacharya, which
was relied on by Justice Chakraborty.
On the ground that application is not required to be made in writing. An oral application is also permissible. That, in my humble submission, because of the specific provision of Order 41 Rule 3A, would not be applicable.
Can 5 year pursue the order? Heard learned counsel for the parties. Next para. The present appeal has been preferred after a delay of about 4 months from the expiry of the limitation for filing the same. Can 5 of 2025, however, has been filed on April 30, 2025, that is long after the filing of the appeal on September 11, 2019. Next para. The said application is vehemently opposed by learned counsel for the respondent, primarily on the ground that even the application for condonation of delay has been filed beyond the period of 3 years from the appeal being filed, which is the mandatory limitation period in terms of Article 137 of the Schedule to the Limitation Act for residuary applications. For sub next para, learned counsel places reliance on a coordinate bench judgment in the matter of SAT 2737 of 2007 within bracket Uttara Rai and others versus Sushanta Mondol. Full stop next para. In the said judgment, comma, the learned single judge, comma, although proceeding on the premise that the expression double inverted shall appearing in order 41 rule 3 capital A of the Code of Civil Procedure is not mandatory, and an application for condonation of delay in preferring an appeal under the said provision can be filed even belatedly, comma, after the filing of the second appeal, comma, nonetheless, comma, the learned single judge observed by placing reliance on another judgment of this court held that the application for condonation of delay in preferring an appeal, comma, either under Section 5 of the Limitation Act or under Order 41 Rule 3 capital A of the Code, comma, has to be filed within 3 years, comma, in adherence to Article 137 of the Limitation Act. For sub next para, learned counsel also cites state of such and such reported at 2000, volume 7 SCC 372, and argues that although an application for condonation of delay in preferring an appeal can be filed after the preference of the appeal and the deficiency is curable, comma, nothing in the said judgment relieves the appellant of the liability to file an application for condonation of delay within the period of residuary period of 3 years from the preference of the appeal in terms of Article 137 of the Limitation Act. For sub next para, learned counsel for the respondent also points out that in terms of the explanation sought to be furnished in the supplementary affidavit to the application for condonation of delay, comma, the primary ground for the delay during the lifetime of the original appellant, comma, whose heirs have since been substituted, comma, is that he was a layman in law. For sub, learned counsel submits that since the period of 3 years from the preference of the appeal and before the filing of the condonation application expired during the lifetime of the original appellant, comma, the principle that ignorance of law is no ground is applicable, and the reasons furnished in the supplementary affidavit cannot be a good ground to condone the delay. For sub next para, learned counsel for the appellant controverts same and submits that the principles as laid down in the above judgments cannot be an impediment to the allowing of the present application, since sufficient reasons have been given for the delay. For sub next para, upon hearing learned counsel, comma, we find that certain cardinal questions arise for consideration in the present matter. First up, the first such question is whether an application for condonation of delay in preferring an appeal under either Section 96 or Section 100 of the Code of Civil Procedure can be constituted to be one under Section 5 of the Limitation Act. Full stop. The positive answer to that is no, within double inverted no, comma, since there is a specific provision as stipulated in Order 41 Rule 3 hyphen capital A of the Code of Civil Procedure, and it is well settled that where there is a specific provision of law, comma, the stipulations in Section 5 of the Limitation Act cannot be invoked. Full stop. Hence, comma, we proceed on the premise that the present application under the present application, comma, captioned to be one under Section 5 of the Limitation Act is, comma, in effect an application under Order 41 Rule 3 capital A of the Code. Full stop. Next para, it is another well settled principle of law that wrong caption does not take away the right of an applicant to get a relief as sought for in the prayer portion if the court otherwise has the jurisdiction to grant the same. Full stop. Next para, the next question which arises for consideration is whether the provision of Article 137 of the limitation of the schedule to the Limitation Act is applicable, and, comma, if so, comma, what would be the effect of that on the present application? Full stop. Next para. Upon a considered reading of the judgment of the learned single judge of this court in the matter of Uttara Roy and others supra, comma, we are of the view that learned counsel for the respondent is justified in arguing that the provisions of Article 137 are indeed applicable to an application under Order 41 Rule 3 capital A of the Code of Civil Procedure. Full stop. Next para. However, comma, we introduce a caveat here. Full stop. In the same breath that we hold that Article 137 of the Limitation Act is applicable to such an application, comma, we cannot but also keep in mind that the invocation of Section 5 of the Limitation Act to condone the said delay beyond 3 years as stipulated under Article 137 is automatically incorporated into the principle. Full stop. Next para. The moment it is held that an application or an appeal is barred by any of the provisions or articles of the Limitation Act, comma, simultaneously the applicability of Section 5 of the said Act is also attracted by definition. Full stop. Next para. Proceeding from such perspective, comma, we construe that the prayer for condonation of the delay in filing the appeal as incorporated in the prayer portion of Can 5 of 2025 should be read liberally, comma, in consonance with the established practice of hearing applications for condonation of delay, comma, to incorporate the inbuilt prayer of condonation of delay in filing the said application itself as well. Full stop. Next para. Keeping in view such perspective of the matter, comma, we look into the supplementary affidavit which has been filed with the leave of court in support of the said application for condonation of delay. Full stop. Next para. In paragraph number 7 onwards of the supplementary affidavit, comma, the explanation has been sought to be furnished at length for the delay in preferring the appeal as well as the application. Full stop. We find from paragraph 7 of the supplementary affidavit that 2 grounds have been taken therein, comma, one, that the original appellant was a layman in law, and secondly, that he was in a financially weak condition and could not find an advocate in time. Full stop. Next para. Thus, comma, there was sufficient justification which was rendered by the financial insolvency of the appellant as well, comma, for the delay in preferring the appeal. Full stop. Next para. Insofar as the other argument of the appellant, the original appellant being ill-advised in preferring the appeal, comma, as appearing in paragraph number 8 of the supplementary affidavit, comma, we find that maxims of law and principles evolved over time by legal jurisprudence are not edicts, edicts, edicts set in stone, and are not commandments which cannot be altered at any future point of time. Full stop. We have to read some amount of compassion into the WRI, letters of law. Full stop. Next para. Although under normal circumstances, comma, it is indeed the settled law that a person cannot take shelter under the ignorance of law for preferring an appeal late, comma, since such a scenario would open a floodgate for unscrupulous litigants to delay filing of appeals and applications. Full stop. However, comma, it does not automatically mean that in appropriate circumstances where some amount of lenience is justified in view of the financial circumstances and the other situations, other attending situations, comma, the court would be powerless to condone a delay even if such circumstances were existing, comma, merely by blindly following the dictum that ignorance of law cannot be a sufficient ground for doing so. Full stop. In fact, comma, we have a peculiar jurisprudence in the sense that the ignorance of law of a litigant is not a sufficient ground, whereas the ignorance of law of an advocate is not attended with any such rigor. Push up next para. There are circumstances where, keeping in view the backward and marginal sections of the society being in a disadvantageous position, that it cannot be imputed on every litigant that such litigant is abreast of all the nuances of law, including the limitation period. Full stop. Next para. Hence, we do not defy the established principles that under normal circumstances, ignorance of law is not a proper ground, we read some lenience and compassion into the said maxim in the circumstances of the present case, where the original appellant has met his demise and his heirs, who have stepped into his shoes and are conducting the appeal, have come to the court through legal aid, which itself is a sufficient indicator that they hail from the marginalized sections of society. For next para, taking into view such circumstances, we do not find any reason why the appellants should be shut out from the corridors of justice merely because their predecessor in interest was not learned in law. For next para, even otherwise, since the application is construed to be one under Order 41 Rule 3 capital A of the Code of Civil Procedure, and we apply Article 137 of the Limitation Act thereto, we also invoke our powers under Section 5 of the Limitation Act to condone the delay in preferring the application as well as the appeal, in view of the factual considerations as indicated above. First step, accordingly, the delay in filing Can 5 of 2025 is condoned. First stop. Can 5 of 2025 is also allowed in view of the above considerations, thereby condoning the delay in preferring SAT 309 of 2019. First stop. Next para. The appeal is now. Are you ready with the appeal? Order for
The stay application I'm ready with.
The appeal has to be admitted first.
Yes, I'm ready.
Accordingly, the appeal is taken up for hearing under Order 41 Rule 11 of the Code of Civil.
Possibly there is a deficit.
Deficit code fee.
Possibly, I don't know. I've been instructed, but the lordship is.
The cause list.
We'll just check up, Mr. Thank you for pointing out.
Effectively,
It's not indicated in the memo.
I've been only told.
Yes, there is a deficit code. 1380 rupees.
stamp it.
Very well. According to the last sentence, at this juncture, it is quite correctly pointed out by learned counsel for the respondent that there is a deficit of rupees 1380 in deposit of the court fees. Full stop. Since this is a legal aid matter, we direct the legal aid services authorities of this court to ensure that the deficit court fees are put in within a month from date. Full stop. The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes, Mr. Medora.
My lord.
I filed the affidavits in opposition to Can 4.
Can 4 is the stay. Let us first admit the appeal. That lenience is not extended to principles of law. Yes.
This is the third round of litigation between the parties. That I was the original defendant.
It's an eviction suit.
Eviction suit.
And it's a judgment of affirmance.
No.
Reversal.
Reversal.
Eviction suit on the ground that you were a tenant.
I'm a tenant.
97 Act.
97 Act.
All right. What was the ground?
My lord, the ground taken, my lord, was non-payment of rent or default in payment.
Only default.
Default in payment of rent and default in payment, my lord, of the municipal charges.
Within that.
Within that scope.
So that was the only ground. Trial court dismissed. Why?
Trial court dismissed, my lord, stating, my lord, that So far as the default in rent was concerned, my lord, it didn't really find any merit in that argument. So far as default in payment of municipal charges was concerned, my lord, the trial court held that that will not come within the scope of default.
Because that will not come within the rent.
The rent, yes.
How did the appeal court reverse it?
Well, the appeal court reversed by saying exactly the contrary.
No, let us see the logic of it.
And I'll also just point out, my lord, it's a subsequent thing. I believe, my lord, there have been similar cases, my lord, filed by the same landlord against similarly placed tenants. And the matters came up before this High Court in second appeal. And, my lord, in second appeal, my lord, they were admitted. And, my lord, the judgment has gone in favor of the tenants. I'm carrying those judgments with me.
Cite one or two. The final judgment has been.
Yes. In fact, Mr. Gupta perhaps is aware of it because I find his name also. Kindly give me one more.
Remember, all right.
না এটা হ্যাঁ আপনার আরেকটা কপি এটার আছে না
So the substantial question of law, whether municipal tax comes within the purview of rent.
Yes, these were the substantial questions of
the appeal on that.
which had been framed initially.
Yes.
My lord, we'll see, my lord, the respondent is the same respondent, Kanchana Mukhopadhyay. দুটো আছে একটা
Is the review pending from this?
Yes, I've checked. That is correct.
Premises Tenancy Act একটু দিন না Premises Tenancy Act 97. We'll admit it on the question that whether this, on a composite reading of section 5(8), municipal taxes and section 6, municipal taxes can be construed to come within the definition of rent.
I'm carrying the final judgments also passed.
Keep it.
There is a Supreme Court judgment completely contrary to this. Popat Court, which where suit was dismissed, appeal preferred by the plaintiff was dismissed. Supreme Court passed the eviction decree on the ground that under section 5(8) of the Premises Tenancy Act, paying the municipal taxes is mandatory, and because there is a default, the eviction decree was passed by the Supreme Court.
Popat has been considered by the learned judge in
But that was
passing the
just
final
given
judgment.
It's an arguable question.
But your lordship would kindly see that it squarely on that, because
Arguable question.
its law has been laid down.
That has been considered by a division bench of our court and explained.
That is why we have
Review is there, review is
But-
pending, but there is an existing judgment which has considered Popat Court, a coordinate bench or a single bench. It's arguable, definitely.
But
This
your
second
lordship
appeal
kindly
will
see
be this second appeal will be heard on the following substantial question of law, whether on a composite reading of section 5 within bracket 8 and section 6 of the West Bengal Premises Tenancy Act 1997, the municipal taxes, the share of municipal taxes payable by the tenant as an occupier can be construed to be a part of the double inverted rent, for non-payment of which a tenant is liable to eviction. Second, whether the learned judge of the first appellate court substantially erred in law in reversing the decision of the court of first instance on the premise that the appellant, the predecessor in interest of the present substituted appellants, was liable to be evicted for non-payment of rent uh, in view of having not paid his share of the municipal taxes. Yes. Substantial question of law is that, and what is your stay application? You have to pay the rent, occupation
Yes, I will
charges.
have to.
What should be the occupation charge? Occupation charge.
I'm
You have filed an
affidavit.
opposition to this.
So I was about to file.
There'll be limited stay. You file a reply to this. You have got prepared a reply. You
No, no, I haven't been served also.
That's a fair. Can 4 of 2025 is an application. Is it Can 4?
Yes, it is can for my lord.
Can 4 of 2025 is an application for stay of operation of the impugned judgment and eviction decree. You have levied execution, Mr. Gupta?
Yes.
As on date, there is an amount much in excess of 5 lakhs which is due and paid.
Let them use a reply and come back. It's your assessment. You have to decide that.
My assessment with all supporting documents
No,
pertaining
no,
to the same
you'll have to give
premises,
them an
the
opportunity.
adjoining premises, and the location of the property.
The affidavit in opposition filed to the said application today be kept on record. Full stop. You have served a copy. A copy thereof is served on the learned advocate for the appellant here and now. Full stop. The appellant shall file, the substitute appellant shall file their affidavit in reply to the said opposition within 3 weeks from date. Full stop. There shall be stay of operation of the impugned judgment and decree as well as connected execution case, if any, till disposal of the application. Full stop. However, it is made clear that the question of imposition of occupation charges from the date of passing of the impugned decree by the first appellate court shall be kept open for being decided finally by the learned judge taking up the stay application for final hearing. Full stop. Next para. The liberty to the parties to mention the application for hearing before the appropriate learned single judge having jurisdiction after the expiry of 3 weeks from date.
I sincerely object to this. Whenever division bench grants any stay, some condition is put in and the subject to the final outcome of the single bench, considering the stay application. But if your lordship kindly, then
what condition?
Because there is no regular second appeal bench now, we will not be able to get
There is
the
no regular second appeal bench.
The honorable judge sits with the division bench as and when sits.
It is not a single regular second appeal hearing bench. Cannot be, sir.
Justice Supratim Bhattacharya is there, but he sits in the division bench.
Is it so? Cannot be, Mr. Gupta. Check up and tell us later in the day. Send somebody and tell us if there is no bench. We'll have a talk with the Chief Justice. That cannot be.
But your lordship's
But this remains.
I'm sorry, no, my lord, your lordship when grants any stay for temporary, at least passes some order, my lord.
Never grant that. Occupation charges we never impose.
But because, my lord, it's been pending for last 6 years, my lord.
Whatever you get from the date of the decree, that we have kept open, Mr.
Yes, but
not now.
Till such time, because if the application is there, my lord, till whenever till the disposal, but then that would give them the leeway, my lord.
ঠিক আছে যেটা বললাম যে stay till disposal of the application না করে stay till disposal of stay till
kindly grants it for a limited period within the
stay till stay of operation যেটা বলেছি till July 31, 2025 or until further order, whichever is out. Next. Yes.
Grateful, my lord.
Thank you.
Lordship, I am appearing for the appellant.
What is the defect?
I have applied for the landed trial court record, but Lordship, till date, it's not come to my hand. So,
counsel for the appellant submits that despite having applied for,
my lord, I am praying for more 3 weeks to
applied for certified copies of the judgment and decree of the trial court, those have not yet been furnished to him. Full stop. Accordingly, let the matter go out of the list. Full stop. The appellant shall file the certified copies of the trial court as and when the same are obtained by the said learned advocate for the appellant with the department, and the department shall give a fresh revised report in that regard. Full stop. Liberty to the appellant to mention the matter for inclusion in the list as and when such certified copies are filed. Out of list হয়ে যাবে. The moment you file it and get a report, mention, we'll take it. Next.
Lord 9, I am the appellant. 8, Lord Mr.
You're for the appellant?
Yes. Lord 9, item number 9. 8 and 9 are Lord clubbed together.
Why? What is the application?
But the plaintiff is the appellant before your lordship, my lord, in item number 8.
Suit
Lord,
for?
if your lordship suit for, my lord, the declaration of my right, title and interest as well as for eviction, treating him to be a licensee.
License, yeah. And what is his defense tenant?
My lord, no. His defense is that, my lord, my predecessor purchased the property in question, my lord, from one of the Corfa tenant by virtue of a deed. My lord, the quantum of the property is 1 bigha 10 katha. So their defense is that the Corfa tenant was there. Since, my lord, after promulgation of the Estate Acquisition Act, his right, my lord, has now been merged as a, my lord, full owner. And, my lord, whatever the transfer that has been made, my lord, in favor of my predecessor, prior to that, one deed has, my lord, several deed has been executed.
Your
Who is
title is
that?
merged with the state. That is their stand.
That is their stand. That is their stand. But in nevertheless, my lord, out of 1 bigha 10 kathas, only 10 kathas was being, my lord, transferred during the lifetime of that Corfa tenant, prior to my purchase. My purchase means, my lord, my predecessor purchase. Lord, I will give your lordship, my lord, to buy
Total is 1 bigha.
1 bigha 10 katha.
So you purchased 10 kata.
No, they have, my lord, by virtue of certain, my lord, deed of gifts, my lord, the Corfa, original Corfa tenant have transferred to their sons, who are the defendant in my suit, 10 katha out of 1 bigha 10 katha. That was happened sometime in 1963. Thereafter, that Corfa tenant transferred to my predecessor in 1965 the entire land, 1 bigha 10 katha. In 1964.
Including that 10 kata. 10 kata could not have.
Lord, I'm coming, Lord, it both the way. Lord, so, Lord,
But
they are
it's sold in your favor.
sold in favor of my predecessor, through whom, Lord, I am claiming. Lord, thereafter, in 1966, Lord, the transfer happened in my favor, the plaintiff's favor. Entirety 10, Lord, 1 bigha 10 kata.
1966 it happened means 1965 it happened.
64, Lord, my predecessor.
64.
1964.
Achha.
Lord,
Then
15th June 1964.
Oh, your predecessor in interest, not
My
your,
predecessor
not
in
by
interest. No, not by virtue of
You
inheritance.
purchased in 66.
66. So this is, Lord, their case at best, Lord, in the written statement is that since the Corfa tenant, Lord, after promulgation of Estate Acquisition Act, Lord, the entire right merges. So, Lord, this Corfa tenant, Lord,
Estate Acquisition Act, I've forgotten the year.
53.
53.
So entire three was both your transfers were after 1953.
Yes.
So both would become bad then. But it's your suit for eviction.
It's my suit for eviction. No, their case is that first, Lord, that after promulgation of Estate Acquisition Act, since, Lord, the Corfa tenancy, Lord, that was merged with the original, Lord, actual ownership. So, Lord, first 10 katha is by virtue of those deeds, and thereafter, that, Lord, after the remaining 1 bigha by virtue of inheritance, though there is a deed existed in favor of my predecessor, at least to the extent of 1 bigha.
No. 10 katha, they
10
were,
katha, Lord, for the time being,
they were also heirs of the Corfa.
but, Lord, they will have to bear it on mind that their predecessor, through whom they are claiming inheritance of 1 bigha, he has transferred it 1 bigha 10 katha. So, Lord, leaving aside 10 katha, 1 bigha during the lifetime of that Corfa tenant, that original Corfa tenant transfer in favor of my predecessor, through whom I am tracing title.
Corfa tenant, he says that Corfa tenant did not have the right to do so. Right to transfer at all.
No, Lord, that I will satisfy. That I will satisfy.
If the Corfa tenant did not have a right,
Lord, that I will
if it
satisfy.
has
Lord,
been
under
that
the
is-
Bengal Tenancy Act, the Corfa tenancy is transferable. That is transfer. And, Lord, certain thing, Lord, who is that, Lord, my predecessor? She was the original, Lord, landlady, whose name was recorded as Rayat. So it is a transfer vis-a-vis in between a Corfa tenant and the original landlady. It's not a third party. I will show, Lord, that distinction.
Corfa tenant was the same person as the landlady.
Yes, he was the Corfa tenant under that landlady.
No, Corfa tenant under that landlady.
Yes, so, Lord, this.
How does it help you? What
Yes,
is the
because
extra?
Lord, if under the Bengal Tenancy Act, if the Corfa tenant want to transfer it, a prior permission from the landlady is required. So I will say that 10 katha which has been transferred, that is, Lord, with a bad in law because no prior permission has been taken.
No, the transfer in your favor was attended by a permission.
Lord, Lord, my predecessor is the landlady.
Oh, acha. Court
That's
tenant
right.
transferred to your
Yes,
to
yes,
the landlady.
yes. Lord, I will show Lord, from the RS recording, even CS recording. CS recording, superior landlord is that superior landlady is my predecessor, through whom I am tracing title. So he was a Corfa tenant under that landlady. So your lordship knows, Lord, after the Estate Acquisition Act, Lord, since the superior right goes, that's why Lord, certain transfer took place.
But gift deed took place in favor of
The heirs of the.
heirs of, yes.
Lord, there are two different arguments Mr. Chatterjee can make. If the written statement first submission is
Why? Who is the second? Another appeal by him. He also filed a counterclaim.
no, not counterclaim. What happened? Lord, my suit has been decreed by the trial court. Lord, he preferred an appeal. The appellate court found that no, entirety he is not the owner, because the 10, Lord, out of 1 bigha 10 katha only 10 he has been. So Lord, the appellate court held that no, I am having ownership to some extent, and he is also having an ownership to a such
Trial
extent.
court passed in your favor.
Trial court passed in my favor.
So appeal court held that he has only 10.
No, Milord, appeal court held, Milord, land is of 34 decimals. Milord, 17.5 in my favor, 17.5 in his favor.
That is also a wrong calculation from
It
what
may be
Milord,
16.5, Milord.
and Milord,
Half.
Milord, the appellate court finds Milord something new, that he has made certain construction which is Milord under section 60B Milord of the Easement Act, since that is Milord with the prior approval, that Milord presupposes Milord it's something Milord which is not on record, what Milord previous permission was being given by my Milord predecessor to make him construction, and so his right is unevictable. So Milord, ultimately my eviction suit goes. Since Milord, his quantum of land is being quantified Milord to certain extent, Milord, he is also preferred an appeal before your lordship's court. But Milord, there is one interesting point also. Milord, what happened? Milord, previously, this Milord, once the suit has been decreed, they preferred an appeal. The appeal court Milord ultimately passed the similar order. I came up before this honorable court in a second appeal. Milord, and before the division bench, it has been pointed out that one of the respondent died Milord during pendency of that appeal. So since Milord, that has not been Milord, the abatement took place and no substitution was being done, this honorable court, relying upon 90 Calcutta, Milord, your lordship knows, Milord, since it has passed against a dead person, ultimately Milord, the entire judgment has been set aside, saying that it's a nullity, and remands the matter back. After remand, what has been done, Milord, I have annexed Milord in Can 2, the learned judge is of the considered opinion, since it's a remand, only with a point that this has been passed against a dead person, so substitution has to be done. Once the substitution has been done, there is no question of rehearing the appeal again. So I am reproducing whatever my predecessor in chair has done, and thereafter he has reproduced everything. So Milord, if the analogy of Milord, 90 Calcutta is taken to be true, then Milord, there has to be a rehearing of the appeal. Once the judgment is being set aside, saying that it's a nullity passed against a dead person, the same reproduction of the similar thing, Toto, Milord, after observing that it's a limited remand only on the ground that one of the dead party is on record. So once the substitution took place, that defect has been cured. So there is no question of rehearing the appeal.
Under which section is transfer permissible with the permission of the landlord?
Section 26 capital B of the Bengal Tenancy Act. But there are certain line of judgment of also Milord of this honorable court holding that yes, there is
Just
no
read out section
absolute
26B once.
Yes.
That relevant.
No, I mean non-agricultural tenancy, because this is non-agricultural tenancy, Corfa tenancy. So therefore, under non-agricultural tenancy act, Milord, section 9A puts restriction.
What restriction?
Milord, restriction is to the extent that it can be only transferred to the extent of mortgage, life insurance corporation, cooperative society. Milord, if Milord looks to the profession. Non-agricultural tenancy.
Section
my lord, 9A. My lord has got my lord 9A. Non-agricultural tenancy, my lord.
This is
Lord, the non-agricultural tenancy,
14
Lord,
of
does
land
not
reform
define
chapter.
the, Lord,
Find out the
Korfa
clause.
tenant.
Lord, can you have
প্রতিদিন দেখুন কি দিয়েছেন, দেখান ওনাকে কি দিয়েছেন।
Bengal Tenancy Act,
no, land reforms act. It's a land reforms act. It's a non-agricultural tenancy.
পারবে না কেন? And your section 26B says
My lord, our court has also affirmed, my lord, Korfa tenancy is non-transferable, my lord, reported in 1984 Calcutta, page 122. My lord, in a rent execution case, sale was made. My lord, there, my lord, a Korfa tenant intervened. My lord, the question came up before this honorable court, what is the status of the Korfa tenant as there already been sale occurred? My lord, question of Estate Acquisition Act, my lord, was considered. My lord, there, my lord, it was argued by Mr. Mukherjee, Shokinath Mukherjee, and it was affirmed, my lord, that Korfa tenancy is non-transferable, and it was further argued, my lord, due to coming of the Estate Acquisition Act, the right to retain the land, my lord, is lost by the purchaser because he is not in possession of the land, which has been upheld by Honorable Supreme Court. So he cannot pray for recovery or, my lord, annulment of Korfa tenancy. So, my lord, if he loses his right of retention, my lord, under the Estate Acquisition Act, coupled with, my lord, read with Land Reforms Act, my lord, which gives effect or right, my lord, upon the Korfa tenant to become a riot of the land directly under the state, my lord, he loses his right of recovery also, because he was not in possession since day one, my lord, when the, my lord, estate acquisition came into picture. My lord, these two issues were held. So, my lord, today his prayer for recovery of possession goes.
Lord, this is, Lord, the 26B says, the holding of an occupancy right or share or a portion thereof together with the right of occupancy therein. Lord, that is the definition of Korfa. Then subject to the provision of this act be capable of being transferred in the same manner and to the same extent as other immovable property. And Milord, I am coming, Milord, Mr. Chatterjee's submission is first based on Korfa tenancy. What is his case in the written statement? His case in the written statement is that, Milord, we all know after promulgation of Estate Acquisition Act, what right goes? The right of intermediaries. So whoever actually in possession of the land, he becomes direct tenant under the state with a non-evictable right, as if he is a full owner. He will pay the ground rent directly to the state. But that is the case. What is his case in the written statement? I shall take your lordship that his predecessor, who was the Korfa tenant, he was there in the actual physical possession of the land. So what right goes? My predecessor's, Lord, the superior right, that all goes because he was at the ground. So he becomes direct tenant under the state. So, Lord, the Korfa tenancy evaporates as per his defense case. So his predecessor, who was a Korfa tenant, his right has been elevated and he become a direct tenant under the state as if he is the owner. So he becomes the owner. Now the question of Korfa tenancy, transferable, non-transferable, that evaporates. So that after that elevated status, what he has done, he transferred 10 kathas to his sons by virtue of different deeds. Demarcated.
There was
portion.
a landlady between in between. You were in between. Korfa tenant was in between.
In between.
Landlady was there.
Landlady was not there, Milord, in the ground.
No, could not have
physical
been.
possession is, Milord, with the Korfa tenant.
Case must have been he has purchased with the Korfa tenant because the Korfa tenant had.
No, he has not purchased Korfa tenancy. That the appellate court has
gifted.
Milord, I shall take
He was gifted by the landlady.
No.
He was
I was the Korfa tenant, Milord.
He was not the Korfa tenant. His father was the Korfa tenant. His case is that Korfa tenancy goes after promulgation of Estate Acquisition
His
Act.
father did not transfer to you.
His father has transferred to me. That's why the question arises. The defense case is that his father, after promulgation of Estate Acquisition Act, his status has been elevated as a owner. What right goes? My predecessor, who was the superior landlord, his right goes as an intermediary. That is his case in the written statement. So once his father become a direct tenant under the state, as if the owner, he done by virtue of separate deeds transferred 10 kathas in favor of these defendants, sons, demarcated portion, remaining 1 bigha with his hand. And thereafter, he transferred that 1 bigha 10 kathas again.
So by this same logic,
Yes.
if you don't have title, they should not also have title.
Lord, I bow down to that. That's why the case
Chatterjee,
made out
how
in
do
the
you say to
written
that?
statements.
Because you are claiming to the
Lord,
court
if
for
my
tenant,
lord
he is also claiming to the court for tenant.
And not the court for tenancy.
Lord, I am claiming through my father, my lord, who was a
Was a court for tenant. He
My
had
lord,
transferred.
court for tenant had a right of inheritance, my lord, and my
So
lord,
whatever rights you have, they also have similar right, you are saying.
no, my lord, my
Your father transferred to them.
my father
So you
transferred.
said transfer was not permissible.
Transfer was not permissible. So, my lord, today, my lord, and my lord, what Mr. Mukherjee submits
Mr.
after coming
Chatterjee's
into
transfer is not permissible,
Exactly.
is denoted to the court for tenancy. But his case in the written statement that court for tenancy goes and his father becomes a
my lord,
direct
court
tenant
for
under the state.
tenancy goes, my lord, in the year 1969. My lord, after my lord, section 3A was given effect to under Land Reforms Act. My lord, this is Land Reforms Act. If my lord takes up section 3A of the Land Reforms Act, my lord, estate acquisition says 6 and 6. My lord, that section 6 was given effect in 1969.
Right.
So, my lord, 64, my lord, there was no right.
The present second appeal shall be heard on the following substantial questions of law. 1. Whether the transfers in favor of the predecessor in interest of the present appellant, if you say appellant, then it is
My lord, there should be 2 admissions.
plaintiffs. You are the plaintiffs.
They are
And
the
the plaintiffs, yes.
Of the
Eight.
predecessor in interest of the plaintiffs is vitiated by the bar under section 9 capital A of the West Bengal Non-Agricultural Tenancy Act. 2. Next ground, whether the court for tenancy of the predecessor in interest of the defendants was governed by section 20 by the limited power of transfer under section 26 capital B of the Bengal Tenancy Act or section 9A of the West Bengal Non-Agricultural Tenancy Act. Roman 3, whether the learned first appellate court substantially erred in law in reiterating its previous judgment after remand without a rehearing on all issues, in view of the remand being an open remand after setting aside the entire previous appellate judgment on the ground that the same was nullity, having been passed in the name of a dead person. Next, for the timing, let these be there. These will suffice. You can always add grounds.
But I have
Apart from status quo, we cannot.
Yes, yes.
Who is in
that's-
person?
I am in possession. My lord, admittedly,
to
his
tra-
praise for recovery.
Yes, yes. That's
Yes.
why not to create further third party interest.
Very well. Can 2 of 2025 heard learned counsel for the parties on the injunction application, full stop, in view of sufficient prima facie case having been made out, can 2 of 2025 is disposed of by directing both parties and or their men and agents from to maintain status quo with regard to the suit property till disposal of the appeal. Blanket status quo regarding appeal till disposal of the appeal. Full stop. Who shall prepare the paper books?
Not both.
Whose appeal is first? Your appeal.
My
No.
8
Lord,
is his
8 is
appeal.
my appeal.
9 is
9
my
is
appeal.
Mr.
No, not first. He filed first.
I filed first.
Second appeal paper. The plaintiff stroke appellants in SAT 3 of 2022, because you have got that injunction. SAT 3 of 2022 shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants in SAT 3 of 2022, full stop. The trial court records shall be brought by special messenger at the cost of the plaintiffs to appellants in SAT 3 of 2022, which shall be deposited within a week from date, full stop. Next para. In view of appearance, you are appearing for all the parties, obviously. In view of appearance of all the parties, comma, service of notice of both the appeals is dispensed with. Full stop. It is made clear that the paper books to be prepared shall be composite paper books in respect of both the appeals.
LCR we called for.
Yes, already.
There is a separate order in 9 minutes. Because in 9 there is no application for injunction
No.
of any manner.
Can 2 is only, there is only one can 2. Single order, because both the appeals will be heard on the. Acha, একটা জিনিস, the present second appeals shall be heard analogously on the following substantial questions of. Great. Thank you very much. এটা আমাদেরই বই, দুটোই আমাদের? না, দুটোই কি আমাদের বই? এটা আরেকটা একই বই রয়েছে, সেটা ওনার দিকে তাহলে থাকবে। এটা তাহলে এদিকে। ও না, সরি, ঠিক আছে। থ্যাংক ইউ। ওটা ল্যান্ড রিফর্মস, এটা ইয়েস। দেন দেখি ডিসমিস ফর ডিফল্ট করি একটা, অনেকদিন ডিসমিস ফর ডিফল্ট করা নাই। None appears for the appellant at the time of call. Push up. Let the matter stand adjourned for the day. Activity chance do report.
My lord, I am for the appellant, my lord. I am praying for 1 week accommodation, my lord.
Why?
Previously, my lord, I have prayed, my lord, time for filing the Vokalotnama.
Yes.
There is the Vokalotnama has cannot be
Got
obtained.
the entire vacation, Mr. Lairi.
My lord, I lost my 2 relatives, my lord. That's why I cannot contact with the client, my lord.
What is the nexus between the two? You lost your 2 relatives. You
No,
could
no,
have.
I am
picked
out
up
of station, my lord. That's why.
When should you keep it?
My lord, next week, my lord, I think.
Very well. Learned counsel for the appellants seeks. Oh, you are for the appellants, you see.
Appellant.
Learned counsel for the appellants seeks an adjournment. Next Monday, we are keeping it.
Next one.
Accordingly, let the matter stand adjourned till June 16, 2025.
If you-
Please give your appearance. Yes. Again, none appears for the parties at the time of call. Let the matter stand adjourned for the day.
Next week, my lord.
On the prayer of the appellants, let the matter stand adjourned till June 16, 2025. None appears for the parties, adjourned for the day.
This matter, Mr. Sukanta Das, learned advocate, is appearing for.
Yes, Sukanta Das. Yes.
Yes, my lord.
He's for the appellant.
Yes, he's suffering with fever. My lord, kindly make accommodation for 1 week.
Yes. On the prayer of the appellant, Mr. Mathi, you give your name. On the prayer of the appellant, let the matter stand adjourned till June 16, 2025. None appears for the parties, adjourned for the day. Same.
Item number 18, my lord, Rithendra Banerjee is appearing on behalf of the appellant. My lord, so far as
Use the microphone, please.
yes. There is during pendency of this appeal, my lord, the appellant number 1 has died, my lord.
Why did you take out? The appeal is abated then.
Yes, we have already prepared an application, my lord. The application is running
Appearing
in the
today?
list, yes, my lord.
Oh.
The legal years, my lord, are already on record, my lord.
Oh, then we'll allow that.
This simply, my lord, application for taking note of death, my lord. The
Right. Who has died? Appellant number 1.
appellant number 1, my lord.
Very
And the legal years, my lord, 2 to 6 are, my lord, the legal years of the.
Respondent numbers 2 to 6.
Yes, my
Very good. Can 1 of 2024 এর উপর অর্ডারটা হবে? Since the heirs and legal representatives of appellant number 1, comma, who has met he or she
C, my
who has met her demise during pendency of the appeal are already on record, comma, can 1 of 2024 is allowed, comma, thereby recording the death of the appellant number 1, full stop. The learned advocate on record for the appellant shall delete the name of the appellant number 1 from the cause title of the memorandum of the appeal during the course of the day. You are the advocate on record?
No.
Whoever he's there in
Yes,
court,
yes, my lord. He is there.
ask him to do it during the course of
yes.
the day. What about the appeal? Appeal is against what?
Kindly, my lord, adjourn it for the day, my lord. Ritendra Banerjee is appearing for the appellant's, my lord. Kindly adjourn.
যেটা বললাম সেটা তারপরে হচ্ছে let the now on the prayer of the appellants, comma, let the appeal stand adjourned for the day for the purpose of hearing under order 4111 of the Court of Civil Procedure.
So defendant is the
Yes.
appellant before lordships.
Right.
Now, my lord, this is a judgment of affirmance suit for eviction of a licensee. And my lord, it appears that our defense was that we applied for foreign liquor shop before the Hooghly Superintendent Office following certain criteria a rental house. He informed about the same to the plaintiff's father, 40 feet by 14 feet at a rent of rupees 250 per month. An agreement was executed on 13/12/2004 in favor of the defendant. And the father of the plaintiff signed on the blueprint required for the superintendent office, which are thereafter submitted. But the plaintiff's father, in order to deprive the defendant, my lord, Suomotu executed the agreement of his own in his own favor without informing the defendant and signed on it. On its basis, he filed a title suit 100 of 2008, where all the evidence were closed, but due to failure of the case, the said suit was dismissed. So the suit filed by the father of the plaintiff was dismissed. Then, my lord,
suit filed by your father against whom? By their father against whom?
Against my client.
That suit was also for eviction.
Eviction. Now, sir, that was dismissed for non-prosecution.
Non-prosecution, there was no adjudication on merits.
That's true, but my lord, it appears that due to failure of the case during the pendency of the suit, he allegedly transferred the suit property to his son, the present plaintiff. Now, plaintiff thereafter filed this suit to oust the defendant without any personal requirement. Learned judge decreed the suit. Thereafter,
what is the substantial question of law?
Substantial question of law, the
personal requirement or licensee?
Personal requirement.
This was 1997 Act.
No, this is a suit for under
56 Act.
And 6 of the Transfer of Property Act. Section 6.
So what is the question of personal requirement? A notice is
I do not know. This is the plaint. This is the plaint.
106 notice was given.
No, it has been.
What was the finding of the court?
Yes. Can you look to this?
Yes, 106.
106.
So both courts believe that the 106 notice was given. They have executed.
Notice, my lord. It is the finding of the courts below that notice was refused, and that is a good service. Now question is, my lord, that appellate court committed substantial question of law.
Yes.
In holding that Ranjit Kumar Das was in not holding that Ranjit Kumar Das was the landlord of the defendant, not the plaintiff. That means the plaintiff father was the landlord, not the plaintiff.
He has transferred in favor of the plaintiff, you said.
Yes, during the pendency of the earlier suit.
So therefore now the plaintiff is the owner.
And my lord, subsequently, the plaintiff made another agreement, and that was not bipartite, but my lord, only the plaintiff.
You have not taken these points in the trial court. None of these points were taken.
That point. Yes. That is that.
Let us see the trial court judgment.
Yes,
Mr.
can look at this.
Let us come to the decision with reasons, page 5.
Look to this. Well, can you look to turn to page 5 of the trial court judgment?
5 you have seen.
Considering the argument put forward by the advocates of both parties, I find it is stated by both the parties that with respect to the suit premises, one tenancy agreement was prepared and entered into by and between the defendant and father of the plaintiff on 13/12/2004. From the certified copy of the evidence entitled suit 100 of 2008, marked Exhibit A series, I find the father of the plaintiff has filed one suit, title suit number 100 of 2008, wherein the agreement dated 13/12/2004 was prayed to be declared as cancelled. From Exhibit B, however, I find the suit being title suit was dismissed for non-prosecution. Now, again, the defendant has denied the existence of any tenancy agreement dated 19 May 2007. In this regard, from Exhibit A series, particularly Exhibit A1, A3, it appears the agreement dated 19 May 2007 was without signature of the present defendant.
So it was held that you are an existing tenant. Ultimately held at the end of that paragraph that you are an existing
tenant. Under whom? Or under whom?
So it has been transferred in his favor.
Yes.
He has produced the transfer documents.
But neither from the next line, neither from the side of the defendant nor from the side of the plaintiffs, any original copy of the stated tenancy agreement dated 19th May 2000 has been produced before me, wherefrom the extent of tenancy and the status of the defendant can be established in this present suit. Although I find from the Exhibit C series, DW2 Superintendent Access was summoned to the produced original agreement between the parties, on the basis of which defendant claims to have obtained license in liquor business, but the same has not been produced in this suit. But at the same time, I find from the cross-examination of DW1 dated 1st April 2007, defendant has admitted to have entered a tenant in the suit property on 19 May 2007, and have also admitted to have started liquor shop in the shop after getting license from the government in the month of May 2007. Therefore, in the absence of any documentary evidence agreement, the oral admission of the defendant himself substantiates.
At the end of that page, Mr. Lokit, it has been held that your evidence has been considered. Court has held that present plaintiffs are in existing ownership and possession of 3 shatak comprising of those 3 pakka rooms, and has granted eviction decree.
Although the defendant...
The questions of fact at best, Mr. Lokit. There is no substantial question of law involved here. It will be a reappreciation of this evidence.
Yes, but
Mr. Lokit, there is no substantial question of law involved. We will hold that. The present second appeal has been preferred against the judgment of affirmance, thereby granting a decree of eviction against the appellant on the uh, uh, under the under section 106 of the Transfer Property Act. Which of next para, learned counsel appearing for the appellant seeks to argue that the ownership of the plaintiffs in respect of the suit premises have not been established properly. However, we find from the concurrent findings of the courts below that upon considering the elaborate evidence of the parties, including the evidence and cross-examination of DW1, the defendant himself, as well as the original gift deed marked as Exhibit 8 and the LR Porchas marked as Exhibit 1 series, and also the plot information slips issued in the year 2014 and marked as Exhibit 2, the courts below came to the conclusion that the plaintiffs are in existing ownership and possession of the 3 shatak of suit property under plot number 296, which comprises of 3 pakka rooms, and accordingly granted eviction against the appellant. Next para, we find that the questions sought to be raised is at best a question of fact, and as such, no substantial question of law is involved in the matter. Hence, SAT 46 of 2023 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2023 is also dismissed without an order as to cost. Sorry. We'll come back in 5 minutes for the next one. None appears for the parties, adjourn for the day. ডিপার্টমেন্টে কত পর্যন্ত আছে? হ্যাঁ, এগুলো তো এমনি তার মানে মেনশনিং স্লিপ আছে একটাতে, এগুলো দেখে নিন না, পরেরটাতে মেনশনিং স্লিপ আছে, তাহলে তো ডিপার্টমেন্টই হবে। ঠিক আছে, আপনি ডেকে যান। সেম, না না ঠিক আছে। সেম, সেম অর্ডার। Yes, same.
Well, in
Yes,
this
Mr.
matter, I am for the appellate.
Right.
Well, dependent oblique respondent number one expired. Upon instruction of my client, the appellant, I have submitted before your lordship. I have to take appropriate steps before.
Appellant number one.
Yeah, dependent number one oblique respondent.
Oh, respondent. The counsel for the appellant submits that the respondent number one has expired during pendency of the appeal and seeks some time to take appropriate steps accordingly. Full stop. Accordingly, let the appeal stand adjourned and be listed next in the monthly list of July 2025. Full stop. The appellant shall take steps in the meantime in that regard and shall be at liberty to mention the application for substitution as and when filed to be listed along with the appeal. Please file that application and mention it.
I have to file in the Lojima court.
We'll take it up, allow it, and direct you to serve copy. And why delay matters unnecessarily? If it is not within time, then it has to come to the court in any event. Yes, next. None appears for the parties, adjourn for the day. Right. Same. Same. দেখি একবার অ্যাপিলটা, আউট অফ টাইম বলছে। এগুলো তো সব আগে কল হয়েছে। আচ্ছা, এবার এগুলো দেখাবেন। বারবার টাইম নিয়ে গেছে, প্রথমে টাইম নিল সেকশন 5 করার জন্য। ক্যান টুটা কি? ক্যান টুটা কি? হ্যাঁ, কন্ডোনেশন অ্যাপ্লিকেশন ফাইল করেছি। We find from the previous orders that the appellant had sought time on May 13, 2025 to file a supplementary affidavit in connection with Can 2 of 2025, an application for condonation of delay in preferring the appeal. Full stop. Even on May 21, 2025, when the matter was next called on for hearing, none appeared for the appellant at the time of call. Full stop. Next para. This is the third occasion when the appellant remains unrepresented and stroke or seeks adjournment. Full stop. Next para as a last chance to the appellant to move the matter, the same is adjourned for the day. এটা একটু লাস্ট চান্স করে রাখবেন, পরের দিন যদি না থাকে ডিসমিসল ডিফল্ট করে দেবো, একটু মনে করে যাবেন। None appears for the parties at the time of call, adjourn for the day. এগুলো সব কালকে পয়েন্ট আউট করে দেবেন, কেউ আসছেন। টাইম চাইবার যদি সময় না থাকে তাহলে ডিসমিসল ডিফল্ট করুন। সেম।
I am happy for the in this matter, Mr. Savitri was appealing for the respondent. It is on his way. Possible can short possible.
No, we'll start.
Short possible.
No, Yes, what is the matter?
On the last time, my lord, appellant took time, my lord.
So what?
Not possible, my lord, I'm saying.
You are there. You are there. Yes, Mr. Rai, what is the matter?
There is the order of remand.
Remand
Yes.
should be admitted as a matter of course. What is your ground, Mr. Rai? Is
The order
there any substantial challenge to any finding?
So, yeah, without deciding one thing, whether the suit for declaration that the degree is void, when specifically from the plaintiff itself, it appears that he came to know about the degree in the year 2004. Suit was filed.
The defendant.
And the defendant there.
Suit for specific performance.
Suit for declaration that degree is void.
Yes.
On the such findings, the suit was filed.
The decree of?
Previously, a suit was filed by the plaintiff.
What?
For declaration of title and injunction. Such suit was decreed ex parte.
Decreed.
Decreed ex parte.
Their suit was decreed ex.
Our suit.
Your suit.
Subsequently, they came to know in a proceedings that suit was decreed, though he was not a party. According to us, he was a party. Be as it may, I am not of that. 2004 specifically mentioned that yes, I came to know about the degree on such and such date. Suit was filed after 3 years. Whether that is maintainable or not, and whether the order.
How do you attribute their knowledge before?
Yes, why not kindly turn to the plaintiff itself? Can you take up my application?
Fraud vitiates all.
Yes.
But what is the challenge on fraud? I mean, how was it fraudulent according?
It is their case that they are not in a position to know anything about the proceedings. Degree was passed. So if the degree was passed, so whether the degree can be challenged in a separate suit, that to a declaration after came to know about the date of the passing of the degree.
Count of challenge, let us see.
Yes, my lord. Can you turn to page 8, the plaintiff itself. At the top, your lordship will find the order filed on 30th November 2007. Page 8 at the top right hand corner. Filed on, my lord, got it?
Yes. Yes.
Now, my lord, can you turn to paragraph 16. Which is the subject matter of challenge in the present suit.
He was a party but was expunged.
Subsequently expunged because the company was not in existence. That was it. Now, can you turn to paragraph 19?
Yes.
Now, my lord, can you only consider the prayer. Page 24.
Why do they say it's a nullity?
According to them, that I have no right at it, just and I falsely implicated some.
No, they say the compromise was fraudulent.
Compromise was fraudulent. If the compromise is fraudulent, my lord, then what will be the effect of that same, my lord? If a suit for declaration, presuppose a suit for declaration.
But there are several judgments that
fraud witness everything from the detection of fraud.
Yes.
So detection of fraud was on, my lord.
In 2004.
2004.
June, not June.
It was on, my lord.
15th April. Yes.
15th April 2004. Now, my lord, can you consider?
So what happened? The suit was?
Suit was dismissed. I filed an application on the ground of integrity that the person who have filed the suit, the company has not in existence, and on the basis of which the court dismissed the suit. Held that this is not
exist. It had gone in liquidation.
Gone in liquidation. Subsequently, my lord,
name was struck off from the records of the Register of Companies.
Now, my lord, an appeal was preferred.
All right.
The appellate court, considering an order passed by this honorable court in company petition, held that they have leave was granted to file the suit. Whether this order presupposely granted leave to the plaintiff to file the suit.
It was a company liquidation. It was a liquidation.
Yes.
Process.
Yes, 39.
So leave itself may not entitle them to file a suit.
That is
there not
the ground. That is in the appellate court judgment. I'll clarify your lordship. That is the ground. Kindly turn to page 37 once.
37.
Yes, page 37.
Yes, 37.
From the order of the Honorable High Court, Calcutta dated 5/10/2007, in connection with.
What is this? This is the appeal.
No,
151.
this is the trial court judgment which I referred to.
The trial court judgment in the present appeal.
In the present.
Yes.
In connection with the CA number such and such, it will appear that the defendant of this suit has challenged the authority of the Pannalal Bagh before the Honorable High Court. However, Honorable High Court Calcutta opined that there is no basis shown to challenge the Pannalal Bagh's authority. Pannalal Bagh's authority can no longer be questioned in view of the order dated 1960, which was made at his behest and upon the court accepting the statute. Furthermore, from the order dated, it appears the Honorable High Court Calcutta allowed the application of the Honorable High Court preferred by the plaintiff company against the register of
That
companies.
striking out was restored. That
Striking out restored.
Then it revived.
It is revived. Now, my lord, kindly consider whether
The appellate court found that it has revived, so
Revived.
therefore consider the suit on merits.
no, that is the problem. The court does not say what this Honorable Court held. Kindly consider that in a company petition. Kindly turn to the memo of appeal, my lord, internal page 6 of the appeals court. Memo of appeal. Internal page 6,
Yes,
last paragraph. 13, my lord, got it?
got it.
In CA number such and such, the Honorable High Court doubted the ownership of the properties. And this is why the Honorable Justice such and such, my lord, page 3 and 4 of the order was pleased to observe that it will open for Bagh or the company to assail the rights of Mollik. Mollik is the present appellant before your lordship, who is the defendant in the suit. If the company is indeed the owner of the land, which is now occupied by Mollik, this order should not in any manner be interpreted to prejudice the rights of Mollik, which he claims to enjoy under the degree of the court. The rights of the company, Mollik's right to possession and title in respect of the movable properties at or about the company's factory will have to be determined in appropriate proceedings that may be instituted by them. Observe that it will open for the company to seek the benefit of the appropriate provisions of the Limitation Act for the purpose of maintaining the suit and other proceedings in respect of the dispute relating to the land with Mollik. Whether this presupposes a premium given for the purpose of enlargement of the limitation for filing of the suit or not.
Why not? The matter was pending. In the interregnum, the company was not in, it was struck out.
No, not interregnum. The suit was filed by a company. We appeared and said that this company has no existence in the eye of law because its name was struck out from the.
It was bad at the inception, you were saying.
Then the suit was
During
dismissed.
pendency, after the dismissal of the suit, it was revived.
Yes. During the.
So if they could today file another suit,
then
why not remand it and let that suit be
Then,
heard
my
again?
lord, whether the cause of action, now, my lord, the limitation. That is why, my lord, I presupposes. Whether this amounts to
Company, even if it wanted, could not have filed an appeal, could not have filed the suit before. Because as rightly your point was upheld by the trial court that the company was not in existence.
So, therefore, so 2004 they came to know about this.
That should be considered by the title by the first court of first instance. Why should the remand order be?
Because on the ground of maintainability, the other parts also order 40
Every
rule
question remains open.
order 40 rule 23A. It is not an open remand. It should be open remand because on the ground of maintainability it was.
Impugn order number 71 dated.
Yes, because on the ground of maintainability that was struck. So plaint was rejected.
It was a rejection of plaint.
But it cannot be also. Because on the basis of our application, the plaint was rejected, then how it can be under order rule 11? It should be under order 14 rule 2 at best. There is some.
No, Mr. I will not admit this appeal. At this stage, let it be cut off at this stage.
One thing,
Have a say.
So the maintainability and the should be kept open. So the
all questions have been kept open. Plaint rejection has been set aside. What does that mean?
No, plaint rejection on the ground that which was there, while the court is of the opinion And the justice, this honorable
Put in
court,
an observation that it is quite obvious. Whatever is obvious and need not be mentioned, we mention in order.
for,
Do that here also, that the merits
for
of the,
my satisfaction.
the present appeal has been preferred against yes, against a judgment and order of remand. Full stop. The trial court sustained the objection as to maintainability of the suit on the ground that the plaintiff stroke respondent company apostrophe S name had been struck off from the records of the register of companies at the relevant juncture when the suit was filed. Full stop. Subsequently, on an appeal preferred against the said decree, comma, the learned appellate judge, first appellate judge, comma, by relying on an order of this court passed in company jurisdiction, comma, took notice of the fact that the company had since been revived by cancellation of the order of striking off the name of the company from the records of the ROC, and it was further observed by this court that it would be open for the company to assail the rights of the present appellant if the company is indeed the owner of the land. So it was further observed by the learned single judge sitting in company jurisdiction that it will be open for the company to seek the benefit of the appropriate provisions of the Limitation Act for the purpose of maintaining the suit and other proceedings in respect of the disputes relating to the land with Malli. For next para, learned counsel for the appellant argues that since the suit was not maintainable at the inception, comma, the learned appellate judge ought to have affirmed the findings of the learned trial judge. So it is further argued that merely on the premise of an observation made by the company court, comma, the appellate court ought not to have remanded the matter without taking into consideration the fact as to whether the suit was by now barred by limitation. Next para, however, comma, upon a perusal of the judgments of the courts below and the relevant materials annexed with the connected stay application, comma, we find that the learned trial judge committed no error either of law or of fact in remanding the suit by setting aside the order whereby it was held to be not maintainable, by taking into consideration the fact that the name of the company had since been restored in the register of companies, and taking into account the order of the company court in that regard. Next para, the apprehension of the appellant to the extent that the appellate court has decided certain issues is entirely misplaced, as is evident from the face of the impugned judgment. Next para, hence, comma, it is obvious that all questions taken by both sides shall be have been kept open for being decided on merits by the learned trial judge, comma, including the maintainability of the suit as well as the questions of limitation. Next para, hence, comma, we do not find any reason to entertain the present appeal or to admit the same. Accordingly, FMAT 332 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure in the light of the above observations. Consequentially, Can 1 of 2024 stands dismissed as well. No arrest to cost.
Great.
Thank you.
For the appellant, we should also kindly take it up tomorrow.
Mr. Mahato, on the last occasion also you had asked for time before vacation. Mr. Roy was there. Anyway, on the prayer of the appellant, the matter is adjourned for the day. Appellants, sorry. Yes, Mr. Bhattacharya. Good matter, bad matter, or indifferent matter? Indifferent.
Both the courts, my lord, dismiss the suit. Thereafter, appeal also dismiss. Here,
your suit, obviously.
Yes,
suit is for? Was for?
The first suit was declaration, suit for declaration of title and, my lord, injunction. Second suit At the time after my lord filing the registerment, my client his father has already transferred the said suit property in favor of these cousin brothers. Now,
Kaji brothers.
actually, my lord, property, my lord.
Your suit for declaration of your title and permanent injunction. So then
that should be withdrawn, because after filing the written statement, my lord, that written statement, my lord, defendant disclosed that the father of the plaintiff transferred the land in favor of the defendants.
So you withdrew the suit.
Withdrew the suit without giving liberty to file a suit.
Then you filed another suit.
Another suit. That suit is different from the first suit.
How is it different?
Different is a declaration of title by way of that he acquired the title and interest by way of adverse possession, because after the deed which was made by his father predecessor, that was not acted upon. Even in the record of rights, RS, civil CS, RS এবং LR record of rights in favor of the plaintiffs. So record of rights does not create any title, but my lord, record of rights is the best evidence of possession. That has not been considered.
How can you take a contrary stand? You pleaded title in the previous suit, which was withdrawn by you.
But my lord, that suit, my lord, depended first time.
You say the basis of the suit was different.
Different only, my lord, that the plaintiff acquired the title interest by way of adverse possession. Adverse possession has not been considered by both the courts.
Adverse possession plea was not taken in the previous suit.
Previous suit, no. And my lord, adverse possession here, my lord, all properties, if the property, my lord, transferred in favor of the defendants, but that has not been possession possession was not delivered in favor of the defendant, and for that reason, my lord, there are 3 and 4 times, my lord, record of rights notice was issued, but that revision settlement as well as the, my lord, error record and attestation says the plaintiff's name are in all along in the record of rights. Number 2, my lord, other, my lord.
But your adverse possession claim corresponds with the period when you had filed the previous suit.
Yes.
The period during which you had prayed that you had title by ownership, that period, your adverse possession period covers that period also. So you could have taken this point on in the previous suit also. So the language of Order 23 is Rule 1 is on the same subject matter. You cannot.
But my lord, when the, my lord, relief as cause of action are different from the second suit, from the first suit, that will not bar. Without considering the, my lord, without obtaining the leave from the court, it is not bar. Because, my lord, this is the practically adverse possession is, my lord, after first suit. Second suit new.
When was the first suit dismissed? Withdrawn?
Withdrawn, my lord, that is 490, first suit, title suit 43 of 77. That was withdrawn 28 November 78.
28th November 78.
70. And thereafter,
second suit filed when?
979.
Then your adverse possession goes into that previous suit period.
But till today, my lord, you can only consider. Till today, exhibit 2, 3 or 4. Till today. Even
suit
my lord
was pending. Till today, how can you consider the sub judice period? During pendency of a suit, can you have adverse possession?
That suit was withdrawn.
First suit was withdrawn on 78.
Yes, ma'am.
You sought for declaration of your title on the strength of what? Inheritance? Inheritance or deed? Inheritance. You failed there. You withdrew the suit because it has been transferred to somebody else.
Yes.
The very next year, you file another suit by claiming adverse possession.
Actually, he came to know from that 78.
That you are in adverse possession. You came to know from someone else.
From 79 to till that, my lord, your lordship is the suppose, my lord, if the land transferred in favor of the dependents, or the dependent have not taken any steps, even in the RS, even LR, even attestation stage, they did not take it. Till today, my lord, my name Manikal Banerjee as well as the Santiram Banerjee record was there. My lord, actually, even, my lord, you will also consider the 65 of the Limitation Act. If the after purchase, if the vendors are in possession, vendors legally has possession. Actually, they did not file any suit dependence.
Difficulty lies elsewhere, Mr. Bhattacharya, because your till 1978, till your previous suit was dismissed as withdrawn, you were claiming to have title in respect of the property. So till 1978, till dismissal of the previous suit, you could not have taken out a contrary claim that because adverse possession presupposes someone else, the defendant is the true owner. You are admitting that he is the true owner. Unless you admit the defendant to be the true owner, you cannot claim adverse possession. That's a cardinal principle of adverse possession. You admit the defendant is the true owner, and I am in adverse possession against that defendant. Till 1978, your plea was that you are the owner. Therefore, you could not have had adverse possession till say 1978.
My lord, ownership and my lord, title only here.
Different things.
In this
What is
case,
the difference
no, my
between
lord,
ownership and title?
my lord, in this case, because my lord, after my lord transferring land in favor of the predecessor or dependents, predecessor or dependent, they did
Till
not.
1978, you said that I am the owner, you are the owner. So how can there be open, continuous, and hostile possession against the defendant?
Only my lord, this my lord, my submission will be when the record of rights is the best revision of poison, and my lord, only.
You say 1979, 17?
Today, my lord, we are in possession.
No, in 1979 itself, you filed the second suit.
Yes, madam.
Why is it numbered 1995? It was renumbered.
It is renumbered, and that should title should 492 of 79. That was subsequently renumbered.
No, sorry.
Number one, number two, my lord, regarding
Number two. Your appeal is number 2. It's a number 2 appeal.
Number 2 appeal. But my lord, it is only my submission will be regarding my lord.
What?
After the sale, well, after transfer of the predecessor.
Sale had taken place
No.
already during pendency of the previous suit.
Well,
after sale, you are saying you could have had an adverse possession.
Recital, as per recitals of deed in the sale deed is not sufficient for
Till your suit for
sufficient for delivery of
till your suit for declaration of your ownership is dismissed. Till then, you are claiming that you are the owner of the property. Therefore, you could not have been in hostile possession. Let alone continuous, uninterpret those things. Open. You could not have been in hostile possession against the defendant. Because till 1978, till the withdrawal of your suit, you are claiming, your plaintiff said that you are the owner by virtue of whatever, not adverse possession. So before withdrawal, till the date of withdrawal of that suit, you are claiming possession hostile to the true owner. You did not admit him to be the true owner.
When his cross-examination stated, they did not deny that we are in possession. It is only admitted fact is this, that we came to know later on that.
No, possession is something else from adverse possession.
Yes.
What is the adversity in that possession till 1978?
Well, in this case, my lord, my submission they did not, my lord, actually after transferring a land, they did not possess, and as well as till today, we are in possession.
The present second appeal has been preferred against a judgment of affirmance. Full stop. The plaintiffs stroke appellants suit for declaration of title and consequential reliefs have been dismissed by both the courts below. Full stop. The premise of the claim of the plaintiff's appellants to the suit property is based on alleged adverse possession in respect of the same against the defendant stroke true owners. Full stop. Next para. Upon hearing learned counsel for the appellants, we find that a previous suit was instituted by the predecessor in interest of the present plaintiffs, into whose shoes the present plaintiffs stroke appellants have stepped in, claiming title to the claiming declaration of title to the property on the basis of their independent rights. Full stop. The said suit was dismissed as withdrawn on November 28, 1978, apparently since the predecessor in interest of the plaintiff stroke appellants found out from the pleadings in the written statement of the defendants therein that the title in respect of the property had been transferred by their predecessor to the defendants. For some next para, in the very next year, that is in 1979, the present suit, from which this appeal arises, was instituted by the plaintiff's appellants on the ground that they had been in adverse possession in respect of the property. Para learned counsel for the appellants seeks to impress upon us that the possession of the appellants was never denied, and the present suit has been filed on a different premise than the previous suit, comma, since the cause of action for the present suit is adverse possession, whereas the premise of the previous suit was declaration of their title by inheritance. Full stop. Next para, as such, comma, it is sought to be argued that the bar under Order 23 of the Code of Civil Procedure is not applicable, commas, even if no leave was granted to institute a suit on the self-same cause of action, while the previous suit was dismissed as withdrawn. For the next para, however, comma, we find no legal or factual error in the judgments of both the courts below, who have arrived at the concurrent findings disbelieving the plaintiff case. For sub next para, the very basis of the argument of the appellants is fallacious, comma, since it is presupposed in a claim for adverse possession that the claimant of such adverse possession admits that the defendant in the suit is the true owner of the property. Full stop. The cardinal premise of a claim of adverse possession is open, hostile, and continuous possession as against the true owner for a period. In the present case, comma, however, comma, till November 28, 1978, comma, when the previous suit of the plaintiff's appellants was dismissed as withdrawn, comma, the basis of the claim of the plaintiffs was that they had independent title in respect of the suit property and were the owners of the same. Full stop. Thus, comma, it could not be that in 1979, comma, that is the very next year, comma, when the current suit was filed, comma, the previous possession of the plaintiff's appellants for a period of over 12 years was automatically turned hostile, which would be in stark contradistinction with the previous claim of the plaintiffs. Full stop. Thus, comma, the bar under Order 23 of the Code of Civil Procedure is squarely applicable, comma, as the plaintiffs now seek to reopen the self-same subject matter by way of the current suit, which was rightly turned down by both the courts below. Full stop. Accordingly, we do not find any substantial question of law involved in the appeal, and accordingly, SAT 149 of 2020 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Can 1 of 2021 is accordingly dismissed as well. No arrest cost. Sorry. Next. Yes. None appears for the parties. देखिए आगे दिन. We find from the records that on repeated occasions, the appellants had either sought for adjournment or were absent. Full stop. As a last chance to the appellants to appear and argue the matter, the same is adjourned for the day. এটাই last chance কালকে মনে করে দাও.
Lordship, I'm praying for not today, Lordship.
Refused. Move the matter. What is the matter about? There's a delay of 135 days. You have preferred Section 5 has been...
challenging an order, injunction order passed by the 10th.
So Section 5 has to be allowed first. What is the reason for the delay?
Lordship, the delay, the main reason is, Lordship, they are not here, Lordship. And they were lame.
Not here means where?
Appellants, the appellants who are now the appellants, they used to reside in Bangalore, Lordship. And they are not aware of...
Where have you stated that in your application?
Lordship, para 3, they were working outside the state, Lordship.
They could have worked outside the state, but it was, I mean, they were contesting. Originally, they had appeared in the suit. This appeal is preferred against an injunction order.
Yes, Lordship. Because, Lordship, prior to that, Lord, same suit of land and order of injunction was passed.
Injunction order was passed against you.
Yes, Lordship.
When did you enter appearance in the suit? works outside the state, so you would not take any information regarding your suit. There's nothing in this section 5 application. Injunction order, 7 months have elapsed. This is ad interim, sorry, ad interim or temporary injunction. Let us see. Ad interim injunction. Go and contest in the court will. We do not find any.
Lordship, but the court, Lordship is not hearing the matter. It is keep on adjourning, Lordship. Either the presiding officer is not there, Lordship. They are not hearing the matter.
You must have taken time due to pendency of this appeal.
No, Lordship. The advocate is
Appearing.
appearing, Lordship.
Will reject the section 5 application. Will express the hope that the trial court. You have
Lordship,
filed your objection, written objection to the injunction.
yes, order 39 rule 4 is pending there, Lordship.
39.4. You also file a written objection. Will direct 39.4 and your injunction.
Lordship, to hear the matter as expeditious as possible.
Very
Lordship. That will do, Lordship.
This এটা হচ্ছে ক্যানটার উপর অর্ডারটা হবে, হ্যাঁ, can 1 of 2025. Next para, the present appeal has been preferred against an order of ad interim injunction, full stop. In paragraph number 3 of the application, comma, it has cursorily been mentioned that the appellant works outside the state of West Bengal. And as such could not prefer the appeal in time. Full stop. However, comma, we find that there are 2 appellants and no sufficient reason as to what prevented them from taking information about the litigation for a long period of 7 months has been furnished in the application. Full stop. Hence, comma, since it is well settled that the reasons furnished and not the period of delay is germane while considering an application for condonation of delay, comma, we find that the reasons furnished in the application are utterly insufficient to condone the delay. Full stop. Moreover, comma, since the appeal itself has been preferred against an ad interim order of injunction, comma, the delay of 7 months in preferring the appeal is also fatal to the interests of the appellants, comma, since it clearly shows that the appellants that the equitable considerations do not lean in favor of the appellants. Full stop. Accordingly, can 1 of 2025 is dismissed without an order as to cost. Full stop. Next para, consequentially, comma, FMAT 45 of 2025 is dismissed as time barred. Full stop. However, comma, since the main injunction application is pending in the court below, in the trial court, comma, we express the hope and trust that the learned trial judge shall dispose of the pending application for injunction along with the connected application under Order 39 Rule 4 of the Code of Civil Procedure filed by the appellants as expeditiously as possible, comma, preferably within 8 weeks from the date of communication of this order to the court below, subject to the appellants filing their written objection to the injunction application within a week from date, comma, if not already filed. No arrest to cost.
Lordship, I'm grateful.
Thank you very much.
Lordship, I'm grateful.
Next.
The 37, I appear on behalf of the appellant petitioner.
I'm to the respondent Eviction.
I'll serve, my lord.
Yes, what is it?
Judgment of affirmance, my lord. Suit for declaration and injunction, my lord. The plaintiff and
Nandi, you can take your seat here.
Yes.
The plaintiff and defendants are the 2 brothers.
You are the plaintiff or defendant?
I am the defendant. The plaintiff and defendant are 2 brothers, my lord.
Sorry, suit for?
Declaration and injunction, my lord.
2 brothers, yes.
2 brothers. The father of the plaintiff and defendant possessed a property. One is 13A Darik Ganguly Street and one is 11 Darik Ganguly, part of 11A, 11 Darik Ganguly Street. Now, by virtue of 2 separate deed of gift, he gifted the property to 2 brothers. But with regard to the first gift deed, which was accepted by the plaintiff, but with regard to the second gift deed, that was never accepted by the defendant, my lord.
No, 13A was given to the.
No, 2/3 of 13A was given to the plaintiff, and 1/3 of the 11 was given to the plaintiff.
and 2/3 of 11 was given to the defendant.
No, 2/3 of 13A was given to the plaintiff.
Plaintiff.
And 11?
And 1/3 of 11 was given to the plaintiff.
By two separate gift deeds.
By two separate gift deeds.
So he accepted both.
No. Kindly visualize, my lord. There are two gift deeds. One gift deed was given to the plaintiff, another was to the defendant.
Which one to the plaintiff and which one to the defendant?
Both of the same date. There are two properties, that is 13A Tariq Ganguly and 11. Part of the 13A, that is
2/3 of that was given to the plaintiff and 1/3 was given to you.
In one gift deed, 2/3 of Tariq Ganguly and 1/3 of 11 Tariq Ganguly was given to the plaintiff.
And the rest was given to you.
And another gift deed.
Obviously, another gift deed in your
was
favor.
given to me, that was never accepted by me.
That another gift deed was given in respect of the other portion of those two.
Yes.
It was not accepted by you.
No, never accepted by me.
So therefore, 122 is not complied with.
My lord. Now, my lord, the plaintiff wanted to create a partition wall in the premises.
These were undivided portions.
Yes. The gift deed specifically says 2/3 undivided and 1/3 undivided. Both gift deeds. He want to create a partition wall in between the premises and directed me to construct a water reservoir, stop my water connection. Thereafter filed a suit for declaration and injunction.
Declaration of his exclusive title.
Yes. Declaration of exclusive title and declaration allowing him to construct a partition wall in the premises.
He relied on some oral settlement between you?
No, there is no. The trial court as well as the appeal court have considered that since I am deciding a portion of the premises and since the property has been muted in the Kolkata Municipal Corporation records, it's a deemed acceptance.
So partition.
Yes, and
even without any partition by Mitchell.
And as stated that no partition is required. Declared
was that finding of the appellate court. Since it's of affirmance.
Just a minute.
No, appeal court says at page 5, well demarcated portions have been given. Plans and please come to page 5 of the appeal court.
May I rewrite the gift deed, my lord?
We will come to that. Please come to page 5 of the appeal court. Third paragraph.
The highly detailed schedule in the two deeds read in conjuncture and well marked plans annexed to the deeds leave no room about the doubt that donor had effectively disrupted not only the unity of the title but also the jointness and possession of the two by executing two separate.
Let us see the gift deeds. Let us see the plaintiff's gift deeds.
May I hand over?
No, you have not annexed to any connected application?
No, that is not there, my lord. If my lord,
that is the only document. It has to be a part of the paper book also. If you admit it.
I have the. May I hand it to here and now also, my lord?
Hand over. But give a copy to me, sir, when only also then. How can you know what you are handing over? This is in favor of the plaintiff?
Yes. अच्छा the schedule portion, if my lord sees, only that portion is stated about the map with a color, but in the body of the gift deed there is no specification. It specifically states 2/3 undivided, 1/3 undivided.
Undivided till then, but by virtue of this gift deed, demarcation is given.
In the body of the
Because when the gift deed was executed, it was undivided one third. But let us see the body of the gift deed. Yes. Please come to page 8, internal page 8 of the gift deed. Donee shall, upon execution of these presents, shall be deemed to be the rightful owners to the extent and demarcation which is more fully described in the schedule and delineated in colors to the plan annexed to the deed, and the donee shall be deemed to be the absolute owners to the exclusion of all heirs.
But that was in regard to one gift deed, which I have not challenged it. With regard to another deed, I have not even accepted that also.
Your deed, forget your deed. A demarcated portion has been given to them. You are excluded from that portion. Your gift deed, forget it.
But that portion has not been even partitioned.
If you have not accepted the other portion, that remains joint, Mr. Bhattacharya. You fail to understand this. The portion which was exclusively given to them goes to them. Your deed you did not accept. So that portion remains joint. Just wait for the partition suit, next partition suit by them. Or you can also file a partition. And courts have construed. We find at least two clear indicators in the gift deed itself. The map and this body.
But that was
so much on the body, we were on the body also.
But body says a 2/3 undivided share, that is, and 1/3 undivided share. But that portion has to be partitioned because that entire schedule, the
owner can sell transfer demarcated portion. If I am the owner of the entire property, then I can demarcate a portion. And
there is no.
Yes. Mr. Basu wants to add something. You cannot add to the color of the map.
We are not.
Green and red are very clear. And it was, the colors were also very indicative. Anyway, no interference because an interpretation has been given to these gift deeds by both the courts.
If my can you give another name?
No, why? The present second appeal has been preferred against a judgment of affirmance, whereby the exclusive title of the defendants in respect of the suit property has been declared and consequential relief has been granted. The learned advocate appearing for the appellant submits that both the courts below misconstrued the tenor and purport of the gift deeds executed in favor of the defendant, on the basis of which the defendant claims title to the suit property, full stop. It is submitted that the gift deeds themselves indicate that undivided shares in the property were given in favor of the defendant, and as such, the exclusive title of the defendant in respect of the subject matter of the deeds could not have been declared by the courts below. Full stop, next para. The learned advocate for the appellant also hands over copies of the gift deed executed in favor of the plaintiff stroke respondent. Full stop, next para. শঙ্খ ডিফেন্ডেন্ট রেসপন্ডেন্টের বোধহয় গুলিয়েছি কোথাও একটা মাঝখানে, তুমি একটু আমাকে ডিফেন্ডেন্ট রেসপন্ডেন্ট গুলো মার্ক করে দিও, বোল্ড করে দিও তো উপর থেকে। হ্যাঁ, কারণ এখানে আমি তোমাকে বলে রাখছি প্লেন্টিফ হচ্ছে রেসপন্ডেন্ট, যদি কোথাও উল্টো মনে হয় তাহলে তুমি চেঞ্জ করে দিও। From the gift deed, we find that in the body thereof, it has been categorically mentioned that the donee shall, upon execution of the gift deed, shall be deemed to be the rightful owner of the property to the italic say extent and demarcation, italic say, which is more fully described in the schedule and italic say delineated in colors in the plan annexed to the deed, italic says, and that the donee within bracket plaintiff stroke respondent bracket close shall be deemed to be the absolute owner to the exclusion of all heirs of the donor, and to have and hold the same for the use and benefit or for his successors in interest to the exclusion of all other persons. Full stop, next para. Also, in the plan annexed to the deed, the demarcated portion of the plaintiff stroke respondent is indicated by use of different colors. Full stop. Thus, comma, the learned courts below rightly came to the conclusion that by virtue of the gift deed in favor of the plaintiff stroke respondent, comma, specifically demarcated portions out of the till then undivided property was donated in favor of the plaintiff by the original owner, comma, the predecessor interest of the parties. Full stop. Next para. We must mention here that although the expression double inverted undivided has been used in the respective schedules of the two properties which were donated by the gift deed, comma, it, comma, read in conjunction with the rest of the gift deed, comma, clearly shows that the donor only meant that till then the property was undivided. Full stop. However, comma, by virtue of execution of the deed and in respect of and in view of the clear words of the same, comma, adjuncted by a specifically demarcated plan, comma, such expression has been qualified to show that the ownership, comma, till then undivided, comma, was severed and demarcated specific portions were donated in favor of the plaintiff stroke respondent. Full stop. Next para. Thus, comma, we do not find any illegality in the judgments and decrees of the courts below in declaring the exclusive title of the plaintiff and passing consequential relief in respect of the suit property. Full stop. Thus, comma, no substantial question of law is involved. Accordingly, SAT SA 63 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed. No arrest to cause. Sorry. Thank you. We are keeping on record this because we have relied on this.
Lordship, I'm for the appeal and Lordship, kindly 2 p.m. taken. আমি just post of Saturday will place the appeal.
2 p.m. Very well at 2 p.m. ডাকবেন তো?
Faithful Lordships.
2 p.m. Pass over.
Affidavit of service. My lord, I am filing my affidavit of service.
No, I'm for the response.
My lord, it is against an affirmance judgment, my lord, that we have come up. Only point involved is that even if our defense under 7.3 has been struck off, whether we are entitled to cross-examine the plaintiff and have our degree forwarded. That is the only question remains in the matter.
How did the court proceed without
They
giving you
did
any
not. Even in spite of that we filed an application, provide us with the affidavit, we have the right to cross-examination, stating, my lord, Modular India, which we have also annexed here. My lord, that was not been allowed. That is why only question which remains in the appeal. Nothing else. Our conduct is also not, my lord, good, I would say, but that is a point of law, my lord, which is open to us, and there is no stop and to. And Modular India, my lord, I have also annexed here, my lord. We have given.
Let us just check up the appellate court, sir.
My lord. Is on the point of point of limitations. Question is, this is a second appeal. There is only the point of law involved.
So not only for the 7.3, your conduct is deplorable. It is recorded by the appellate court that several dates were given.
But the question is, but in that conduct also, we made an application that provide us with a copy. That is also our conduct. We have annexed that application.
No,
now
no.
that is it.
The court records that you had, it was fixed for expertise on the expertise board since 18th of November 2017. When was the defense struck out?
My lord, the defense was struck off, my lord, Once, and fixing of accordingly, there was not much.
2015.
Then CO
So long after the defense was struck out, it was in. So you had got an opportunity for 2 years.
Milord, but they did not provide us with the affidavit.
CO
We filed
dismissed?
an application. With that application
No,
has
we
been read.
go by the 7.3 being allowed. So CO dismiss is immediate.
CO dismissed.
Milord, we have filed an application that is on page 31 that provide us with a copy of
When did
the
you file that application? Let us see.
Milord, that is with the stay petition, Milord, page 31.
No, when did you file that application? That is my
When
question.
it is filed. When it is filed. When it is filed.
2019.
Huh?
Let us nothing indicated in this.
Milord, no, when this 151 was filed.
Yes, very important.
19-1, 2019. Milord, as per
2019.
the instruction goes.
2019, then it's
Milord, but Milord, the court did
from
not.
2017. It was on the expert board already on a different footing than 7.3.
Milord, but Milord,
You got that chance for 2 years.
Milord, in the meantime, Milord, we filed and we asked for it as per the trial. Milord knows in the trial court we ask for it. We do it is not being there. Then we file an application.
You
stating
filed the
that-
application only in 2019.
Milord,
2 years after the suit was
Milord,
already
they
on
were
the expert
supposed
board.
to give us under the law. They were supposed to provide us with the affidavit because we are entitled to cross examination and.
No, there was no question of that because in 2017 itself, 2 years after the 7.3 defense was struck off, the suit was fixed on the expert board. What were you doing till then? You had not filed any application for affidavit. You had not even mentioned that you don't have any affidavit, or you did not take this point.
Yes,
you took
Milord,
this.
we
You
filed.
grew wiser after 2 years from the suit being fixed for expertise.
Here, Milord will consider that there was a change of the advocate. We have stated the earlier advocate did not take any proper steps.
That is
So
neither
there,
here nor
then,
there.
Milord, the change was there, and instantly upon the change being
This was on a different
you know,
footing. Unlike
came
what
up and make on this.
contrary to what you are trying to
earlier
impress upon us, it
Milord.
was not fixed for expertise hearing on only for the 7.3.
Yes, Milord. But Milord will consider that then only after the change, immediately the new lawyer came up and filed.
New
this
lawyer, we are not interested in new lawyer, old lawyer.
Milord, old
New
lawyer
judge
did
or
not take
old
up-
judge.
Milord, the litigant is suffering because of the lawyer. He did not take these steps. He should have been.
Sorry, we cannot admit this. The present appeal has been preferred against the judgment of affirmance, whereby the defense of the defendant stroke appellant in a suit for eviction was struck off under Section 7 within bracket 3 of the West Bengal Premises Tenancy Act 1997. For sub next para, learned counsel for the appellant submits that despite the defense being struck out under Section 7 within bracket 3, the defendant is very much entitled to cross-examine the witnesses of the plaintiff and to point out the lacunae in the plaint case and advance arguments in respect of the suit. However, in view of the defense being struck out, in the present case, the learned trial judge did not grant any opportunity to the defendant stroke appellant to so cross-examine and or advance its arguments and fixed the suit on the ex parte board. Full stop. Next para. However, contrary to the arguments of learned counsel for the appellant, we find from the impugned judgment of the appellate court that the suit was fixed on the ex parte board by the learned trial judge since November 18, 2017. Full stop. On query of the court, learned counsel for the appellant submits that the defense was struck out under Section 7 within bracket 3 as long back as in the year 2015. Full stop. Although an application was filed by the defendant stroke appellant under Section 151 of the Code of Civil Procedure, seeking copy of the examination in chief of the plaintiff on the allegation that in the absence of such examination in chief, no cross-examination could be conducted, the said application was filed only on January 19, 2019. Full stop. Thus, the timelines indicate that the defendant stroke appellant got ample opportunity for over 2 years from the defense being struck out under Section 7 within bracket 3 in the year 2015 till November 18, 2017, before the suit was fixed for ex parte hearing. Full stop. Hence, comma, the fixing of the suit for ex parte hearing in the present case is only due to the conduct and repeated adjournment sought by the defendant and not connected with the striking out of the defense under section 7 within bracket 3 of the 1997 Act, which the defendant appellant is seeking to mix up. Full stop. Next para. The defendant grew wiser, comma, again 2 years after the suit being fixed on the ex parte board and filed an application in January 2019, comma, to to strengthen its alibi for non-appearance in the suit and or seeking adjournments, comma, by seeking purportedly a copy of the examination in chief in order to prove to the court that it was the non-availability of such examination in chief which deterred the defendant from appearing in the suit previously and or contesting the same. Full stop. However, comma, if the defendant was so eager to contest the suit, comma, it should have done so between the defense being struck out under section 7 within bracket 3 and the suit being fixed on the ex parte board in November 2017. Full stop. Having not done so and the suit being fixed on the ex parte board merely due to the dilatory tactics adopted by the defendant appellant, comma, unconnected with the striking out of the defense, comma, we are unable to accede to the arguments of the appellant in that regard. Full stop. Hence, comma, we do not find any question of law, comma, let alone substantial, comma, involved in the present appeal. Accordingly, SAT 91 of 2025 is dismissed under order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 stands dismissed as well. No address to cost.
Grateful.
Sorry, you argued well, but
Lord,
Thrice
you can
ex
only
parte.
try. Lord, there is
Thrice
no
ex parte.
level
thing
best.
that,
That was the only point.
that was the only point left, my lord.
Grateful.
Appellate, my lord.
You are appearing? Yes.
Yes, my lord. I am for the appellant, defendant, suit for confirmation, my lord. Suit decreed and appeal was dismissed. In a very short form, my lord, our grievance in the written
Suit was for what?
suit for recovery of khas possession and cancellation of license. Cancellation of license and suit for recovery of possession. And but the suit was valued at rupees 99 only, my lord. Though they have paid for recovery of possession, but the suit was valued at rupees 99. But after it, my lord, in our written statement, we took two pleas that the property on which we are residing and they are trying to oust us, that is a walk-up property. That is a walk-up property, and when the property belongs to the walk-up board, the civil court has no jurisdiction to try out. As per section 85 of walk-up act, my lord, it's barred. It's
Right.
barred, my lord.
Yes.
First submission, my first submission is this, and next one is this, my lord. We have tried our level best to prove it that it's a walk-up property by filing one certified copy of the deed, which shows that it's a walk-up property. That said deed shows that it's a walk-up property. But unfortunately, at the time being when we deposed our deposition as DW1, we failed to establish, we failed to produce the certified copy of the original deed of walk-up deed. And so we filed a Xerox copy.
Walk-up was created by the plaintiff's predecessor.
Yes, plaintiff's predecessor, and plaintiff's predecessor is my uncle. Is a matter suit between cousin brothers. Suit between cousin brothers. And our submission is this before the learned
Their
trial.
father had created the walk-up.
One of our uncle created it, and he is also the uncle of the plaintiff. Plaintiff, though it's in the name of the plaintiff's father, but originally property belongs to our uncle, and that person was the uncle of the plaintiffs also. And so it's a Benami property. As per our submission in the written statement, it's a Benami property, belongs to the in the name of the petitioner's plaintiff's father. And my lord, in the first appeal court, we tried our level best to file one application.
You said it's a Benami property in the name of the plaintiff's father.
Yes, my lord.
But walk-up was created by the uncle, not by the father.
Uncle
had no right to create the walk-up because you say it's the property of the father of the plaintiff.
But another thing is this, my lord. But in the walk-up property, my lord, in the walk-up property, the Maulavi was the father of the plaintiff. He has signed that and admitted that
he was the Mutwali.
Mutwali. He was the Mutwali, my lord. And I have that said deed with me, my lord.
No. With you won't do. So what happened? Why did you lose in the courts below?
First, we have we failed to establish that it's a walk-up property, and second, my lord, we failed to when at the first appeal court, my lord, at first appeal court senior division,
trial court held that Benami you failed to prove.
Yes.
Because passage of consideration was not proved.
Yes,
by you. And regarding walk-up, what was how was it dealt with?
No, my lord, the trial court did not consider it. That is
yes, considered internal page 8 of the trial court.
They have not considered it, my lord.
Come to internal page 8.
Yes, my lord.
Walk-up estate and all. Even all to contrary, they declared as property of state, walk-up estate. And actually, it's true that the pleas are contradictory to each other. Yes. It's a walk-off property. How can it be his father's property?
Yes, my lord.
So your defense was disbelieved on that ground. And what was the proof regarding walk-off? You did not produce the original document.
At the timing of first appeal court, my lord, we filed on one application under Order 41 Rule 27. No, even certified copy. Order 41 Rule 27.
How was it dealt with?
And it was also not been considered, my lord. We have filed a said application with our stay application, my lord. Kindly see the stay application, my lord. Page. It was not at the timing of.
It does not contain any affidavit or notary or anything of that sort. This is just a copy, plain copy. How do you know it was filed?
It was filed by and it was rejected.
The affidavit page was not affirmed even.
It was rejected.
What rejected?
Affidavit. It's affidavit.
Where is the rejection order? If it was rejected, then you must have challenged that order also.
Yes, my lord, we have challenged it here.
Rejected in the final judgment of the appellate
Final
court.
judgment. Final judgment.
Where
of
is
the
it dealt
First
with?
appellate court.
Let
My
us see that.
kindly see, my lord, page internal para 14.
14, yes.
Para 14. Order 41, Rule 27.
You failed to satisfy AA. That
Yes,
is the
my lord.
finding.
Yes, my lord.
Why you are not be able to produce it?
Yes, my lord. But at that time, my lord, when the trial court held that judgment decree, it was not in the certified copy was not with us, and we
Not with you means you did not apply.
We applied, my lord. We applied, but it was not at that time with us. Thus, we filed the
You have
Xerox
applied
copy.
before.
And after it, my lord, in the appeal court, we filed the certified copy of it. And we filed the Order 41, Rule 27 application for additional evidence, but it was also rejected. Those two, my lord.
Court says that defendant had ample opportunity to bring in the deed to prove the property, additional evidence, and elaborately dealt with order for
No, my lord, those are as per our submission, my lord, is not.
You could have obtained the certified copy during the trial.
We failed, my lord. We failed. We filed the Xerox copy, but after it we collect it.
There is
After
a
it we collect
substantial-
it and we filed it before the
That's true,
first
but there is a
appellate court. my lord.
substantial question of law involved here.
Yes, my
Appeal
lord.
court rejected on consideration of the factual circumstances.
We have two grievances over this matter, my lord, from the very beginning.
Benami
in
and
our
Waqf.
WS, first one is Waqf, and second one at
Benami-
appeal court, my lord, the order 41/27 rejection. We tried our level best to file by application. We filed, and it was dealt with but not considered. And my lord, the grounds, my lord, we took here at second appeal in this high court, my lord, in the memo of appeal, my lord. Those are our main grievances, my lord. Everywhere we try to our level
Order
best.
for Rule 27. Let us see what is the explanation you have given.
Yes, my lord. Kindly see, my lord.
Let's see that.
কত আছে মেমোতে নেই মেমোতেও আছে
No, you have annexed to the.
আচ্ছা page 11 my lord of the CAN application.
একটাই শুধু জিনিস দেখেন, যদি ওয়াকফ প্রপার্টি সত্যি হয় তাহলে তো এটা মানে অর্ডার ফর 27 বি তে তাহলে কনসিডার করা উচিত ছিল, কারণ ইট ওয়াজ নেসেসারি টু ডিসাইড দি অ্যাপিল কনক্লুসিভলি। ওই গ্রাউন্ডে তাহলে অ্যাডমিট করেছে যে ওয়াকফ সত্যি ওটা will admit the appeal. The present second appeal will be heard on the following substantial question of law: whether the learned judge of the first appellate court failed to take into consideration the impact of clause small b within bracket of subrule 1 within bracket of order 41 rule 27 of the Code of Civil Procedure in refusing to permit the production of the certified copy of a deed indicating that the suit property is apparently a Waqf property, comma, which hits at the very root of the jurisdiction of the civil court to adjudicate the matter. On this ground, Benami, you are not convinced because it is a concurrent finding of fact.
Another thing is this, my lord.
Yes.
That as in our WS we took that plea that suit is barred by parties also, non-joinder of parties also, non-joinder and misjoinder of parties also. Because as per our
You
submission,
did
my
not
lord,
argue it before the trial court. We
yes,
don't
my
find
lord,
any argument.
we argued before
How
the
was it
trial
dealt
court,
with?
my lord. Kindly see the issues, my lord. Issues which issues were framed by the learned trial court at civil.
Issue, there is no non-joiner issue.
Yes, my lord. They failed, my lord.
What failed? Page 4 contains the issues. Trial court judgment. There is no issue on non-joiner. Oh, defect of parties, yes.
Yes, my lord.
How was it dealt with? Let us see that.
Yes, my lord. They dealt with that is
Court.
not a very big question for them.
Oh, bad for non-joiner of whom?
Non-joiner of parties, my lord. Because
Parties means who? Who was not?
other cousin brothers are also used to be involved here, my lord.
This is an eviction suit.
Yes, my lord.
They sought for declaration of title also.
Yes, my lord. Declaration
and-
of title and by virtue of
Sir,
title.
following substantial questions of law, one যেটা বললাম, আর second হচ্ছে whether the learned courts below substantially erred in law in failing to adjudicate on the question of non-joinder of the other co-owners of the property, of the alleged other co-owners of the property, despite having framed an issue on the question of the suit being bad for defect of parties. No, this is for eviction of licensee and recovery of no declaration of title.
No declaration.
Why are you saying declaration of title?
My lord, eviction will come after they have to establish that
এটা কেটে
title.
দাও,
my lord.
second round কেটে দাও, প্রথমটাই শুধু থাকবে. Yes, any interlocutory application, thank you. Which specifically asked you for declaration, yes, you said yes. We did not even look into the papers. Stay of operation, they have levied execution.
No, my lord, till yet not.
You have asked for injunction only. Your prayer portion says changing nature character, creating third party interest.
If they oust me, my lord, if they are trying to oust me and after it they
Your
will.
prayer is not for stay. You have captioned it as stay. Not be restrained by an order of stay from disturbing, alienating the suit property in favor of third party and changing nature character.
Okay,
But it's rectified. It is step by
Caption করেছিস,
stay from disturbing, alienating any.
you are granting an order of stay from disturbing, alienating the suit property.
If the my lord oust us, then every possibility is they will create third party.
We know that,
interest
but you have not even paid for that. Next para, leave is granted to the learned advocate on record for the appellant to carry out the necessary, ভালো করে দেখুন, carry out the necessary amendment to the prayer portion of the application by incorporating the prayer for stay of operation of the impugned judgment and decree of the courts below. Push of such amendment shall be carried out during the course of the day. Please ensure that this amendment is
Yes,
done.
my lord. Yes, my lord.
Whatever prayer is there, plus that.
Yes, my lord.
Next para, there shall be stay of operation of the impugned judgments and decrees of both the courts below till disposal of the application. Full stop. The appellants shall serve copies of the application on the respondents and file an affidavit of service on the returnable date before the appropriate bench. Full stop. Liberty is given to the parties to pray for inclusion of the application in the list before the appropriate learned single judge having determination.
Grateful, my lord. হ্যাঁ সবাইকে করতে হবে শুরু করবো
What is for the appellant?
What is the defect?
Defect has already been cured.
Cured. Very well. What is the matter?
The matter where the suit is for declaration of the civil death of the brother of the appellant number one.
You are the defendant or the plaintiff?
Plaintiff. My suit is dismissed on the ground that
both the courts dismissed.
Both the court on the ground that we have no cause of action, and the defendant has not denied the contention that my brother is dead. This is the contention of the trial court at the time of dismissal of the suit. Against that, we filed the appeal. First appellate court was of the view that Section 81 notice has not been issued against because in the suit there is a defendant inspector in charge of the concerned police station. Thereafter, what has happened? Real fact is that, my lord, by filing the suit on the same date, we filed the suit on 21st December 2017, and on the same date we filed an application under Section 80 subsection 2 of the CPC for waiving the issue of notice provision. That has not been considered by the first appellate court. Now but
leave was not granted to you. You must have moved that application also.
Well, we filed the
application.
We filed the application before the trial court.
In the trial court, you have to obtain a leave. You have to obtain an order on that application. Mere filing of an application does not absolve
that is
you.
pending dismissal. Kindly see the order of the trial court once. Kindly see, which is at page 58 once.
You are looking at the impugned judgment of the trial court, yes?
Yes, yes, yes. There is no recording to that application under Section 80 subsection 2.
The court says that neither I find from the LCR that any leave has been paid. Even if you have filed an application, you have to pay for that leave.
That has not been done.
Then what
But
is the
there is-
relief sought? What is the plaint? You have annexed the plaint?
Yes. Plain
Yes.
from page 15. And the prayers portion is page 20 onwards. And kindly see the observation made by the trial court that the suit has no cause of action because no one denied, but the defendant filed their written objection in the suit, denying the contention that my brother is dead.
They denied?
Yes, kindly see the written statement I have attached. Written statement.
You sought for declaration of whose death?
My brother death.
And defendant are the
defendant number 3, that is the inspector in charge of the concerned police station, filed his written statement.
You are also brothers, the plaintiff.
Yes. Also
he was your only other brother.
Yes, or elder brother. I am the elder brother. We are 3 brothers.
You had 3 brothers, according to you.
Yes.
So where is the denial page?
Kindly see page. The written statement starts from page 28.
Yes, page 31. False and denied that
every statement of the plaintiff.
What does the trial court hold that it's not denied? No cause of action. That is held by the appellate court.
Kindly see page 63.
No, we are seeing from the memo.
Oh,
let us see from the appellate court. Yes.
Kindly see the last page of the trial court's order. In the instant plain, there is no statement to that effect that the defendant had either denied and be interested to deny that the said Shotrendra Kumar Pal is dead. First paragraph. And the cause of action.
No, they say in your plaint you have not stated that they are denying.
Can you see the written statement?
The present second appeal will be heard on the following substantial questions of law. Roman 1, whether the learned courts below overlooked the pendency of an application filed by the plaintiff stroke appellants under section 80 within bracket 2 of the Code of Civil Procedure in disposing of the suit, in dismissing the suit without adjudicating on such prayer of the appellant by holding that no such leave under section 80 within bracket 2 was sought by the plaintiff appellant at all. Roman 2, whether in view of the peculiar nature of a suit for declaration of civil death, the learned courts below substantially erred in law in construing that no specific cause of action had been made out against the defendant stroke respondent stroke authorities, in view of the character of such a decree being having a legal impact akin to a judgment in rem, and the cause of action not being confined to certain to the defendant stroke authorities. Any interlocutor, there is no scope of interlocutor application. We'll direct you to prepare paper books and all this. The appellants shall put in due requisites and postal costs for service of notice of the appeal on the respondents, within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, of liberty to the parties to mention the appeal for inclusion in the list of the appropriate learned single judge having determination as and when the appeal is ready for hearing.
Obliged, grateful.
Thank you. Yes. Yes. Motor application. Yes.
Plaintiff number 1, the mother-in-law is the author who has transferred.
You have to bring in these complications regarding relationships in every matter. Mother-in-law, father-in-law, brother-in-laws, elder son. Oof. Yes, what is the matter about?
That my client
Yes, what
husband-
did your mother-in-law do?
Yes, but my
Apart
client's-
from
no, but
giving
my
her daughter in
client's-
marriage.
My client's husband died. The
Your clients, there are two clients.
yes, but the
Predecessor
plaintiff
interest.
number one is the widow,
Very well.
and plaintiff number two is the son.
Very well.
And the mother-in-law.
First, tell us, is it a judgment of affirmance?
No, it's not. It's a first miscellaneous appeal.
Oh,
I was granted. I was protected by an order of status quo ad interim. Obviously, that was continued since from 2022. Now,
Ultimately
by the
dismissed.
order impugn, that has been dismissed.
What is the case?
Yes. Now, the plaintiff, the mother-in-law gifted the property.
Whose mother-in-law? One or two?
One. The plaintiff number one's mother-in-law gifted the property in favor of the defendant number one. And
who is the defendant number one? How is
defendant number one is the daughter, married daughter. Defendant number three is the subsequent one of the purchaser who have purchased one of the part of the property from the mother-in-law. But defendant number three is an outside. And defendant number two is the developer with whom a development agreement has been executed by the defendant number one by dint of that deed of gift executed by my mother-in-law. My suit is that there is a joint family business which was run by my father-in-law as well as my deceased husband jointly, and out of that fund these two property as mentioned in the schedule of the plaintiff is being purchased in the name of my mother-in-law. And I have a right of residence over the property in question even if it stands in the name of mother-in-law. So by virtue of these two grounds, I have prayed for cancellation of those deeds.
You have a right of residence under which act?
Under the domestic violence 2S. Now after that judgment, now it's protected.
Yes.
So if that be so, I say you cannot evict me without due process of law. So I was protected by an order of injunction. The final order.
Injunction sought.
Injunction sought so that my possession cannot be disturbed by the defendant number two by dint of the execution of the development power of attorney executed by the defendant number one. By the order impugned, the learned judge have reversed the finding which whatever has been held at the ad interim stage on the ground that there are two deeds that are subsisting registered document. So since these two deeds are subsisting, so I cannot be.
Why two deeds?
Because one deed in favor of not development. One deed in favor of the defendant number three, who is an outsider, and defendant number one is the daughter.
You claimed the right of residence through your husband, domestic.
Yes, my husband died. I also pleaded in my plaint. There was a suit for divorce that was filed on the instigation of the defendant number one and mother-in-law, but ultimately during the lifetime of my husband that was not compromised and suit withdrew.
No, your one ground is right of residence and the other ground is that
I have challenged that it is my father-in-law's property. It is out of that joint fund.
The present appeal arises out of the refusal, the dismissal.
But only one thing that I must point out. There is a caveat I have served today. I have served.
The present appeal has been filed against an order whereby the temporary injunction application of the plaintiff stroke appellants has been dismissed. Full stop. The claim of the plaintiffs stroke appellants to the suit property is twofold. Full stop. It is contended by the plaintiff stroke appellants that the defendant stroke respondents claim title to the suit property by dint of transferred deeds executed by the mother-in-law of the plaintiff stroke appellant number one, despite the property originally belonging to the father-in-law of the appellant number one and comma having been purchased from the joint family nucleus of the family. First of secondly, the appellant number plaintiff stroke appellant number one claims a right of residence through her deceased husband in respect of the suit property, and as such, it is argued that even in the event the purchase of the suit property from the joint family nucleus cannot be substantiated at this stage, the appellant number 1, in any event, who is residing in the property with her son, the appellant number 2, has a right of residence to the estate of her in the estate of her deceased husband. Full stop. Next para. We find a sufficiently strong prima facie case having been made out. Full stop. Moreover, taking into consideration that the appellants were enjoying ad interim injunction during pendency of the injunction application, which was ultimately dismissed by the impugned order, we are of the opinion that the appeal should be heard on the above questions and on the other grounds as taken in the memorandum of appeal, and is accordingly admitted. First of next para, since we have already indicated that prima facie case has been made out, and from the averments in the injunction application, it is clear that there is urgency involved and the balance of convenience and inconvenience is in favor of grant of injunction, we grant injunction restraining the respondents and or their men and agents from interfering with the peaceful possession of the plaintiffs stroke appellants in respect of the suit property in any manner without due process of law till disposal of the application.
But also changing the nature and character. That was also granted by the trial court.
First of the respondents shall also nature and character.
That status quo was I was enjoying. Status
No,
quo,
but
nature, character.
they
and
have a
policy.
development agreement.
That's why, no,
No,
it is
only
in respect of one dwelling house.
Only injunction. Nature, character, if they can change without disturbing your position, they will do it.
Practically, it's not possible. Very well, Milord,
We won't grant that at this point. The application, since none appears for the respondents, despite service of notice on the learned advocate who has lodged a caveat on behalf of the respondents, which is borne out from the receipt which is filed today and kept on record, we choose to pass the above ad interim order in the absence of representation of the respondents at this juncture. Full stop. The appellants shall, however, serve a server copy of the present order on the learned advocate who has lodged a caveat on behalf of the respondents. She lodged a caveat on behalf of all the respondents.
All respondent,
as well as directly on the respondents who are not, on behalf of whom no caveat has been lodged. Full stop. Next para. The appellants shall file an affidavit of service on the returnable date. Full stop. The application shall next be listed for hearing on in the monthly list of July 2025.
Great.
It's not clear for whom she lodged a caveat.
Yes, Milord, I also.
We made it vague.
I
That's why we
I
made
shall inquire it. Milord, if
made it vague. Yes.
One. Oh, Milord, only one.
One.
Respondent number 1, the daughter.
তাহলে যে roundabout হইতে করলাম না, caveated respondent number 1 are shall serve copies directly on the other respondents.
Right. Great.
May it please your lordship.
Yes, Mr. Munshi, what is the matter?
But this is an challenge from an order.
There's a section 5.
Yes, my lord, there is a section 5.
Was there any direction to serve?
My lord, no, there was no direction.
You have to serve and come back.
I'll serve it. But I've already served it, my lord. That
was there a direction of the court?
No, my lord. Because there was a section 5, I have served it. But they have not received it.
No, you have to serve in any event. If they appeared, we could have.
As your lordship pleases. As your
the appellants shall serve copies of the of Can 1 of 2025 as well as Can 2 of 2025 on the only plaintiff respondents. On the plaintiff's respondent numbers 1 and 2, indicating that the applications shall be listed for hearing on. How soon can you serve? We'll keep it on 23rd, 2 weeks. On June 23, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Or my lord can keep it to 1 week hence, my lord. If my lord
Let
Very
it be
well.
23rd.
Very well.
We have full confidence on the postal authorities. So let us keep it to
Grateful,
23rd.
grateful.
Yes. Next. Yes, what is the matter?
I beg to appear for the appeal,
Yes.
my lord. My lord, on last occasion, my lord has granted us liberty to file supplementary, my lord.
By section 5?
No, my lord. To the our stay application, my lord. I would like to, and we have served a copy upon them of the supplementary affidavit, my lord.
Yes.
My lord, the
why is the supplementary affidavit captioned as a memo?
My lord, it is on page 2. It is, my lord, there is a mistake.
Blind copy paste. Yes. Anyway, what is the matter?
And
we had admitted the appeal, no?
No, my lord has not admitted the appeal.
What-
My lord, I just want to show you, my lord, the order. We have only annexed the orders of the
you had not
below.
filed certified copy of the order.
We have filed a certified copy of the impugned order, my lord. And with regard to this supplementary affidavit, my lord, we have annexed all the orders passed in this matter, my lord, to show your lordship that the impugned order passed has been passed based on a ad interim order passed by the learned court, which has died its natural cause, my lord.
1 minute. The memorandum of appeal does not. What is the date of the impugned order?
2nd April 2025, my lord. Order number 19. Right.
Yes. What is this endorsement to key endorsement? Leave has been granted. You are granted you leave to file without certified copy.
Without certified copy, as well as my lord has also granted leave to, as the appellant is from outside the state, my lord has granted leave to file it with notary, my lord.
No, subsequently you have filed the certified copy.
Subsequently, my lord, we have brought on record the certified copy.
When? How?
Well, we have not brought on record, my lord. We have just brought on record all the orders passed in the.
You have filed the certified copy.
My lord, we have not passed. We have just received, my lord. We have
you
just
got it with you.
I am. It is with me, my lord.
You have to file that.
My lord, I will. I shall. My lord grants me liberty. I shall file within the day, my lord.
Very well. Yes. What is the matter?
My lord. My lord. I will beseech your lordship, my lord.
Have you got sufficient copies of that? If you want to rely on that set of orders, you have to have copies.
At this moment, I do not have.
Come prepared with copies. Give them copies also.
Well, I have already given them copy, my lord.
So have copies for both of us, because we cannot mark on that certified copy, because we will have to direct that to be filed.
Well, then kindly grant me.
I have not received the certified copy. But
No,
my lord,
photocopy.
Copy must not be served, my lord. I have served the xerox of the certified copy.
Yes, yes. They can only
we
do
can
it.
work without it.
So you do this. You file the certificate. Have you got copies with you?
My lord, I have got copies of these.
These are the certified copies.
This is the only certified copy we have. This is certified copy. I have not got the extra copy with me. Kindly grant me liberty. To come back tomorrow.
Let the matter stand adjourned for the day in order to enable the learned advocate for the appellant to file a certified copy of the impugned order in court. We are adjourning it for only this, and then tomorrow when you argue it, you just
grateful.
And whatever you rely on, give copies to your other side so that.
We have already served them everything.
আচ্ছা আরেকটা লাইন অ্যাড করে দাও, supplemented affidavit filed today with leave of court be kept on record. Please give all of your names in the previous matter, both sides. Yes.
Lord, suit for declaration, partition, and injunction.
Right.
And the ad interim injunction was passed ex parte against me. I filed written objection, written statement, and an application under Order 39 Rule 4. My Order 39 Rule 4 has been rejected. Against that rejection, I have come before you. Lord, plaintiff.
39 Rule 4, very limited window.
Yes, my lord.
The initial order was passed ex parte.
Ex parte.
So what is your ground in the Order 39 Rule 4?
They say that the whole property is Ismaili property. My first contention was that the property is not Ismaili. When my lord will find from the plaint that the landlord has sold specific and distinct portions of land to 25 purchasers, and all those 25 purchasers are the defendants in the suit. Plaintiff claims that he had purchased 10 katas of land out of that property. So my first contention was that the suit is not maintainable as because the property is not Ismaili, whereas in the plaintiff himself asserts that I am in the possession of my property which I have purchased.
Have they annexed the deeds?
Yes, I have annexed the deed.
The deeds show that it was demarcated for
Yes,
substitution.
yes, my lord. My lord, please come to page 49.
But does that come within the ambit of Order 39 Rule 4, or you should have preferred an appeal or have the injunction application heard out? 39.4 is very limited. Suppression of material facts, yes, but then everything will come under suppression of material facts. If they had annexed those deeds with their injunction application, there was no suppression as such.
No, but the suit is that. How that
Yes,
suit
you have a right to say that. Then you hit at the maintainability of the suit, right?
Yes.
So that in turn hits at the prima facie case. But that is amenable to challenge by you have an appeal against the ad interim injunction or in the final hearing stage of the injunction application. This is not an Order 39 Rule 4 scenario. We'll leave open to you to take all these points in the injunction application, direct the trial court to hear out the injunction application quickly. But this is not an Order 39 Rule 4 scenario.
In the meantime, my lord, my portion has been injuncted.
Suffer that injunction for some time and have the injunction application out. This does not come under Order 39 Rule 4. We get your point that the appeal you hit at the maintainability of, because first of all, demarcated portions, if demarcated portions has been sold, transferred, then suit for partition is not maintainable. But you have taken a point of non-joinder also.
No, because all the parties are there. All 25 purchases
You find
have been
some mention of non-joinder somewhere.
Yes. But I haven't.
That's a general.
I haven't raised.
Because in the same breath, if you say non-joinder, then your case is gone.
No, I haven't
Then it
said
becomes
anywhere in my written objection or in my written statement that non-joiner parties are there.
Let us see what the court has said. Court has said exactly what we are saying, probably. Right. There is no deliberate suppression of material fact. Exactly. This is a very good order, in fact.
Milord, please come to page 19.
Refer to the internal pages, please. Internal
Page
page 4.
19.
We are in the memo. So internal
No.
page. We are referring to the impugned order.
Yes.
See, there is the court says in internal page 4 there is no misrepresentation. They annex all the documents. There is no suppression or misrepresentation.
Suppression of fact is that
they have annexed all the documents, placed it before the court. They played their cards.
I have supplied them the documents. They haven't. They except deed of conveyance. They haven't annexed anything with the plaint.
With the injunction application also, they have not annexed.
No.
Acha, let us see your deed. Those deeds.
Page 49, my lord. Last piece. Remote contribution report.
We'll leave these points to be decided in the appeal, in the final injunction order.
Page 63, below.
63, we are looking at page 63. It appears that there are boundaries. You have a case there, but this is not an Order 39 Rule 4 case. If you say that, then in every case, wherever there is a on merits there an adjudication is required, it will be a material suppression of fact. 39.4 is on a higher ground. The present appeal has been preferred against the rejection of an application by the defendant/appellant in a suit for partition and consequential reliefs under Order 39 Rule 4 of the Code of Civil Procedure. Next parallel, counsel for the appellant argues that although the suit has been filed for partition and an injunction, ad interim injunction has been obtained by the plaintiff stroke respondent on such premise, comma, the plaintiff suppressed the material fact that only a demarcated portion was transferred by way of the transfer deed in favor of the plaintiff. Full stop. As such, comma, it is contended that the learned trial judge ought to have vacated the injunction order in view of such gross suppression of material facts. Full stop. Next para, we find from the impugned order that the learned trial judge proceeded on the premise that the status quo order was passed at the ad interim stage on the basis of the amendments made in the application for injunction, and as such, there was no material suppression, no suppression of material facts involved. Full stop. Next para, although the plaintiff, the defendants to appellants might have an arguable case insofar as the learned trial judge is required to adjudicate as to whether specifically demarcated portions of the property were transferred in favor of the plaintiff, comma, the said objection partakes the character of an adjudication of the merits of the injunction application and cannot strictly come within the purview of gross suppression of material facts evident on the face of the record. Full stop. Next para, in the event such a liberal construction is given to suppression of material facts for the purpose of Order 39 Rule 4 of the Code of Civil Procedure, comma, every figment of argument in respect of an injunction application would be broadly covered within the ambit of such expression. Full stop. Next para, hence, comma, we do not find any illegality per se in the trial court refusing to vacate the interim order under Order 39 Rule 4 of the Code of Civil Procedure. Full stop. However, comma, needless to say, comma, the grounds on which the present appeal and the Order 39 Rule 4 of the Code of Civil Procedure have been preferred by the appellants are required to be adjudicated on merits by the learned trial judge at the time of final hearing of the temporary injunction application, comma, without being influenced in any manner either way by the observations made in the present order and stroke or in the order impugned herein. Full stop. However, comma, in the light of the above observations, we do not find any scope of admitting the appeal. Accordingly, FMAT 173 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure, comma, leaving it open to the appellants to argue all points taken in the memorandum of appeal as well as the application under Order 39 Rule 4 of the Code of Civil Procedure at the final hearing of the temporary injunction application. So, have you filed your objection to the injunction?
Yes, my lord. Time should be.
Since we are apprised that a written objection has already filed by the appellants to the temporary injunction application filed in the court below, comma, we are of the opinion that the learned trial judge should dispose of the temporary injunction application on merits as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order to the learned trial judge. Can 1 of 2025 is disposed of as well in the light of the above observations, no arrest cost. Gross suppression of material fact to jali করে একটা proof করতে হবে, এটা matter of adjudication. Yes, yes, Mr.
Last question, Lordship was pleased to direct me to serve notice.
Why are you laughing? You have been managed by the other side.
No.
Yes.
This
I am for the respondent number 1 to 6.
Obviously, you are. Yes, Mr. Rai.
It is a desire of this court that it will be hard to allow this application and the appeal itself. And the Lordship was pleased to direct me to prepare an informal paper book for that purpose.
So, what is the challenge against?
Injunction, granting our order, injunction, status order, status quo.
What is the point involved? Yes. We directed you to we directed that the appeal should be heard together, means the presumption is it will take 5 minutes. Otherwise, you would not have directed the appeal along with the application to be heard of. Yes, what is the matter? What is the matter? Quick, Mr. Rai, let us finish it. Not finish you, finish it.
Just a suit today.
What is the suit for? Partition?
Partition.
They are suit for partition, injunction granted. What injunction granted?
Terrasco not to change the nature and character and the position.
What is your base ground?
Yes, my lord. The base ground is the predecessor of the plaintiff transferred the property in favor of the kindly turn to page 1 of the volume 2. I have handed over the paper book to your lordship, my lord.
Volume 2.
Yes, it is in the it is mentioned volume 2 in the just after my lord page 37. Your lordship, part 2. Part 2. I should be.
Yes. Yes. What is that?
That is the deed.
Their predecessor transferred
Yes.
to you.
No, the defendant number 3, one of the defendant. That your lordship, that defendant is 12 defendants are there, out of which, my lord, the defendant number 3 who purchased the property from Esgar Yunusek. Yunusek is the predecessor of the plaintiff. Now, this is the deed by which, my lord, your lordship find he transferred the property to the extent of 15 decimal out of 30 because it's the half share. He is having half share of the property. Now, apropos to this, my lord, kindly consider the plaintiff itself.
He transferred his entire share.
According to us, he transferred the entire share. Now, my lord, kindly turn to the internal page 3 of the plaintiff. That is the Yunusek, Nalji Sampotite. My lord got it. Running page 3 of the paper book.
Yes.
Plaintiff start.
Yes. Yunusek.
এবং ইউনুসেক নালিশি সম্পত্তিতে একজন মালিক থাকা মারা গেলে তার 2 পুত্র আসমুরা শেখ, খাইরুল শেখ প্রত্যেকে একের চেয়ে অংশ, 2 কন্যা.
No, what is your point? Just tell us, then we'll.
Because he has no title over the property, because he transferred the property predecessor of the plaintiff. That was taken into
Predecessor of the plaintiff, according to you, transferred his entire share.
share.
So
if
he has no locus standi to file.
file a suit for partition unless that deed is challenged.
This is you have challenged an ad interim injunction status quo.
Now, kindly consider how the
No, by the impugned order, the injunction application.
disposed of. Kindly consider the nature of the order passed.
This is your main point, that he did not have title letter.
Did not have title. Apart from that, another case was also made out by us.
Yes.
That prior to arrest record of rights, he already transferred whatever he writes by amicable settlement, it was given to somebody else. And his name was recorded in the arrest record of right.
What amicable settlement?
Amicable settlement, prior to that, where 2 plots are there. Instead of 1 plot, he has got in its entirety. His name was recorded in the arrest record of rights. So the other plot, instead of which he has some title of the property, that was given.
He has filed the partition suit not regarding the other plot, which admittedly is in his favor.
So
he has filed a partition suit in respect of the other plot.
Other plots.
The plot which has been already transferred by his predecessor. So what is the other point you couldn't understand? What is arrest record? And
these are the 2 points. One is even assuming that the amicable settlement is disbelieved by this court, then also he has already transferred the property which, according to the admitted share.
Assuming, what is the first point?
First point is that already he transferred his share.
That is the key point which we could understand. What is the other point?
One by act, one by way of deed. By act is that the prior to arrest settlement, it was transferred because that point of time, the transfer of amicable settlement
Not transferred, recorded in his name.
Recorded position transferred by amicable settlement, my lord, it can be termed to be transferred in that point of time.
How does the arrest record
1959 exclusive position? That is in 13th column, it is the exclusive position of a particular person's name is recorded. That is why, my lord,
whose exclusive position?
Our predecessor, defendant's predecessor name was exclusive.
In whose favor his predecessor transferred? His predecessor transferred in favor of your predecessor.
Yes, one of it. Now, can you consider how the order of injunction has been passed? Can you turn to the order?
Let's be clear on this, Mr. Rai. His predecessor, according to you, transferred in favor of your predecessor, and accordingly, entries were made in the records of rights. Is that your case?
No, my lord. There are 3 plots. My lord, that is why. My lord, can you turn to the plaintiff itself? Your lordship will find 2 plots are there. 3662.
2 or 3?
2. Page 4, my lord.
3?
3662.
Yes, and
12783. These are the two plots
yes.
where they are claiming half share of the property.
So both are the subject matter of this partition suit.
Partition suit. That is why, my lord, if you logically they are
Your
claiming.
case is that?
My case is that already one plot in respect of which they have already by amicable partition they got the
Which plot?
Yes, that your
3662 or 12783?
that 12783.
Regarding that, what happened?
It was exchanged and by
it was
amicably partitioned, and by amicable partition I got the exclusive right over the property, and our name is recorded in the RS record of rights. And the other one is concerned.
No, 12783 is exclusively in your name.
Is your name.
The entire plot.
Entire plot.
Very well. Your
Maybe
predecessors.
my predecessors names were there.
Very well. Then and 3662.
It was transferred. According to us, half portion which is there, it was transferred. Am I clear to your lordship?
Yes. Well, the other half belongs to you.
Other belongs to me. This is admitted. That is why, my lord, it is a specific case that half portion belongs to UNISEC.
So this case has been made out in your written objection.
Yes.
How does the court deal with it?
Now, my lord, can you consider the court, how the court's order is, my lord, at page 17.
But if the if the amicable settlement is disbelieved, then Mr. Rai, these are not alternative cases. These are regarding two plots. Supposing even that half share, his predecessor's half share in 3662 has been sold out, transferred to your predecessor. If amicable settlement is disbelieved, you have to prove that in the suit.
Yeah.
Otherwise, 12783 remains joint.
I could have understood that any findings to that effect arrived by the learned court below.
Conclusion then is correct. Injunction
Why?
Even as per your proceeding on your case only.
Then, my lord, prior phase, I am showing that I am in exclusive position.
Of what?
The
12783.
Yes, because my name is exclusively recorded in the RS
Person is the person in respect of all the courts.
If that be so, my lord, it is after the 1969, my lord. And can you consider section 14 came into effect, my lord?
Nature character person has been given only. If you are in person, you remain in person.
Nature character, my lord, it.
They have made out a prima facie case at least regarding 12783. And regarding the half share of 3662, you have annexed some deed.
Yes.
So let us take your best case on that half share, yes, in 3662. But regarding the other half, 12783, regarding that at least they have a case. And these are joint properties.
Joint properties. So what the joint properties?
So if when they can show a fraction of a right in the property, it comes within the
well, can you consider whether this aspect, to what extent they have proved their title of the property they are claiming to be the owner, on basis of which I have
you are admitting their co-ownership.
Ownership. And how they are not
12783, you admit that their predecessor was the owner. But you say by amicable settlement, it has been given to you.
Yes.
Amicable settlement, you go and prove in the suit. Unless you prove the amicable settlement, you remain a co-owner, they remain a co-owner. Then partition suit is maintainable.
Therefore, well, for that purpose, I produced the record of rights, RS record of rights prior to 1969.
Injunction stage, there cannot be a mini trial. You have to prove on evidence that amicable partition was there.
On the basis of which, I produced the document.
Family arrangement, you have to prove by elaborate evidence, Mr. Rai. Family arrangement, otherwise section 14 comes in. As per your argument in the other matter.
Section 14, that is I am constantly saying before 1969.
Oh, this was not before 1969.
This RS record, that is why my name was recorded in the record of rights.
When prove your case of amicable partition regarding 12783, unless you prove that at best it has been recorded in your name. Even if it is recorded in your name, it is at the best prima facie proof of possession. And unless you prove independently, unless you prove ouster or amicable partition, otherwise your position is in respect of all.
That is why, if something I am claiming to be in a position of the property in question,
yes.
For the purpose of showing I am in position, I produce the RS record of rights and subsequently the KB stage. Up to the KB stage,
subsequently
up to KB stage is there, my lord. So for the LR record of rights,
yes,
I produce showing my position. For the purpose of getting a suit for partition, he has to prove that yes, something is there for the purpose of showing that he is in position, either constructive or actual. Constructive means by through me.
You are admitting his title.
Admitting
sans that amicable partition, you are admitting his title.
Yes, so
Your
therefore
case is based on that amicable partition,
That
which is your case.
he delivered possession to me, so
There is no written partition deed
he delivered possession to me, so this
that you have to prove in the suit. Otherwise, if there is no such amicable partition, you admit his title.
yes, if the amicable partition goes, so therefore, my lord, something I brought before the
You have
court
to
showing
prove. You have to prove by
at least
positive
the possession
evidence.
is with me.
Even if possession is
Then
with you,
if
that
he-
it will be deemed that it is joint possession
then
on behalf of all.
partition, my lord, Kali goes, the suit for partition, the person ouster. So far,
Outside has to be pleaded and proved in the suit by you. Outside, you have to have a very high proof.
ouster to the extent, my lord, whether the delivery is this
Mere recording of one of the co-sharers' name in the record of right does not automatically mean that there has been either ouster or an amicable partition. That's one of the circumstantial pieces of evidence at best. But in the suit, evidence has to be. Let us see how the trial could do.
Yes, my lord.
Page
Page
Your
18.
cases have been stated. Just from reading it
Yes.
appears there is a question of title involved, which should be decided. Yes,
Problem is the UNICEF already sold his half share in plot number 362 in support of his claim and filed one deed from where it appears UNICEF transferred his share for a association, but there is no document which is going to show that prior to artist record of rights, property was partitioned between the parties.
Right.
Well, so what this is the document. Subsequently, well, there are two plots. One can consider this.
Even if his half share was sold, his predecessor half share was sold.
Then
he co-shared in the property in view of 12783.
No, two plots are different. Then how can he get injunction?
Plots are different does not mean they were a joint property. They come within the joint hotspot of the property.
Yes, but if I produce so that the
share in one plot was given.
Given. So for the if that we show he is not entitled to get the injunction of that plot, kindly consider it that way also.
Not necessarily, Mr. Rai. If it's a conglomerate property, I mean,
it is not a
total joint property has to be brought in.
Yes, according to him, he
cannot segregate. If he wants to bring a suit for partition, he has to bring it in the hotspot the 12783 as well as the other plot also, because those are together they are joint property. They comprise
two distinct plots. Plot number such and such, plot number such and such. If I fail to prove any sort of interest over one plot, and I brought that plot in the hotspot, that means I am entitled to get an order injunction whether it is permissible or not. I said that yes, these are the three plots, out of which I can prove co-shareship in respect of one plot. If so fact I am entitled to get injunction in respect of the other two plots.
Yes, what do you say regarding the other plot? 3662.
My lord, kindly come to the order, my lord. Third paragraph, my lord. Before ROS ROR, the suit property along with the other properties amicably partitioned between the parties, and Basit Sikh, predecessor of the plaintiff, got entire 16 annas here. My lord, this is we are not the my lord predecessor of Basit Sikh, my lord. In the plot number ato. Again they have stated that Basit Sikh is the predecessor of defendant and he got the entire plot of such and such. So there is an anomaly in the WO of the defendant, my lord. There is something, my lord. And the status order was passed, my lord.
So but the other plot.
This is regarding 12783. 12783, we are with you.
Yes.
What about the other plot? 3662.
They have stated that that UNICEF has sold the entire share. But my lord, this is our case, but we have got the property from UNICEF, my lord. This is our my lord.
But before you got the property from UNICEF,
yes, my lord,
they have produced a deed of sale or what?
Yes.
Sale deed. Registered sale deed.
Registered document. It is also admitted to the London trial court. But what it doesn't reflect that what it does, it relates to partition. It is not related to partition. This deed
but there
plot,
is no document which
plot
going to show
itself
that
shows
prior
that
order
yes, whatever the interest he has in the property, he transferred particular plot.
So let us hear him. Yes, complete him. Yes.
My lord, regarding 3662, my lord, we have bought from the UNICEF, my lord. That is the amount case.
But he has produced a sale deed in respect of the self-same plot. And court records that in support of the claim, defendant filed one deed from where it appears that UNICEF transferred his share in favor of Iskar Hussain.
But there is no.
But there is no document which goes on to show that prior RS record property was partitioned between the parties.
That is the point.
The plot number 3662 is a separate plot. What is your answer to this argument of Mr. Rai? Can you mix up 3662 and 12783? These are the two suit plots.
Two suit plots. The
So these are distinct plots.
That is true, my lord. But my lord, that is in the hodgepodge of the partition suit, my lord.
Can you do that? Can you incorporate a suit, a property which has been already transferred by you? Regarding 3662, they had half share, their predecessor, you had half share. Your predecessor sold his half share, therefore they became exclusive owner of 3662. It's a demarcated
Then, my lord,
plot.
I have to take instruction regarding that, my lord. I have-
Well, you have not further time to take instruction. We are hearing the appeal.
my lord, I have
We'll
got
modify the injunction and grant it in respect of 12783 only.
status order was passed, my lord. There is no harm.
Pass status quo order regarding 2783, 12783 only, if you are satisfied with that. Status quo not for the asking.
Status is one form of injunction, my lord. Status quo means, my lord, one form of injunction.
We'll make it injunction then. Only on you. Only against you.
Status quo is a nature character injuncted me.
There could not be any past status quo order against him on his prayer. কেউ তাই করে কনফাইন করে কেন ওটা তো সেল লিড রয়েছে নিজেই স্বীকার অবজার্ভ করে প্রাইভেসি কেস তো নিচ্ছেন
This is the annex page 1 of part 2.
The present appeal has been preferred against an order of temporary injunction in the couched as a status quo order in respect of nature, character, and possession of the suit property. Whose of next para, the learned counsel for the defendant stroke only one defendant appellant.
Yes, given number 3. Yeah.
Defendant numbers 1 and 3 stroke
1, 2,
the defendant stroke appellants.
1, 2, 3.
Learned counsel for the defendant's appellant submits that
1 and
the plaintiff's predecessor had transferred his half share of suit plot number 3662, and as such, the plaintiff was not entitled to injunction in respect of the said plot in any event, nor could the plaintiff incorporate the said plot within the hodgepodge of the partition suit. Full stop. Next para, insofar as plot number 12783, the other suit plot is concerned, it is submitted that there was amicable partition between the parties and the entire plot was allotted in favor of the predecessor in interest of the defendants as reflected in the extracts of the records of rights produced in the court below. Full stop. Thus, the partition suit is not maintainable at all at the behest of the plaintiff stroke respondent, and the plaintiff respondent was not entitled to any injunction. So next para, learned counsel appearing for the plaintiff respondent submits that mere recording of name of the defendants in the RS records of rights does not indicate automatically that amicable partition was effected in respect of the said plot, full stop. Insofar as plot number 3662 is concerned, it is argued that it is a debatable question as to whether the half share of the plaintiff's predecessor was transferred in the name of the defendants, and as such, during pendency of the suit, the learned trial judge was justified in granting an order of status quo. Full stop. Next para, upon a careful consideration of the materials on record, we find that in the impugned order itself, the learned trial judge recorded that insofar as suit plot number 3662 is concerned, a registered deed of transfer has been produced by the defendant stroke appellants to show that the predecessor in interest of the plaintiff, namely Yunus Sheikh, transferred his share in the said plot in favor of Eskar, E-S-K-A-R, Hussain, the predecessor in interest of the defendants.
Given number 3.
Of the defendant number 3. Full stop. Next para. Since the suit property is comprised of two separate and distinct plots, being number 3662 and number 12783, we cannot club the two notionally merely because both have been put within the common hodgepodge of the subject matter of the partition suit by the plaintiff at his own choice. Full stop. Next para. Insofar as plot number 3662 is concerned, the same is a distinct and different plot, and since there is strong prima facie evidence that the half share of the plaintiff's predecessor was transferred in favor of the other co-owner, that is the predecessor interest of the defendants in respect of the said plot, comma, which is borne out by a registered deed produced in the court below, comma, we are of the opinion that the learned trial judge erred in law in granting status quo in respect of suit plot number 3662. Full stop. Next para, however, comma, inasmuch as plot number 12783 is concerned, comma, it is arguable as to whether the same was amicably allotted to the defendant's predecessor exclusively. Full stop. Such a case, comma, as made out in the written objection of the defendant's appellants, comma, in respect of alleged amicable partition, comma, has to be made out and established by cogent evidence at the trial of the suit itself. Full stop. Merely because the name of the predecessor of the defendant's appellants was recorded in the RS records of rights does not automatically indicate ouster of the defendants, comma, who were admittedly co-sharers thereof prior to such recording, comma, from the said plot and stroke or the factum of alleged amicable partition having been effected by allotting the entire plot number 12783 in respect of the predecessor of the defendant stroke appellants. Full stop. Since an arguable and triable issue has been made out in respect of plot number 12783, comma, it would only be prudent if at this stage status quo is maintained by both parties in respect thereof as rightly directed by the learned trial judge. Full stop. Next para, thus, comma, although the reasoning in the impugned order is somewhat cryptic, comma, the conclusion of the learned trial judge insofar as plot number 12783 is concerned, comma, is borne out by sufficient materials on record. Full stop. Accordingly, FMA 235 of 2025 is partially allowed on contest, comma, thereby modifying the impugned order bearing order number 14 dated June 20, 2024, passed by the learned civil judge, senior division at Kandi, comma, district Murshidabad in partition suit number 173 of 2023 to the effect that the parties shall remain restrained. The parties are hereby directed to maintain status quo in respect of nature, character, and position of the suit property in respect of plot number 12783, comma, which is a part of the suit property till disposal of the suit, and full stop. However, comma, the status quo order in respect of the other part of the suit property, that is plot number 3662, is hereby vacated. Full stop. Next para, it is made clear that the above findings and observations have only been arrived at for the limited purpose of adjudicating the appeal in connection with an injunction order and shall have no and shall not be binding at any further stage of the suit and or the final hearing of the suit. Full stop. The learned trial judge shall be at liberty to adjudicate all issues involved, comma, including those which have been touched upon tentatively in the above order, comma, at the final hearing of the suit independently without being influenced by any of the observations made above or in the impugned order. No order is to cost.
The paper will be kept in the record because the lordship was.
প্রথম লাইনে করে দিই, the paper books filed, informal paper books filed to be kept on record. Can was disposed of previously.
No, can application and the appeal will be heard.
Acha. Can 1 of 2024 stands disposed of accordingly in the light of the above observations are then certified. Thank you.
Okay.
Yes. I appear on behalf of the defendants. My lord, the plaintiff has filed a suit for declaration that he is the owner of the 17 decimals of land and asking for demarcation of the land and other consequential reliefs. In such a suit, my lord, an application for injunction has been filed, identity granted against that, my lord. We entered appearance and the contested suit. Our specific case is one of the 4 decimals of land was transferred in our favor by the.
You have challenged an ad interim order or final?
The final order.
Temporary. Yes.
Status quo order was granted, my lord, which is bereft of any reasons, and it has been passed for non-consideration of the pleadings of the parties. My lord, our specific case is well, the 4 decimals of land was transferred in favor of my clients by the vendor of the plaintiff. And the 17 decimals of land was acquired by the land acquisition by the state of West Bengal, which has been reflected in the deed of transfer in favor of the defendants. And we have taken a specific pleading in the written objection and the written statement that 17 decimals has been acquired by the state of West Bengal.
Now, what is the total extent of the property?
21, 4 decimals to the defendants.
4 to you, 17 acquired.
I shall expressing the paragraph number 14 of the objection, my lord, we have specifically stated the land, it has been.
You produce the deeds also?
Yes, my lord, if you lost it, kindly comes to page 35, that is objection to the injunction application, my lord, where we have specifically stated that it has been acquired under the allocation.
Regarding acquisition, did you produce any document or?
Yes, we have stated, my lord.
This is only your statement.
Statement, my lord, but this application, my lord, we have taken. Well, the deed has been produced before the court.
Deed regarding your 4?
Yes.
And what about the 17 acquired?
In the deed, my lord, it has been specifically stated that property has been acquired by the.
That itself is not a proof of acquisition.
No,
Even if in your deed it has been stated, that is not a proof of acquisition.
No, my lord, indeed.
Some document, some notification, something.
Some notification, you have given, my lord, LA case number 10 of 65, we will also can see. We have specifically stated page 35. And the learned judge doesn't even discuss this particular matter, discuss the statement made in the written objection and pass it order of status quo without any finding that who is in possession of which property. My lord, your lordship, my lord, no, this type of order of status quo is bad in law in terms of the Supreme Court judgment and the division bench judge of the lordship court. If your lordship can seize the impugn order, I have stated before the court below, my lord, that the 4 decimals and the 17 decimals have been acquired by the land acquisition collector. And your lordship can seize the order. There is no finding, nothing.
This particular Ghosh, you serve a copy and come back, serve a copy of the memo and the injunction. Will also hear out this application.
Yes,
this appeal along with the application. We'll keep it under the heading application. We are keeping it on 23rd. We are giving you 2 weeks, serve both and come back. We are admitting the appeal formally.
We also can admit the appeal.
We're doing it now.
Yes.
The present appeal has been preferred against an order of temporary injunction, which of learned counsel for the appellant submits that the suit property is comprised of 21 decimals of land, out of which the defendant's appellants have produced documents in the court below to the defendant's appellants have produced documents in the court below to show that 4 decimals have been transferred in favor of the defendant's appellants, whereas regarding the other 17 decimals comprised of the suit property, the same has been mentioned in the transfer deed of the defendants to have been acquired by the state government. Full stop, next para. In fact, learned counsel points out from the relevant portions of the written objection filed by the defendants in the court below that the specific case number with regard to such acquisition has also been mentioned. Full stop. The learned trial judge, while passing the impugned order, entirely glossed over, glossed over the entire objections taken by the defendants stroke appellants and did not advert to any of those averments as and stroke or the documents produced by the defendants. Full stop. Since a strong prima facie case as indicated above has been made out by the appellant, we admit the appeal to be heard on the grounds as taken in the memorandum of appeal. Full stop. In view of the nature of the interim order, we are not inclined to grant any ad interim order at this stage, since the same would tantamount to allowing the appeal before hearing the same. Full stop. However, in view of the short conspectus of the appeal, the appeal and the application are required to be heard together. Full stop. Accordingly, the appellants shall serve copies of the application as well as the memorandum of appeal on the plaintiff respondent directly, as well as on the learned advocate appearing for the plaintiff respondent in the trial court, indicating that the appeal and the application shall be taken up for hearing together on June 23, 2025, when an affidavit of service shall be filed by the appellants full stop, the matter shall be listed on June 23, 2025 under the self-same heading with the understanding that the appeal shall be taken up along with the application, full stop. Accordingly, let the notice served by the appellant as indicated above be treated to be the notice of the appeal as well, full stop. The since all the relevant papers are annexed to the connected application, comma, the appeal will be heard out without preparation of paper books and by dispensing with calling for the trial court records on the basis of the papers which are already on record.
All right, I'm grateful, Your Honor.
Thank you. Mr. Ghosh, better serve a server copy of this order along with this, so that everything will be clear to you. It is complicated, a bit complicated.
Lordship, I am for the petition of praying for not today, Lordship.
Why?
Mr. Sotendra Agarwal appear on this matter.
You are there, remove the matter. What is the matter about?
I don't know, Lordship.
On the, not today?
Only not today, only.
On the pair of the appellant, the matter is adjourned for the day. Mr. Mahato, come back to me.
My Lord, I am for the.
Yes.
So the point involved here, my Lord, I have challenged the order of refusal to grant the injunction.
Yes.
The final.
Ad interim injunction.
Ad interim injunction, not ad interim injunction, Lordship. It's
temporary injunction dismissed.
Yes, my Lord. Upon hearing the other side's Lordship. Now, the only sole ground which was considered that the agreement for sale was not.
So, what is a suit
registered? Suit for specific performance.
All right. Agreement for sale was not registered.
And that was the sole ground to refuse the injunction. My Lord, I paid the money. Consideration amount was paid. And after that also, there was certain non-performance from their side.
But Mr. Chatterjee, both under the Transfer Property Act, because here it is not a question of non-registration merely. In a sale, the title does not pass unless it is registered.
Well,
Section 54.
However, Lordship, that the document.
So, on the basis of that document, you do not acquire any title.
No, Lordship, I have
so this
not
is an agreement.
Agreement for sale.
Sorry. Yes.
Therefore, my Lord, the learned trial judge.
So how did you get over the registration? How do you get over the non-registration?
Lordship, this non-registration at this stage, Lordship, this can be this is not completely inadmissible evidence, my Lord. This can be because if my right is not protected, considering this suit.
What is the effect of Section 49 of the Registration Act? Just place it before us. Ekটু দিন না registration একটা stamp একটা দিন registration একটা লাগবে stamp একটা section 49 section 30
my lord section 49
of the registration act
yes
and 33 and 35 of the stamp act.
Effect of non-registration of documents required to be registered, no document required by section 17 or by any provisions of Transfer of Property Act 1882 to be registered shall affect any immovable property comprised therein.
So therefore, Mr. Chatterjee, it is not a question of non-registration rendering it non-admissible. In case of non-registration, no title passes.
Now,
49, the effect of 49, unlike section 33 of the Stamp Act, is that shall affect any immovable property comprised there. So you don't acquire any right, not only title passage.
If today my right is not,
it's as if it does not affect the immovable property at all.
Since it's the agreement for sale, so
that's also an actionable claim on the immovable property.
So, Lordship, the provided there can be the document can be impounded.
Impounding is in respect of deficit stamp. Registration cannot be cured unless you have it registered.
Conferred power to adopt or be received as evidence of any transaction affecting such property of conferring such power.
We are not on be received as evidence. Evidence stage has not yet come.
My lord.
B, confer any power to adopt, and A, affect any immovable property comprised there. So it's as if there is no such agreement in the eye of law.
Lordship, now then this since this
it's one of the plausible views. Why should you interfere, Mr. Chatterjee? If it was mere non-stamping requisite stamp, we could have directed it to be impounded.
May I,
it's not really that.
May I seek 1 day accommodation, my lord. 1 day. So
Very good.
So I will also try to raise
Very
your lordship on this point.
On the prayer of the appellant, the matter is adjourned for the day.
It will be taken up tomorrow.
No.
I'll do.
If you can reach it, otherwise.
I will. So
you hope that we can't reach it. And we will hope that we can reach it.
So that is the impediment I have to overcome.
What is the impediment? The court. Apart from the court, you don't have it. And section 49.
Section 49. Effect of non-registration.
Would the same as of the 48. In the last occasions, your lordships.
Same as of 48.
48.
Also
But
come
my lord,
orders.
No. My lord, I have in last occasions your lordship was pleased to ask me because the order under challenge is my lord, the ad interim order refusal, and that is without my lord, your lordships has observed this order is completely palpably blank. But the thing is, your lordships observed that the documents which has relied upon that the agreement for sale that is not registered one. My lord, I have gone through my lord, 3 judgments. My lord, latest one is at my lord, 2025, one of the Supreme Court decisions. My lord, which my lord. 2025 SCC online, SC 1067.
Yes.
Well, I'm relying on the paragraph. And paragraph 10. The earlier one was the paragraph 10 is Kala Devi. That was decided earlier Kala Devi. That I have also got the Kala Devi. That taken the that is a 2010 5 SCC 410 401. দুটো দিয়েছিস 10 করে কলা দেবী দুটো দিয়েছিস in Kola Devi I am relied on paragraph the 12-13 specifically 12 paragraph 13 the ratio which has been
No, you rely on the proviso to section 49. That is your answer. You're right.
And in Kala Devi the paragraph 13 I have handed over Kala Devi also.
Kala Devi is not required. Proviso to section 49 is sufficient. Yes, you have a very good point here. We'll admit the appeal. And injunction was refused on that ground?
Yes, ad interim order of injunction refused.
What was the nature of injunction? Yours was also suit for specific performance?
Yes.
Specific performance suit. Nature of injunction sought?
No, that is that plaintiff. That is that
আজকে সুবিধা যখন আসবে 49 প্রোভাইডার করে কোড করে দিতে হ্যাঁ একদম ঠিক
page 27 of the application.
By the impugned order, the learned trial judge refused an ad interim injunction sought by the plaintiff stroke appellant in a suit for specific performance of a contract. The only ground on which the ad interim injunction was refused was that considering the pleadings and the affidavit and documents appended with the plaint, it appeared to the learned trial judge that the defendant number 1 should be given an opportunity of being heard. Full stop. Next para, the learned trial judge also held, without assigning any reason, that no prima facie case of the plaintiff was found. Full stop. Next para, however, we find from the records that the plaintiff produced an agreement for sale before the trial court, on the strength of which the suit for specific performance has been filed. Full stop. Learned counsel for the appellant cites নামটা দিয়ে reported at এখানে আছে reported at 2025 SCC online SC 1067 and such reported at 2010 5 SCC 401 in support of the contention that, taking into account the proviso to section 49 of the Registration Act 1908, an unregistered document affecting an immovable property may be received as evidence of a contract in a suit for specific performance despite the bar under section 49 of the said act. Full stop. Next para, we find sufficient substance in such contention and accordingly hold that a prima facie case for grant of injunction has been established. Full stop. Accordingly, the appeal is admitted and shall be heard on the above grounds and the grounds taken in the memorandum of appeal. Full stop. There shall the respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property, and or from changing the nature and character of the suit property till disposal of the injunction application. Full stop. The appellant shall serve copies of the application as well as the memorandum of appeal on the respondents, indicating that the application shall be listed for hearing on June 23, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Much impressed.
Thank you. এই দুটো একটু জেরক্স করে আমাকে পাঠিয়ে দেবেন, রেকর্ডে রেখে দেবেন উনি যেটা দিয়েছেন, আর আমাকে এক্সট্রা জেরক্স করে পাঠিয়ে দেবেন, কালকের একটা ম্যাটারে লাগবে। দুটো করে জেরক্স করবেন, একটা জাজ সাহেবকে পাঠাবেন, একটা। নেক্সট। Yes. Plaint and injunction application. You have to produce plaint and injunction application. Give to the other side and to us. You have to circulate previously.
Because previous occasion, my lord, this matter was taken up for hearing.
Yes, we saw our previous order.
Well, this is the part. But my lord, a short point, my lord, I shall argue before your lordship.
It is very evident from the size of the document.
Maybe the bulky of the papers, my lord, but I shall to the point.
Please hand over those. নিন ওটা, বসে আছেন আপনি। আরে পাশে কেউ নেই, আপনি আপনি অর্ধেক দুজন ধরাধরি করে নিয়ে এখানে দুটো সাইড ধরে। এই ভালো। ওটা খুলে দেবেন। The thinner one is the plaint and the thicker one is the injunction application. The other way around.
Second injunction application.
Thinner one is the other way around. Second injunction.
Yes.
Oh.
দেখি আমার এটা কোথায় গেল, আমার পেপার বুকটা কোথায় গেল?
What is this?
তাই নেই পেপার বুকটা, এই তো তো এটা আগে দেবে, এটা নোট করবো তো আমি।
What is the case about Mr. Banerjee? Mr. Mittal, please take it.
Lordship, kindly, Lord, let us come to the, first of all, Lord, the plaintiff case. Lord, according to the plaintiff's case,
The plaintiff was a freedom fighter?
No, no. Lord, according to the plaintiff's case, Lord, Jitendranath Das, Jivan Ghosh, Arjun Kumar Ghosh, and Ratan Chandra Ghosh was the owner of the property.
Right.
Now, Lord, they sold the property on 26/5/1964.
Sold to whom?
Krishna Mondal and Kitish Chandra Ghosh.
No, they sold to whom? Who sold to whom?
ওটা কাটা কেন হলো?
কাটা না কাটা না
ও ওটা ইয়েস মিলট একটা দিয়ে দাও।
Please give a copy to them also, Mr.
Yes.
Give a copy to them also.
Yes, we have given. Lord, this is the property,
Yes.
Lord, to the extent of the for 82 out of 82 decimal, Lord Shivkishno Mondal and Kirtish Chandra Ghosh. Then, my Lord, 1965 and 1964 and 66 sold the property. Now, my Lord, thereafter Shivkishno, my Lord, to Radhika Bala Ghosh. Radhika recorded her name in the LR record of right
in 22
in 22. Lord 7/12
13
2013 sold total 66.09 decimal land to these peoples. Lord, they are the deeds, my Lord, annexed to the plaint and the injunction petition. That is why bulky paper book.
they all transferred to
Then, Lord, they transferred to Sukumar, Sujata, Phoni Bhushan, Mithu, Mitali, Sonali, and Bornali.
from them LPS.
Lord, 2016, 16, 16. Now, Lord, all of them, Lord, sold the property to Real View Developer LLP on 13/4/2021. Therefore, my Lord, they are claiming title and possession in respect of the property on the basis of these deeds. That is why, my Lord, bulky paper book. Now, my Lord, our claim is practically they admitted in their plaint because we purchased the property in court auction in Ponji case by the division bench.
List of dates, you know.
Yes, list of dates are there.
I am handing over the list of dates.
Lord, our title, Lord, comes, Lord, from Lord
16th
Greenery Developers Limited in 2012. Greenery Developers Limited, my Lord, purchased the property.
MPS Greenery.
MPS.
You are missing out the main.
No, MPS Greenery Developers
Greenery
Limited.
is secondary.
Lordship.
MPS is.
MPS.
That's why you could purchase the property at all.
Lordship. Lord, in 2012, then my Lord, they sold the property in 2013 to another, as per High Court auction sale, Lord, 2013. Now, Lord, 12 deed and then 2016 deed, vendors, Lord, sold it again. Our vendor, Lord, vendors 1/3/2016. Now, Lord, 16 vendors, Lord, 2016 vendors, Sukumar, Sujata, Phoni, Mitali, Sonali, Bornali, they did not challenge the deed of 2012. Lord, we trace out our title on because the MPS Greenery Developers Limited title, my Lord, was sold in auction
By the High Court.
by the High Court. Possession
In
was
Ponji
delivered by the High Court
in Ponji cases.
in Ponji cases. Lord, now 2012 deed was challenged in a suit, Lord, brought in 2024, beyond 3 years. Lord, my submission, Lord, then your Lordship kindly look to this. 2013, my Lord, vendor, purchaser did not challenge the deed of 2012. 2016 vendors did not challenge the deed of 2012. It is but by limitation. Then, my Lord, when they could not challenge the deed, Lord, in the vendors of 2012 and 2016, 13 and 2016, Lord, in that case, plaintiff is not entitled. The suit is but by limitation, and this is the principal prayer in the plaint. And if principal prayer it goes, Lord, then ancillary.
The principal prayer?
Principal prayer is that declaration that the deed is void.
Of 12.
2012 deed is void. That is Article 58, not 59. Lord, 59 comes in its setting aside. 58 comes in declaration that the deed is void. When their vendor did not challenge the deed, Lord, he cannot challenge the deed. First point. Second point is it is but
Their vendor means this real view.
the plaintiff vendor.
All right.
Now, Lord, your lordship sees that 2013 vendors and 2016 vendors. And then, my lord, 2021 vendors. 2021 vendors, my lord, sold the property to plaintiff.
No, this
2021 vendor also did not, but by this, my lord, does not matter because
purchase from whom? From these, any of these people, your list people, this
Greenery,
list.
MPS Greenery.
Yes, MPS Greenery purchase from whom? Any of these
Purchase
people?
from the heirs of Jitendra, Jibon and Arjun.
Jibon and Arjun find place in their this list.
That is a subject matter of challenge. Whether they
are
sold the
not in
property.
their MPS Greenery's vendors, they are not part of this list.
They are not part of this list.
They are somebody else.
Yes. They are the heirs.
Of whom?
Heirs of Jitendra, Jibon and Arjun.
Achha.
Their case is that Jitendra, Jibon and Arjun sold their property.
তো অর্জুন ফর্জুন হ্যাঁ এই গ্রুপটা থেকে ঠিক আছে
Namlord,
their purchase were their purchase or MPS Greenery was prior to this.
Yes. Namlord, your lordship, kindly look to the plaint, my lord, prayer. Let us come to the plaint prayer, my lord. Practically, my lord, title question, my lord, so far the judgment is concerned, my lord, disposing of the temporary injunction application. Lord, title cannot be decided, my lord, in a temporary injunction application. I may have a title, may not have a title. That will be decided in trial. But question would be that the suit is barred because 12 deed, Lord, has not been challenged. Lord, now your lordship kindly come to, Lord, the plaint prayer. Plaint in page. এখানে প্লেনটা দাও নেই প্লেনটা এখানে
Page 28.
সুটের প্লেনটা এটা দাও নেই
হ্যাঁ page 28
Lord, page 28
of the plaint.
28
Page 28 of the plaint is page 28 of the plaint.
Lord, see.
Yes.
It was the
Suit.
detail.
Yes, page 28. A
Yes.
decree for declaration that the plaintiff being sole and absolute owner of the suit property, fully described in schedule herein below, is as well and truly entitled to enjoy the same and every part thereof free from any encumbrances by the defendant and their men and agents in any manner whatsoever.
They have challenged the 2012 deed.
Yes, the decree for declaration that the defendant number 1 has had no manner of right, title, interest in respect of the suit. Then Lord C. Lord C is the principal payer. Lord A, B will not will be ancillary. Because if C goes, then A, B will automatically.
Yes.
Lord, because A, B is ancillary.
Yes.
Now, Lord, D ancillary. D ancillary. Lord, E ancillary. F ancillary and G ancillary.
But in 1966, if Arjun, Ratan and the vendors of MPS Greenery, they already sold the property to Khitish in 1966. Then in 2012,
No,
how
only
could they?
Ratan sold.
Only Ratan sold.
You have, in your
That
chart,
is-
it says that all of them sold.
No,
In the
No,
bracket.
I have said all of them.
Only Ratan.
only Ratan
Ratan.
sold to Khitish.
Ratan sold to Khitish
In 66. It
in
is their case.
1966. Their case
It is
in
their
the plaint. Ratan sold to Khitish.
Where is that stated? In which paragraph?
Lord, paragraph. Plain paragraph.
Over the of the
দাঁড়াও না প্যারাগ্রাফটা দেখিয়ে দাও না।
We have an apprehension that the gist may be longer than the plaint. We'll go by the plaint for it.
Lord, paragraph paragraph 9. Lord, paragraph 9. Their trace of title melody is in paragraph C, possibly. Paragraph 3, my lord. How devolution comes in. Paragraph 3, my lord, A, B, ওই জায়গাটা অর্জুন না এটা দিয়ে ওইটা দেখাও ওই জায়গাটা না ওটা দেখিও না ওই সব এটা দেখাও না আপনারটা it 19 details. ঠিক আছে
Lord, for the convenience, my lord, may I hand over a list of dates, my lord, or I place it later on?
We already have a list of dates. She'll be confused.
Yes, very.
So you want to see the paragraph only where?
List of dates, my
ওই
lord,
জায়গাটা
start
লিস্ট
from
অফ ডেটসে যাবে না প্লেটে দেখা ওই জায়গাটা
which has been given.
6 এর যেটা
No, our is from 1964.
Theirs is better then. We'll go by theirs on that. No, you have got a copy of this.
চালাও না
I have. In fact, my lord, your lordship,
Lord, your lordship kindly come to paragraph 12 of the plaint.
Paragraph 12 of the plaint.
The plaintiff states paragraph 12 of the plaint. জীবন কৃষ্ণ তো গেল হিতিসের কাছ থেকে যেটা paragraph 12
MPS, Mr. Banerjee, MPS Greenery purchased from whom? Kitish? No.
Heirs of Jibon, Jiten.
But they have already transferred in the left hand column. See the left hand column of this.
Yes. Lord, according to the case
web
of the
structure
plaintiff,
of yours.
yes. Lord, according to the case of the plaintiff, Jitendra, Jibon and Arjun.
They sold everything to this ship prisoner and all. Then they claim through.
Now, Lord, that
happened in 1964-65.
Yes, but MP Jeweler, Lord, MP Greenery
Not MP
Developers
Jewelers.
Limited.
This time Greenery. Yes.
Lord, I'm sorry, Lord. MP Greenery Developers, my Lord, name was also recorded in the record of right on the basis of that purchase.
On the basis of what?
On the basis of the purchase.
Purchase no, name may be recorded anywhere, but in 2012, before it purchased in 2012.
Lord, they purchased the property from heirs.
Nobody was in the
না দাঁড়াও না ভাই পজিশনে পরে আসছি they are
you have purchased.
We are claiming to have purchased the property, my lord, from
the court
heirs
sale,
of Jitendra, Jibon and Arjun. They are claiming to have purchased the property from Jitendra, Jibon and Arjun.
There are two portions.
Therefore,
One is 82 decimal, the other is 43 decimal.
Yes.
Now your property is covered by that 82 decimal.
82 decimal, even including Khitis. Khitis so আছে নালে আসবে কি করে?
No, he says no. How can you say
82
yes?
decimal. Yes, very well, my
There's
lord.
a conflict of interest between you two.
Yes. 82 decimal, right?
82 decimal.
Right.
Then we forget this Kitish side.
Yes, we
So-
forget.
Kitish.
Yes,
Now,
forget.
if that be so, then 64, already in 1964, the predecessors of MPS Greenery has sold to chief prisoner. So
Now,
then
Lord,
it goes on there after 64, 65, 66,
But my lord,
2013.
yes. Now,
So
Lord,
what do you come in? MPS Greenery does not get anything, get any title in the property.
According to them, my lord, they did not get any title to the property.
All the deeds must have been annexed.
But my lord, this property was treated to be an asset by virtue of a purchase by MPS Greenery Developers.
You cannot purchase a
Possession was
better
delivered.
title even in
Lord,
a
at
court
this
sale.
stage,
Mr. Banerjee, let us get this very clear. Even if I purchase something from a court sale, that does not vest me with title if otherwise my vendor did not have
Lord,
it.
my only
Even if it has the blessings of a court.
my only submission, my lord, before your lordship is this: rightly or wrongly, he may not have title because the Arjun, Jitendra, Jivon, and Arjun,
yes,
when sold the property, not to MPS, but heirs sold the property to MPS. Heirs cannot, because when the original owners have already sold the property.
No, or not already. Original owners sold the property only in 2012.
20
to MPS Greenery.
No. MPS Greenery, my lord.
Your list of dates starts from 2012.
2012 from the heirs of Jitendra, Jivon, and Arjun.
How could they? Because their predecessor Jitendra, Jivon, and Arjun had already sold in 1964 to somebody else.
Yes, that is their case. Exactly, that is their case.
They have produced deeds to show that.
Now, my lord, our case is that possession was there.
Your case starts from 2012.
2012.
When MPS allegedly purchased from Jitendra and such their heirs.
Yes. Now, my
but
lord,
their heirs could not have anything in
Lord,
view of the sale in 64.
That's right, my lord. Now, my submission is, Lord, whether my title is there or whether they have at all executed the deed or not, that title will be decided, my lord, by the suit court. If
there is
suit
strong
court
prima
holds
facie evidence that they have title.
strong prima facie evidence with regard to that. Another way, my lord, the strong prima facie evidence that we, being a bona fide purchaser for value, took possession of the property
How
after
can they be
purchasing in
strong? Why
auction
strong? Why even prima facie
sale.
evidence?
Auction sale from the High Court.
Does not vest you with title because
Does not vest with title.
Because the property, the vendor, it was never an asset of MP.
My submission before your lordship is this under section 27 of the Limitation Act. 2012 MPS took possession entire property. And my lord, original owners, my lord, did not get delivery of file any suit within a period of 12 years for recovery of possession under section 27.
The limitation is your main point.
Limitation is the main point, my lord.
And RS records show your name.
Yes. No. RS record, because
the
at
RS
that time,
records, the possession you were saying something regarding possession.
no, possession was delivered by the High Court in auction sale, and he was in possession in 2012, and possession was delivered by the High Court sale. Lord, that he knew it because he appeared in appeal.
Where is the proof of possession? He appeared in the appeal.
He appeared in the appeal, wanted to set aside the sale.
Then what happened?
Then, my lord, court said no, we cannot enter into that question. If you have a title, then this will not prevent to claim title from the civil court.
They have done precisely
now,
that.
Lord, yes. Now again, that order, my lord, they went to the High Court, Supreme Court.
Supreme Court maintained that.
Supreme Court, in addition to that, my lord, said that he is entitled to file a suit. If suit is pending, he said suit is pending. If suit is pending, then selling will not in any way
affect that. His right.
Their right for the declaration of title to the property.
So they have,
no, Lord,
that.
Yes, Lord, I am on that. My submission is that unless it was treated as an asset of the company's asset, Lord, it was sold and High Court delivered that possession in our favor.
Wrongly.
Possession was also delivered, possession certificate
That
was
does
given.
not create any title. Just because High Court, the sale was conducted by the High Court, does not necessarily mean that it clothed you with title.
No, rightly.
Mr. Banerjee, no.
Lord, my only point is, my Lord, 27 of the Limitation
Only point
Act.
is limitation. That is what we are
limitation under section 27 of the Limitation Act.
Limitation
He ought to have, Lord, filed a suit within a period of 12 years.
Limitation Act.
Because, my Lord, 12 years from 2012, Lord, after 12 years, suit was filed.
Limitation Act.
Section 27.
Extinguishment of right to property. At the determination of the period, hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. Now, Lord, 27 can be read with Article 65
They have
of the
claimed,
Limitation
claimed
Act.
possession here also.
Now, Lord, they claimed, your Lordship
They are
kindly look
claiming
to
injunction.
the-
They say that they are in
no,
possession.
Lord, your Lordship kindly look to, no, are দাঁড়াও না রে ভাই, degree G, a decree for delivery up and cancellation of the sale deed.
Yes, and H is that their possession should be protected.
Possession should be protected.
Where is the question
Now,
of
Lord,
recovery?
possession was delivered by virtue of the sale deed executed by this court.
Where do you get that possession was actually handed over to
Yes,
them
Lord,
physically?
your Lordship kindly look to that document.
Yes.
Possession delivery paper টা দাও।
At page 79.
Page 79 किसे? Paper book है? Paper book है? Lord, page 79 में Lord.
79 of what?
Can application. Page
Well, it was
79.
not there before the court date.
No, I am telling that. You have deliberately suppressed. How it can
That
be
is
there?
that is why it was there.
You have deliberately suppressed.
That is why it was not there.
Yes, that is why it was not there. Page 79.
Yes, 79.
No affidavit was filed.
84. Page
Yes, because court did not give me an opportunity.
Page 84.
That is a procedural lapse. I shall come later on.
No, this was temporary injunction was granted. Temporary injunction.
Page my Lord 84. Your Lordship kindly come.
You
to
must
page-
have got opportunity to file written objection.
No, I was not given. This is the procedural lapse. I shall satisfy your Lordship
How
second
can it
time.
be, Mr. Banerjee? Without defendant number 1 did not file a written objection against the
No,
same.
Lord, there are two petitions. Lord, I can come back a step by step. Let us, Lord, with regard
Okay,
to
let
the
us complete
limitation.
this first. Page
Yes,
79.
because first of all, my Lord, limitation point.
Right.
Because, my Lord, in a case of an injunction, prima facie case, balance of convenience, irreparable loss and injury, conduct of the party, suppression of the material,
Prima facie includes
conduct of the
maintainability
party,
maintainability of
and
suit.
maintainability of the suit. 5 things, my Lord. Even in the case of even in the case of temporary injunction, maintainability of suit
Yes,
can be
yes.
raised
Within prima facie.
within prima facie case.
True.
Now, Lord, your Lordship kindly come to page 84 of our application.
Not 79.
Not 79, my Lord. I'm sorry, 84.
That was the confirmation of sale.
That is the confirmation of the sale, then sale deed was executed and registered.
Certificate of delivery of possession.
Yes. Lord, this fact was deliberately suppressed, my Lord, in the injunction application. Kindly come to the injunction. They, Lord, why deliberately suppressed? Because they entered appearance in the appeal.
In their application, we have anecdote document.
And their application, we had to satisfy that a possession was delivered. Lord, I am a bona fide purchaser, participated in the auction sale. And then, my Lord, I purchased the property, delivery of possession was given. And my Lord, this fact, my Lord, was, and how delivery of possession? Because it became an asset of the company, MP. Therefore, 2012 deed, my Lord, was unchallenged. Lordship.
Taken in 15. It was High Court took possession of MPS.
My Lord, the High Court took possession from MPS, my Lord, in 2015. High Court took possession, Lord, in 2015.
It must have been notional possession.
No, not notional possession, my Lord. The records are there, my Lord. Otherwise, they cannot give delivery of possession to us unless possession is taken by them. If notional possession is taken, then notional possession is to be given to us by the High Court. Lord, High Court did not give notional possession. Therefore, obviously, my Lord, a delivery of khas delivery of possession was given by the High Court means, Lord, presupposes that he has taken possession in 2015. There was also a document on that.
At page 50, as order of the High Court to take possession of the property.
As order of the High Court is also there to take possession of the property. And based on that, possession was taken.
Oh, then what happened to the transfer of land by way of the
Lord, transfer of the right, my Lord, my respectful submission by virtue of section 27 and article 65, that right goes. And with regard to 2012 deed, Lord, under article 58, my Lord, of the Limitation Act. Suit is barred by limitation. If suit is barred by limitation, then no injunction can be granted. And my lord, as far as section 3,
যখন দখল নিল কেউ এসে প্রটেস্ট করলো না, কেউ চ্যালেঞ্জ করলো না।
দাঁড়াও না।
So therefore, first, suit is barred by limitation. Secondly, this delivery of possession certificate shows possession is with you, but they claimed only injunction in the suit.
In the injunction, your lordship,
Somebody
kindly
have
look at
possession.
their injunction application. In the four corners of the injunction application, this was not stated. No whisper.
So it was non-
Therefore, on
this
the
was
ground of
suppressed.
suppression of material fact, injunction ought
But
to have
what
been-
about you did not file, you chose not to file written objection, Mr. Banerjee?
Yes. Now, Lord, procedural lapse. Lord, lordship, kindly come to the order sheet. Lord, there are two petitions filed. One petition was filed. Lord, first injunction petition was filed on 8/10/2024. And second injunction was filed on 4/2/2025.
against first, they come to the High Court.
Now, first injunction, High Court passed the first injunction order. Because your lordship kindly come to at page 106, injunction was refused. 106, my lord. 106.
What's in it to do?
Lord, page 105,
The ad interim was refused.
ad interim was refused.
Yes.
Lord, against the refusal of the ad interim order, they preferred an appeal. Now, Lord, appellate court, my lord, this honorable court, page 103, my lord.
103.
103.
Acha. It is going backward.
Lordship, in this way, my lord, pagination is given last. It ought to have been, my lord, earlier than the High Court order.
Yes, so 103.
103. Lord, 103, your lordship, then page 103, my lord, the paragraph 3. In view of such reference, one-man committee took possession of the various assets of the company, including the auction property, which has been sold to MPS Greenery Developers Limited, registration deed number so and so. As per order dated 23/12/2015, public auction, e-auction was held with the assistance of the SEBI on 3/3/2023, and auction sale was confirmed in favor of the auction purchaser. Respondent number 35 by this court.
This was passed by that bench, the Ponzi bench,
Passed by the Ponzi bench.
on their recall application.
That has been
This is
recorded.
not an
in the
appeal
order.
against the injunction.
Yes, not, Lord, that was the order recorded, my lord.
That bench
Now, Lord,
stood by its own order.
yes, lordship. Now, Lord, paragraph 14, there is no scope to recall our orders confirming so and so. Then, my lord, Lord, High Court passed an order, your lordship sees.
Mr. Banerjee, there are two things.
No,
this
therefore,
court
my lord,
held that yes, we cannot recall our order because already that sale process has been completed. So therefore, that's one question, that whether that court can recall that order because already certificate has been issued.
Lord,
And all.
that, yes, my lord, that
That
has
is one
nothing to do.
aspect. The
One
other aspect is whether by virtue of that sale took place, no doubt on that. But whether that by virtue of that sale, any title passed. That is
Lord,
another question altogether.
Another question, Lord, the answer given by the trial court is,
Yes.
Lord, so far that finding is concerned, I do not have any dispute. Trial court held that it will be decided at the time of trial. Undoubtedly, my lord. Whether I have a title or I have not a title, or my predecessor
Yes,
has a
yes.
title or my predecessor has no title.
That will be decided.
Lord, that will be decided at the trial. My Lord, I am the last person to argue before your Lordship. My Lord, I am not on that. I am simply now, my Lord, your Lordship, then status quo order was granted in appeal. Now, my Lord, when the status quo order was granted in appeal, when within the time, Lord, High Court directed within a period of certain date, my Lord, my client was directed to submit, my Lord, written objection. I could not be able to submit my written objection. As a result, my Lord, I was precluded to argue.
Then you are given opportunity.
No, we have given opportunity. Lordship, kindly come to the finding.
Written objection,
Finding
if
of
any,
the-
by such and such date.
Yes, Lordship, kindly come to the finding.
Trial court could not extend that time which has been granted by this court. Did you pray for extension of the
trial
time?
court did not, Lord, trial court said it appeared that the defendant number 1 had contested the proceeding before the Honorable High Court at Calcutta, and so this court finds no reason to give further opportunity to the defendant to come before this court and contest
Where
the
are you
injunction
reading
petition.
from? You are reading from?
Lord, page 122, my Lord. The second part, third paragraph.
That is the present impugned order.
Yes, present impugned order.
Acha.
Lord, he said, it appeared that the defendant
Yes,
number 1 had contested the proceeding before the Honorable High Court, Calcutta, and so this court finds no reason to afford further opportunity to the defendant to come before this court and contest the injunction petition. Therefore, my Lord, first injunction petition on the basis of that, my Lord, has been disposed of.
The previous two paragraphs say, as per direction of Honorable Court, you have to read in context, wherein the defendant number 1 has appeared and contested, and Calcutta, this court had directed the defendant number 1 to file written objection within February 14 and to take up hearing. It appears that defendant number 1 did not comply with the terms of the said order.
Application number 1.
Did not comply. Then, my Lord, your Lordship says, it appeared that the defendant 1 had contested the proceeding before the Honorable High Court.
So the instant injunction application.
So this court finds no reason to afford further opportunity to the defendant to come up before this court and contest the injunction petition. Lord, so far as
you cannot call out one sentence. The previous 3 paragraphs you are omitting. The previous 3 paragraphs categorically record. High Court directed you to file written objection within February 14th.
Yes, if both are taken.
You have to file written objection by Valentine's Day.
Lordship.
So you lost all love with the trial court and
Lordship, if both are taken in consideration, my Lord, then so far first injunction petition is concerned, I did not file objection.
It has been recorded. You did not comply with the terms of the order.
No, therefore my submission is.
You are what? No. Come to this. Read this out also.
Then what about the second application?
No. Yes, my Lord.
Please read from the first paragraph of that order.
Hence, the plaintiff in respect of the injunction petition,
as per direction of the Honorable High Court, that is the third paragraph.
Direction of the Honorable High Court, wherein the defendant number 1 of the suit has appeared and contested, and Honorable High Court at Calcutta directed the said defendant number 1 to file written objection within 14 February 2025 and to take up the hearing of the injunction petition on 26/2/2025. It appeared that the defendant number 1 did not comply the terms of the said order of the Honorable High Court at Calcutta. It appeared that the plaintiff filed affidavit dated at file affidavit of service upon the defendant number 1 in respect of the injunction petition with annexures. So the defendant number 1 did not appear and to contest. Lord, this part, my Lord, is the second injunction petition part. Because they filed second injunction petition.
The next sentence says instant injunction petition dated such and such are taken up. There was a second injunction application after the first was refused. That was refused.
Yes. 4/2/2025.
Was filed on 8/10.
The opportunity to Mr.
petition-
Banerjee, the opportunity to file written objection was given in respect of the first injunction.
Opportunity was given by the High Court
in respect of the first
injunction, not second injunction petition.
And this present order has been passed on the second.
Present order has been passed combinedly, but practically second injunction petition order was passed.
Written as
Second injunction is was it maintainable because second injunction was on the self-same prayer?
Lord, my submission before your Lordship, their submission is also that if subsequent facts happened, attending circumstances happened, then second injunction petition is maintainable. Lordship knows the judgment of Justice A.M. Bhattacharjee. Lord, I must not, Lord, make any debate, Lord, with regard to that. If the attending circumstances, Lord, change circumstances are there, Lord, then second injunction application is maintainable. Lord, I am not on that, Lord, the maintainability of the second application. I am on the
Second application, you did not get any opportunity.
Therefore,
to file
yes, Lord, therefore, first injunction petition, I did not file objection. Therefore, I am being sealed. And whatever, Lord, pleadings, affidavits have been made shall be deemed to have been admitted, because I did not file any objection to that. Now, on the basis of that application, injunction petition, I shall have to argue on that only.
Yes, because
Secondly, my Lord,
second injunction application becomes redundant.
yes.
Even without that, they can get an order on the first.
No, no. Secondly, my Lord, which we want to say, because on the basis of the second injunction petition, Lord, second injunction petition, practically he has disposed of the second injunction petition.
Yes, dispose of both.
He has disposed of the both.
But the
Now,
second,
Lord, your Lordship,
second
kindly
was
come.
a superfluity. Even without the second, the first one, on the first one, they
But
could
my
get an
Lord, the
injunction.
order your Lordship kindly look to, on the basis of the second injunction application, injunction was granted.
How can you segregate? Because both were taken up together. As per the
Both
impugned order,
have been taken up
the
together.
injunction
But
petition are
on-
taken up for
yes,
consideration.
Lordship, kindly come to the order.
You mean to say that this was regarding the second one? It has been observed that since in FMAT they have already got an opportunity, therefore no further opportunity.
Therefore, no further.
You say that you should have been
Yes,
given an opportunity
yes.
for filing written objection to the
Therefore, no
second.
further opportunity, because first line, my Lord, and second line,
Understood.
Lord,
Yes.
on the basis of that.
Yes.
Now, Lord, your Lordship kindly come to the, Lord, the order dated.
The second injunction application, you never got any opportunity at all.
No. Lord, Lordship kindly come to the order sheet. Lord,
show us. It was filed on 4th of February. অনিন্দিত এই পাখাটা নিবে দিতে, এই এসিটা নিবে দিতে বলুন ঠান্ডা।
That's filed on 4th of February. Can I hand over the order to the item?
Page.
It's annexed here, the previous order. We'll get it from the previous order. Page 120, page 119. Court 2 order. What happened on that day?
No, Court 2, Lord, the order dated Court 2.
This was the date of the
That is
second
at page
injunction.
119, my Lord, taken application
Right.
for the injunction. Lord, so-called notice was issued, was directed to be issued within 7 days. From why the injunction will not be granted. Issue notice upon the defendant asking them to so-called within 7 days from the date of receipt of the same as to why the prayer for temporary injunction are sought for shall not be granted. Then, my Lord, he proceeded on that basis, and ultimately, my Lord, he passed an order that this application at the time of hearing had inquired whether the second petition can be moved. Initial injunction order has been refused on this score. Hence considered, my Lord, page 120. Hence considered this court at the time of hearing had inquired whether a second injunction petition can be moved and prayed for when initially one interim prayer of injunction has been refused by this court, though subsequently allowed by the Honorable High Court. On this score, learned advocate for the plaintiff has referred the civil division case number so and so and read petition number so and so. After considering the submission so and case number so and so, Honorable Court was pleased to observe that Order 39 Rule 2 temporary injunction, source of the power. Then, my Lord, on going through the observation of the Honorable High Court at Calcutta, second application for injunction, interim form of injunction can be considered. In the case in hand, it appeared there is a change circumstances, and this cropped up in the suit during pendency of the appeal made by the plaintiff before the Honorable High Court at Calcutta. It appeared that this court had earlier observed that the plaintiff has a prima facie case to go to trial. Therefore, thereafter, Honorable High Court at Calcutta has been pleased to restrain the defendant number 1 from making any transfer or creating any third-party interest over the suit property. So, considering the observation made by the Honorable High Court Calcutta, this court finds that the Honorable High Court has been pleased to observe there is always a requirement to protect and preserve this suit property. So, considering the observation of the High Court, the court is of the view that the principles of prima facie balance of convenience, inconvenience, irreparable loss and injury is liable to be allowed. Hence, ad interim injunction is allowed in the form of injunction. Now, Lord, so-called notice, your Lordship kindly look to the entire order sheet. I have taken the entire order sheet. from the record itself, certified copy of the entire order
But the
sheet.
court considers everything, the
No,
auction
Lord,
sale and all.
Lordship consider, no,
Page
question would be, Lord, that the,
What are you waving at us?
we wanted to, that after this order, my lord, he was directed to file so-called notice within a period of 7 days. The so-called requisites are required to be filed and served on me. That was not served on me, and within a period of 4 days, my lord, injunction application has been disposed of.
Let us see.
Because 2 days are, and unless the order sheet I
keep it with you,
produce,
keep it with you. Those are not part of the record.
unless I, Lord, this is the certified copy of the order sheet. I'm placing certified copy of the order sheet.
The two orders, relevant orders are there.
This is the final order.
4th of February, you have also annexed.
And in between that, 4th
In
of
between
February
4th of
and injunction order, in between that order sheet, I'm placing.
There was some date in between.
Yes.
Yes.
That is why, my lord, I'm placing. একটা কপি দিয়ে দাও না। Lord, case is put up on record. আরে আমাকে order sheet-টা দাও না রে ভাই।
Order sheet-টা Calcutta order.
আরে এরপর নয়, যে order sheet-টা দিয়েছে তারপরে।
Yes, in fact, on 27th of February,
27th of February.
only the first injunction was directed to be heard on the next date.
Yes, it is the submission of the plaintiff that one appeal has been prepared against so and so, and the defendant should file objection against the injunction application within 11th February, and consequently plaintiff was required to file affidavit in reply and further directed the injunction application on perusal of the record. It appears no written objection has been filed by the defendant on so injunction petition be heard on 1/3/2025. Plaintiff filed one petition for extension of interim order dated, which is allowed that interim order is extended till date. Therefore, that date was fixed for the purpose of hearing the two petitions without serving any copy of the so-called notice.
It was the holiday. It was fixed on 27th, then fixed on 1st.
Yes.
Mr. Banerjee, how could you have improved your case? I mean, in the sense that they have not asked for anything new in the second injunction application. They have brought on record the prayer for injunction was the same. The premise was same. They have brought certain further incidents on record, including probably they are having knowledge of the court auction sale and all these things. Those were brought on record probably by this. Suppose even if you say that the trial court, without giving you opportunity, did not have the jurisdiction to hear the second injunction application. We take your best case on that second injunction application. Then we can direct the trial court to rehear the second injunction application upon giving you opportunity to file written objection.
Yes, this injunction.
But the first injunction application was disposed of rightly. It was fixed on that date. It was disposed of, and
Lord,
this injunction
practically
granted.
in the
They can just go and not place the second injunction.
Lord, so
they
far
will do
that
that
part,
evidently.
Lord, so far that part is concerned, kindly look to the impugned order, my lord.
We are there, impugned order. So insofar as the first injunction application is concerned, let us focus on that for the timing. Let us, for the timing, assume that yes, second injunction was wrongly decided. But the first injunction application was rightly decided because timeline was given for filing written objection. You did not.
But only, yes, only one line, my lord. In view of judgment of your lordship knows, my lord, judgment of Justice Ganguly, fraud is practiced because I have challenged it.
What is
because
the
fraud is, my lord, that suppression of fact that the delivery of possession was given by the High Court. That was not a spoken, my lord, in the injunction petition. Lord, if opportunity is given to us, then we ought to have disclosed that. And now, Lord, in appeal, we can disclose before this honorable court because it is amounting to a fraud. Lord, that judgment. Lordship knows that judgment. Lord, otherwise, my lord, in the case of ad interim injunction or ex parte temporary injunction on contest, I did not contest, I cannot rely any other document. 7 except if it is amounting to, he secured, which is amounting to fraud.
Mr. Banerjee, let us suppose that they have suppressed the delivered of poison. If it was disclosed, how could it have changed the title? Because they have not asked for, if injunction was granted, restraining you from disturbing their possession, we could have understood. injunction was granted only regarding nature, character, and third party.
But my
interest.
submission is title cannot be decided because the court has already held it will
No,
not be.
we are on this on a different aspect. We are now focusing on that fraud. Fraud means on because of suppression of material
But
facts.
as regards possession at this stage, it will be decided.
Yes.
Injunction
So
matter, not
regarding-
with regard to title.
So regarding possession, even if they suppress, if they had disclosed that possession was handed over to you, suppose that was disclosed, how could that have changed this order?
Lord,
Because this pertains to
a finding
on the
has been
basis of the
recorded.
apparent title, court directed you to maintain status quo regarding nature, character, and possession. Possession.
Right, my lord, on this I am joining issue.
Possession is there.
Yes, possession is there. They said they are in possession. And that is why they suppress the material fact with regard to
But in
delivery
the
of
final
possession.
injunction was possession regarding, was it given regarding possession?
Yes.
Let us
Lordship,
just
kindly come to the finding.
Men and agents are directed to maintain status quo in respect of nature. No, that was regarding the interim order. The final order, yes.
Final order 1/3/2025.
1/5/2025, right? Let's see that. Allowed in temporary form, restrained from creating any third party interest and from changing the nature and character only. Not regarding possession.
Possession finding is there.
Page 125.
These are possession finding is there. You will
No, 125.
to page 124.
125 injunction is not granted regarding possession.
Yes, but finding is there, my lord. Your lordship kindly come to.
Where is that?
Yes.
Rather, the factum of that court spell and all was taken into consideration.
Yes, yes. Factual matrix has come up before this court is that the property was jointly owned and possessed by the.
Where are you? Yes, factual matrix. Yes.
Yes, my lord. This is.
Yes.
This
court takes into consideration the High Court's order.
Page 124.
See the
High Court did not record, my lord, that he is in possession or we are in possession.
No.
High Court simply.
But the sale certificate and all these aspects were considered. And ultimately, no injunction regarding possession was given.
This finding, my lord, has caused me. Lord, that is the reasoning behind it. Because I was not given opportunity to file.
There has been no injunction granted regarding possession. Injunction has only been granted.
Therefore, my lord, this part, my lord, may be clarified by your lordship.
Why should we? Because they have the court
No,
has
they are the actual factual
restrained
before this court that the property was jointly owned and possessed by the Jitendranath Ghosh, so and so. Developers acquired the property from whom the plaintiff have acquired title interest by virtue of and has been in legal possession of the suit property. Lord, that too, my lord, with separation of the material fact, that is with regard to that.
And had been.
Yes.
Past tense.
Had been in legal possession of the suit property. Past tense.
Please carry on. Thereafter,
Yes.
there are many things thereafter.
Thereafter, plaintiff enter into a development agreement intending the developer intimating the plaintiff that a sale certificate by deed number so and so was issued by the Joint Secretary of One-Man Committee of the Honorable High Court at Calcutta. Sale was confirmed and made absolute so and so passed by the Division Bench High Court Calcutta. In respect of in this respect, the plaintiff has filed one order of the Honorable Supreme Court against the order of the Honorable High Court dated so and so, wherein the Supreme Court was pleased to observe that at this stage, learned senior counsel for the petitioner submitted that in fact a suit has been filed assailing the auction sale of the property sold to Messrs. MPS Greenery Developers Limited 2012 and the consequential sale subsequent transaction. Apprehension expressed is that since the aforesaid transaction have been approved by the High Court, that the trial court may be influenced by the order approved by the High Court. Needless to observe that if the suit has been filed assailing the auction sale as well as subsequent sale, and the suit has been considered on its own merit as on the evidence to be let in and not to be guided by the approval of the High Court. So at this stage it appears the bar or the impediment guided in my mind of the.
Rather, in a sense, Mr. Banerjee, it has been acknowledged that you are in possession.
Now, Lord, my
Because
respectful
it
submission
court says if you are allowed to create third party interest or change nature and character.
Now, Lord,
how can you change nature and character from?
Lord, my submission would be 2012 challenging that deed, Article 58 will come into play. Blood injunction cannot be granted and court is bound to decide whether suit is maintainable or not. That ground he did not decide. With regard to the conduct, he didn't decide. That conduct, obviously, he cannot decide because he did not disclose ex parte. Naturally, he is not at fault. But before your lordship, we are pointing out before your lordship, and we are entitled.
Don't create any third party interest or change nature character.
My lord,
That
but
is the
if the
injunction
suit is not maintainable, then my lord, in that case,
limitation. So it boils down to limitation.
Yeah, boils down to limitation. Article, my lord, 58 of the Limitation Act.
Let
And
us
my lord,
say-
2 judgments I have. Lordship. Revoked or not. আগে এটা দিয়ে দাও। না না আগে এটা দাও, আগে এটা দাও। Lord 2024 হ্যাঁ আসমা লতিফ। Lord আমার কাছে আছে দুটো কপি আছে। একটা ওনাতে দিয়ে দাও না তোমার, যদি থাকে তোমার কাছে।
এটা নিয়ে নিন।
Lord, paragraph 39. Lordship, kindly come to paragraph 39. This is 3 judges bench judgment, my lord.
Yes.
Although not directly, paragraph 39.
39.
Although not directly arising in the present case, we also wish to observe that the question of jurisdiction would assume importance even at the stage a court considered the question of grant of interim relief. Her interim relief is claimed in a suit before civil court and party to be affected by the grant of such relief or any other party to the suit raises a point of maintainability thereof or that it is barred by law and also contends on that basis that interim order should not be granted. Grant of relief in whatever form, if at all, ought to be proceeded by formation and recording at least prima facie satisfaction that the suit is not maintainable or that it is not barred by law. Such satisfaction resting on application of the averments of the plaintiff, the application for interim relief, and the written objection thereto, as well as relevant law that is cited in the support of the objection, would be a part of the court's reasoning of the prima facie case, having been set up for interim relief. Balance of conveniences in favor of the grant, not grant, would cause irreparable harm and prejudice. It would be inappropriate for the court to abstain from recording any prima facie satisfaction on the question of maintainability. Lord, that is the question, my lord. I am respecting, my lord, with that with regard to 12 deed, my lord, he ought to have decided maintainability. My lord, one is rejection of the plaintiff, and one thing that has nothing with regard to the maintainability of the suit, recording prima facie within the frame of the prima facie case. This has to be recorded. Lord, in this case, Lord, it has not been recorded by the trial judge. Lord, 4 corners of the impugned judgment, my lord, it was not recorded. Now, Lord, your lordship may question
Did you
me.
raise the limitation point?
Lordship,
Did you raise the limitation point?
They did not appear.
Blood, section 3 of the Limitation Act, notwithstanding
He
raising.
did not take an objection.
No,
but
because, yes, blood, not taken.
was it argued? You are just asking.
No, yes, not taken, but I am taking before the appeal court. I am entitled to take because of section 3.
Court itself has to look into.
Court itself is to have taken. Well, notwithstanding defensive in. Lord,
Yes,
section
yes.
3, well, Lord, specifically
Section 3
says
is
that.
clear.
And
Court has
so
to-
many judgment your lordship knows, my lord.
Yes.
Therefore, I am on this, my lord.
So you did not appear at the final hearing also.
Lord, while Adjournment gave me the brief to argue before your lordship, I did not know earlier.
Yes.
For the first time, Lord, in this matter, I am here.
Very well, yes.
ওইটা দিয়ে দাও। Lord, now 50 with regard to 58.
Mr.
Section 50.
Manna is a veteran in the High Court and as well as in this.
Lordship. Now, Lord, with regard to section 58, Lord, section 58, my lord, your lordship judgment. Now. And then, my lord, your lordship judgment.
My judgment means sitting singly,
Sitting singly.
not binding on the division bench. Cite some other thing.
That is why, my lord, I am telling your lordship judgment, Lord, in toto,
Don't have
my
any
lord,
particular
no,
fascination.
in toto, my lord, decided by the Supreme Court. Therefore, let me
Who
place
was
the
the
Supreme Court judgment.
Place the Supreme.
Yes, Lord, I am placing the Supreme Court judgment. Lord, what I am telling you, your lordship, what your lordship said, Supreme Court said that. That is the
Who
reason
said
I want.
first? The Supreme Court or me?
No, your lordship
Well,
said
then,
first. Lordship, your
That's a
lordship.
feather in my cap. Thank you, sir.
Lordship,
But cite the judgment also.
lordship. Supreme Court 2020, 17 HCC. 17 HCC.
Invitation
2020, 17 HCC. 17 HCC. 17, 2020, 17 HCC. 17 না, এটা today show। এটা কি পার্টির নামটা বলো না নাগেশ্বর রাও দেহিভেনটা এটা দেহিভেন নয় এটা শক্তি
থাকলে তো পাস করবে
ব্লড ফার্স্ট জাজমেন্ট ইজ ব্লড আচ্ছা দাঁড়াও না শক্তি দেহিভেনটাই দাও না আগে ব্লড টু জাজমেন্ট আই এম প্লেসিং বিফোর ইউর লর্ডশিপ
Yes.
One is Dehiben, another is Shakti Bhog, with regard to the interpretation of those two sections. Bloods, আগে দেহি ভনটা দাও না দাঁড়া কোনটা দিলে তুমি এখন আরে একটা একটা করে দাও না এরকম ভাবে দিলে তো আমি বলতে পারবো না আদার সাইড ধরতে পারবে না
একটা dahi ben. All relate to food. One is dahi ben and another is shakti bhog.
Shakti Bhog.
Food products.
Lord Shakti Bhog at paragraph Lord 18.
We take shakti bhog first.
Yes. Shakti Bhog first. Yes. 2020 volume 17 HCC page 260.
কপি দিয়ে দিচ্ছি
Lord 58 and 113 and 58 and 113 was not explained. Right to sue first accrues and right to sue accrues.
Mr. Banerjee will continue tomorrow.
Lordship.
Although the matter is substantially heard, hearing cannot be concluded today, so accordingly let the matter stand over till tomorrow. It will remain under the same heading, so that we can.
Lordship.
সবগুলো সাবধানে একটু
এই আমার বই আমার
বেরিয়ে যাচ্ছে। একটু দেখুন।